Check, check. All right, good morning, everyone. Good morning. I'd like to call to order the Judiciary Committee public hearing for March 16, 2026. Just a reminder for those who are joining us today on some of our ground rules. When you come up to testify, you have 3 minutes for an opening statement. We will then entertain any questions from the committee. As a reminder, if you've submitted written testimony, we have that on our laptops in front of us. There's no need to come up and speed read your written testimony to us. Frankly, that's not helpful. Just feel free to summarize the salient points of your testimony. And like I said, we'll entertain any questions. All right. We do have a relatively decent list today, so we will try to get through it as expeditiously as we can. With that, we will start with the Claims Commissioner, Robert Shea. Bobby Woods.
Dark recesses.
All right.
That's like a mood lighting.
Good morning, everyone. My name is Robert Shea from the Claims Commissioner's Office. With me is my esteemed Deputy Claims Commissioner, Attorney Tamara Teet. I'm respectfully wondering if it makes sense for the committee to hear testimony from folks, and then I can come up at the end and respond to questions you may have. I think that's the way we've handled this in the past couple of years.
That's fine with us. We can certainly punch it to the end. I didn't know if you wanted to make any introductory opening remarks on maybe just the process your office goes through with respect to the claims, and then touch on your bill, which is 5535.
Yeah, that sounds great, Representative Stassram. Thank you very much. And thanks to everyone on this committee for the support of what the work we do at the Claims Commissioner's Office is very important. We try very hard to make fair and fast decisions. Last year, we made 550 decisions in 2025. So we look at a lot of claims, and we understand that people are waiting for decisions, and we try to be fair. Some of them may not be right, and that's where this committee comes in and fixes that. So we try to be very respectful to everyone who appears before us, even if we don't agree with their position. And we work very hard. And everyone on our team loves the work. That sort of segues into House Bill 5535. We have a good system in place, and we're hoping that the Judiciary Committee will consider giving us more work to do. And that is what is proposed in House Bill 5535, an act concerning the Claims Commissioner. What the bill proposes to do is it would allow us to hang on to smaller claims that are filed with our office, and we can decide them. Claims that are considered to be otherwise authorized by law, but they're small claims. They're mostly filed by pro se claimants, and our office has already opened the claim and looked at it, and we just think that it might be good for the citizens if we can hang on to those small claims and make a decision whether or not the state should be held responsible. Because, we want to stay busy, and we're in very good shape as far as the number of claims that are pending in our office, and frankly, we're looking for more work. And so we hope that this committee supports House Bill 5535.
Thank you, Attorney Shea. So on 5535, I hear you. Right now, you need more work, but traditionally, the Office of the Claims Commissioner, I think, has sort of struggled with the workload they have. I'm not so concerned about you and your administration of the office, but I am concerned about the next person, the person after that, and the person after that. And so, what sort of comfort, kind of structurally, can you give us that if we do give the Office of the Claims Commissioner more work, that we're not going to return back to a pattern of years prior where it seemed there was a backlog of in the office?
It's a great question, Representative Stafford. Thank you. So these particular claims, these are claims that they're already being filed mostly by pro se litigants, if not exclusively by pro se litigants. They're asking for less than $15,000 in damages. So those are claims that we're already reviewing and opening and assigning a claim number. And then we send them to the Attorney General's office, who represents the state in all claims. They look at the claim as well and give us their position. And then what has to happen is, because we're not currently authorized to work on that claim, we have to tell the poor claimant, well, we can't work on this claim, you have to go to court. So it's not going to be a ton of extra work, but to handle these smaller claims. And we have a great system in place with really awesome paralegals and Deputy Commissioner Teet. So I don't honestly see a reason why we would sort of fall behind again. Um, all the litigants are very cooperative. When we schedule hearings, they get ready for the hearings, they show up at the hearings, and we're able to issue quick decisions. So I think structurally, and now we have a full-time deputy, which is a great new thing that this committee supported. So I think structurally we'll be able to handle the extra work.
And is the idea on those claims under 15,000, you would issue a monetary award, or simply that you would be empowered to send them to Superior Court?
I think it would be, well, if they're claiming under $15,000, which is what they claim in their original claim, under the statutes, the Claims Commissioner's Office has authority to award up to $35,000. So I think our option would be either to respectfully deny the claim or award up to or $14,999. Those would be the two options in those smaller claims.
And I think there may have been sort of a drafting oversight in this bill when it was originally released. So what would be the recourse for someone who believes the claims commissioner got it wrong in denying that claim? Where would that claim go to?
The current law under 4-158 says that a person has a right to appeal to the General Assembly if their original claim was in excess of $50,000. So that on these smaller claims, and that's the current law, the claims commissioner's decision is the final decision, unless a claimant could come to the Judiciary Committee and suggest that there's a way that a special act could be passed to overturn the claim commissioner's decision.
Okay, so the intent would be that a claim up to $15,000, your office would essentially adjudicate the claim, issue an award, and that would be a non-appealable decision.
Issue an award or deny the claim. We, as you can see from what we're doing today, we do deny a lot of claims.
Of course.
Yeah.
Okay.
We
But it
believe
would be,
the state didn't do anything wrong.
but it would be a final decision one way or another that would be non-appealable.
Yes, under the current version of section 4-158, where you have to make, the appeal rights are triggered if a claimant claims in excess of $50,000.
Further questions or comments on this? All right, if not, Mr. Shea, what we're gonna ask you to do is hang around, and at the very end, if there are questions that come up during the course of our hearing today, we'll ask them then.
Thank you, everyone.
Thank
Appreciate it.
you. All right, next we'll turn to Omar Miller. Is Omar Miller with us?
Good morning. Hello?
Yes, go ahead, sir.
Yes, good morning. Good morning.
Good morning, Mr. Miller. You can go ahead.
Hello?
Yes, sir. All right, Mr. Miller, can you hear me?
Good morning.
Good morning. Go ahead with your testimony. All right, we're gonna skip Mr. Miller and come back if we can get that worked out. We're gonna go to Paul Lewis.
Yes. Good morning.
Mr. Miller? We're gonna skip. We'll go to Paul Lewis, please.
There we go. Hello?
Mr. Miller, can you
Good
hear us?
morning.
Good morning. There you go. Go ahead, Mr. Miller.
Hello? Good morning.
Good morning, Mr. Miller.
Good morning.
We're gonna move on. Huh? Okay. Mr. Lewis with us? Paul Lewis? Paul Lewis with us? Julie Lamoth? Julie Lamoth's not with us?
And my speech was slurred. Fast forward to
Julie Lamoth with us?
Yes, I am. Good morning.
Morning. Go ahead, ma'am.
My name is Julie Lamont, and thank you for inviting me to speak today. I am here because over a 7-year period, I experienced a pattern of actions by certain Connecticut state employees that I believe violated my constitutional rights. Between 2017 and 2024, I was arrested 8 times by Troop D officers, yet none of those cases resulted in a conviction. Several were dismissed and one resulted in a full acquittal. Despite the lack of evidence, the cases continued for years and required more than 100 court appearances. The impact on my life has been severe, including the loss of my business, damage to my reputation, and serious health consequences. I am here today to ask the state to examine how these events occurred and to ensure that accountability and transparency exist when constitutional protections may have been violated. The central constitutional concerns involve repeated Fourth Amendment violations through arrest without probable cause, malicious prosecution, and Fourth Amendment due process violations arising from a pattern of misconduct by law enforcement and prosecutors. I went ahead and I sent the key evidence supporting the violations and the constitutional violations to you as well.
Thank you, ma'am. And just for the record, I believe you're here on agenda item number 5, which is Senate Joint Resolution number 39. Is that correct?
Yes.
Great. All right, questions from the committee. Senator Kissel?
Thank you very much, Chairman Staffstrom. Thank you for your testimony, ma'am. What were you arrested for over and over again? Was it the same basic charge or what was it all about?
Well, I would like the committee to actually look at all of those reports and all of the arrests that happened. It was a violation of restraining orders. There was no proof. I basically was just trying to run a business in Connecticut. I owned an artisan cheese company, so they're various. Let's see, theft. They were made up. They were not. There was no truth to them at all, and there's no evidence.
Thank you. Further questions or comments from the committee? If not, thanks for bringing this to our attention. Next, we will hear from Narisha Terry. Just while she's getting ready, if folks could just identify the bill number or the resolution number when they come up to testify, that would help orient us to the testimony. Narisha Terry.
Hello.
Yep, go ahead, ma'am.
Hi, good morning, everyone. My name is Narissa Terry. Thank you for inviting me here to allow me to testify. Oh, wait, I think I have to turn my camera on. How do I do that?
There you go. We got you now.
Okay. My name is Narissa Terry. I am asking permission to pursue my claim against the state of Connecticut because of serious medical harm I suffer while in state custody. On September 14th, I'm so sorry. I am a caregiver and I have a disabled child behind me. Well, in the background, I don't know if you guys can hear him, but I'm trying to keep him as quiet as I can.
You're fine. Go ahead.
Thank you. On September 14th, 2021, I underwent a total thyroidectomy. After this surgery, my doctors made it very clear that I had to take two medications every day, levothyroxine and calcium supplementation. The calcium was essentially because the parathyroid glands that regulate calcium levels can stop functioning after thyroid surgery. 1 week after the surgery, on September 22nd, I was arrested and taken into custody. Well, Harvard Police Department took me to the emergency room so that I could receive my medications that had been prescribed by the following my surgery. The next day, Thursday, which was the 23rd, I appeared in court in Hartford. I informed the judge that I had just had surgery and that I was under doctor's orders to take specific medications. I explained that I require medical attention related to my surgery. The judge and acknowledged this on the record and stated that I am to receive medical treatment while incarcerated for my surgery. When I was transferred to York Correctional Institution, I repeatedly informed the medical staff, the correctional officers, that I had just had major surgery and that I required calcium supplements. I showed them the surgery bandage on my neck and explained the instructions from my surgeon and my endocrinologist. Instead of providing the calcium that my doctors required, I was given a prescription of ibuprofen. I explained that I was not in pain and that what I needed was the calcium and my thyroid medication. The following day, which was Friday the 24th, I was taken to court again in New Britain. I once again informed the judge that I had recently undergone surgery and that I required my prescribed medication and medical attention. The judge also documented that I was to receive medical treatment for my surgery while I was in custody.
Ma'am, that was,
Tuesday,
ma'am, that was the bell. I need you to summarize your testimony, please.
excuse me?
I said that was the bell. I need you to summarize at this point.
Oh, the bell. I didn't hear. Okay, I'm sorry. I didn't know this was timed. When it first started, it was like echoing. Okay, I will sum it up. The summary is basically I informed medical staff at the correction facility, Hartford Police Department, two judges of my condition. And despite informing all of these people multiple times, I did not receive the calcium supplements. Within 5 days of not receiving my medication, my body went into calcium deficiency.
Well, let me ask this question.
It
So
was tetany. So,
let me ask you this question. So your claim then, is your claim against the Department of Corrections? Is it against the judicial branch? Is it against the Hartford Police Department? Who did you file your claim against?
the state of Connecticut, which is the corrections officer. I'm sorry, the correction institution. which is the state of Connecticut.
And how long after this incident did you file your claim?
Now, with my claim, I had to make sure that as a result of me getting denied my medication, that you know, what the outcome was, what my health conditions would be. So through medical appointments, evaluations, doctor's appointments, I see my endocrinologist, my cardiologist, because I suffered a heart attack. When I was rushed to the emergency room from the correctional facility, my body sustained tetany, which is where your muscles, they're depleted of calcium, so they like how you have a muscle spasm or a Charlie horse. Excuse me, I told you. No, I'm on my meeting. You have to go back that way, and you're not dressed. Go that way. Thank you. Take yourself into your room. Go. Mayor, please go that way. I told you I have an important meeting here. Go. Thanks, Mom. You're welcome. So sorry about that.
Can I ask for a clarifying? Again, just when did this occur? When did the lack of administration of the medicine occur?
September 2021.
Okay. And when did you file the claim?
2024.
Okay. And obviously you're not getting the resolution that you want out of the claim. What have you been told about why you're not getting that resolution?
That the statute of limitation, or that you have to file within a year of the claim, but there's also a part that says you can file up to 3 years when you find out about more medical problems that you have. Now, with this right here, the medical emergency that occurred in 2021, I could not know the extent or immediate, excuse me?
Hold on a second, because I just want to make sure I'm myself and the committee are following you. So and I was going to go where you're going. So then I'm assuming that you are asserting today that it's not just the non-administration of the medicine, but that at a certain point subsequent to the actual non-administration of the medicines, you found out that non-administration of the medicines had an impact on you, and that was later than the date from which you've been told this should run. Is that correct?
Yes, sir.
All right. That is helpful to thinking about this.
And the important thing about it is that this is my endocrine system was affected. And these are internal organs that, you can't just go to one doctor's appointment, or even when I was admitted into the hospital, rushed from York Correctional, they wouldn't have known. They wouldn't have known the extent of the damage because it was internal.
Yeah, I think we grasp that. Let me check to see if there are any further questions from other members of the committee. I don't want to cut you off, but I think we kind of understand the basis for you being here today, and I just want to make sure that happens and we give everybody an opportunity to explain their side. But thank you very much. You've made it very clear. Are there questions or comments from other members of the committee? Questions or comments? Not Ms. Terry, thank you very much. The committee will consider what you have told us here today. Have a great day.
Thank you. And the only thing that I'm asking from the committee today is just respectfully to give me permission, grant me permission so that the evidence can be heard. You know, this is, it was very traumatic for me and still is. And I still go through, I'm still in physical therapy. I'm still seeing my,
Okay. We understand that these things really have deep impact on people's lives, and the committee has a process where we will consider what you've told us,
thank you.
consider what the claims commissioner has told us, and we will make a decision based on all of that, which is why it's so important that you were here this morning. So thank you very much for joining us, and I hope you have a great day.
Thank you very much. You guys have a great day also.
Right. Joanne Connolly. Joanne Connolly, good morning. When you are ready, you may testify.
So can I just say I have shingles in my eyes, so I'm a little slow reading?
I understand that, and if it's helpful, and it may be helpful even to the committee, you don't have to read every word. If you want to just summarize, and then we'll see if there are questions and kind of
Okay,
bring out more of it, that would be
Sure.
great too.
thank you. Okay. Good morning, co-chairs and members of the committee. My name is Joanne Connolly. I'm an RN, an acupuncturist, and a lifelong Connecticut resident. I've always loved animals since I was a little girl, when my dream was to be a veterinarian. Beginning in 2019, I operated a foster-based animal rescue, placing thousands of dogs and cats in loving homes. In 2022, I was a single mother in crisis. My daughter was struggling with mental health issues, cell phone addiction, and had become physically violent and emotionally abusive towards me, resulting in multiple hospitalizations and arrests. I was a victim of daily domestic violence at the hand of my own child. When I sought help, the state turned my crisis against me. On March 23, 2022, DCF conspired with Animal Control to orchestrate a warrantless search of my property. They cut my locked gate, entered my home with no warrant, no emergency, no exigent circumstances. DCF's own notes prove this was planned 5 days in advance, enough time to get a warrant, yet they chose not to. I refused consent and was denied access to my attorney until after the search. This was all captured on an audio recording. Police forcefully handcuffed me, resulting in injuries requiring months of physical therapy. The warrantless search was later characterized as merely a visit on the affidavit. 2 days later, they returned with a warrant based on false statements and observations from the illegal entry, another delay demonstrating no emergency. The state seized 71 animals, including my personal pets. I was arrested and incarcerated at York Correctional. DCF took custody of my daughter, placing her with a family who had groomed her. As a condition of my release, they ordered I could not speak to my own daughter. She was a straight A student in my care. In DCF custody, she became a high school dropout. Our relationship was severed by government order. Several animals died in state custody. Patty, a healthy vaccinated dog, died 18 months later, emaciated, suffering multi-organ failure from distemper. A parakeet starved to death in state custody. My German Shepherd developed a tumor the size of a soccer ball. They euthanized him alone and refused me the necropsy report. The appellate court acknowledged the fact of the warrantless search, but ruled the evidence could still be used because the proceeding was remedial. The state can break into your home, take your property, and keep it, as long as they call it a rescue mission. And it's not limited to animal cases. DCF is using these same tactics to remove children and erase parents. The agency created to help families is destroying them. Constitutional violations in child and animal seizure cases are functionally unreviewable. It is a piracy court you simply cannot win. I face 71 criminal charges for alleged animal neglect, including animals who died by state negligence. I lost my animals, my child, finances, my home, my health, my reputation, and years of my life. This is no longer just about me. In Northeast,
Ms. Connolly, if you could,
it's done.
okay.
Is that okay? In Northeastern,
Well, let me just say this. We usually ask folks to summarize, so if it's more than 30 seconds,
it would be.
okay, go ahead. And then there are questions for you.
This is no longer just about me. In Northeastern Connecticut Council of Government versus Tracy Donovan, the court cited my case as controlling precedent. The injustice done to me has now become case law applied to other Connecticut residents. The claim commissioner denied my claim on a procedural deadline without evaluating the merits. I missed the deadline because I was fighting criminal charges, and multiple attorneys advised me I had to wait until the case resolved to understand the full scope of damages. I'm asking the committee to grant me permission to sue and consider a just settlement for what I have endured. After 4 years, I'm asking for a chance to be heard. I have submitted full written testimony and welcome additional questions.
Representative Stastrom.
Thank you, Mr. Chair. I think she actually may have addressed my question in that last comment there. So you acknowledge that you missed the deadline to file in this case, correct?
That is correct, but I would like to point out I was suffering from severe PTSD. I had a head injury from my daughter, and I had multiple attorneys tell me I could not sue until this was resolved.
So I hear you, and we may go through this a number of times with a number of folks say this committee actually does not have discretion to waive that 1-year deadline. So, you know, we can determine the claims commissioner got it wrong in terms of, you know, the case was filed within the 1-year deadline, or where there's a denial on the merits, we have the discretion to say we think the claims commissioner got it wrong, but we do not have the discretion to waive that 1-year statute.
Well, except that it does say there is leniency right in the law that if you're not aware or if there's other circumstances, it does say that in there, I believe. I don't know how it's exactly worded, but I would think something this egregious that the state is now using against literally all citizens in Connecticut, that it really should be looked at.
Thank you very much for your testimony.
Questions and comments from other members of the committee? Questions or comments? There are none. Thank you for joining us, and we will consider your testimony in our deliberations. Peter Sterling. Good morning.
Good morning. I'm Attorney Peter Sterling. I represent Milagros Hess. Ms. Hess is the fiduciary of the estate of her daughter, Jakari Hess. Jakari Hess was in the care and custody of the Department of Children and Families, and on September 30th, 2020, she died. She had been in the care of the Department of Children and Families for less than a month. She was less than 4 months old. We brought a claim, the commissioner denied it. It's very difficult to summarize this in 3 minutes because it's the death case, but I'll do my best. It's our position that the commissioner's decision ignored facts and misstated facts. There are 2 dates that you need to be concerned with. One is September 29th, 2020, when the social worker took Jakari to Yale New Haven Hospital because she wasn't feeling well. While she was at the hospital records indicate that she did fine. She drank vigorously, she interacted with the staff, and according to the social worker, she was a happy baby. The hospital gave the social worker discharge instructions, which she shared with the foster mother when she brought her back. They're the standard discharge instructions you would get if you brought your kid to the emergency room. If your kid has additional symptoms, if there are issues that come up, you need to seek medical advice. Over the night of the 29th to the 30th, Jakari went downhill. The foster mother testified both to the commission and told the police that Jakari was up and down all night, was hard to console, hardly drank anything, and was clearly was not the happy baby that she was the night before. That morning, as she was getting Jakari dressed, she noted that the soft spot right here that on a baby is open and flat was not open and flat anymore. It was like a bag of jelly. That's what she told the police. Did she seek medical advice? No. She called her aunt, who was another foster mother. She discussed it with the social worker. The 3 of them didn't know what it meant. They just shrugged their shoulders. That morning, there was the first in-person visit with mom since September 7th. The social worker took Jakari to visit with mom. When Mom saw Jakari, she cut the visit short. She was clearly very sick. What Mom said to the social worker was, Jakari was like a zombie. She was unresponsive. She didn't move on her own. She didn't make any noise. She didn't smile. She was a zombie. The commissioner has none of those facts in his decision. None. The one, if I could just finish this, the one fact that he does have is that on the morning of the 30th, while the social worker was at Milagros' house, she did call the pediatrician. The commissioner says she called the pediatrician for help. She didn't call the pediatrician for help. She called the pediatrician to set up a follow-up appointment, which was extremely difficult to do because we were in the midst of COVID.
Okay.
One thing.
Hold on, because there are going to be questions for you. Trust me. So we'll pull it out. But let me. You want to go first?
Go ahead.
Okay. So I'm going to give you another 30 seconds to finish, and then I have a question for you.
Okay. What the doctor's note said is that the social worker called and told the triage nurse at the pediatrician's office that Jakari was doing better that day. She clearly wasn't. Jakari was dead by the time she went back to the foster mother. She was unresponsive in the car. She was pronounced dead at 2:05 that afternoon at Yale. She died of bacterial meningitis. And it's our position, the negligence of the foster mother and the social worker by ignoring the symptoms are approximate cause of the death of Jakari Hess.
Okay. And that was really the question to clarify what the root of the claim here is. All right. Well, that was my question. Rep. Pavlik D'Amato.
Thank you, Mr. Chair. So can you go over again at what point the baby was brought to the hospital and how many times?
What was the question?
How many times on what dates and times was the baby brought to the Yale New Haven Hospital?
She was brought to Yale New Haven on the 21st because she wasn't feeling well. After the 21st, she saw her pediatrician on the 24th, and she got a clean bill of health. And then she was brought to the hospital on the 29th because she wasn't feeling well.
And what was their diagnosis at the hospital?
Fever of an unknown cause.
Okay. And what was the reason for the denial by the claims commissioner?
The claims commissioner said it's very sad that Jakari died as a young baby, that the manner of death was natural, and he said that he did not believe that the foster mother or the social worker breached their duty of care to Jakari. They did not cause Jakari's death. But that's not the issue. The issue is whether or not a third party in the place of the state could be held liable given those facts. And we believe that that's what the commissioner should have decided. And we're asking the legislature to give us the ability to sue the state of Connecticut. We oppose Senate Joint Resolution 48, which would approve the commissioner's decision.
Okay, I did read, I do think that the statement given is very, I felt a little bit different than the claims commissioner. So I will be reaching out for some further information, but I just want to thank you for coming here today, and also for the mother following her mother's intuition. She knew something was wrong and she insisted that they bring her back to the hospital. And I have to say, as a mother, sometimes the first try or the first place you go to, you know, just doesn't get it right. But you know, as a mother, when something's wrong. So I'm glad she followed her instincts, and unfortunately it was too late. So thank you for your testimony.
Thank you.
Thank you, Representative. Representative Stavstrom.
Thank you, Mr. Chair. Sir, was there a full evidentiary hearing on this
Yes.
claim? Okay. And testimony was presented by both sides at that full evidentiary hearing?
Correct.
And I'm looking at the notes here. It looks like there was an expert witness that was, the state moved to preclude. Was that testimony ultimately allowed or no?
It was not.
It was not.
It
So
was
the,
not, because the issue was not a medical malpractice issue.
okay,
The issue was a simple negligence issue. That witness would have testified a certain way. The commissioner determined that he didn't think he needed that because our claim was not medical malpractice. It was that the state actors were negligent.
was a medical malpractice claim also filed?
No, when we first took this case, we ran all the medical records past a infectious disease doc, an infectious disease pediatric doctor from New York, one of the NYU hospitals, a emergency doc at John Dempsey, who is a personal friend of mine, and an emergency pediatric doc from one of the Boston hospitals, because we were looking at whether or not Yale was liable. None of those people could point a finger at Yale.
Okay.
Believe me, if we thought that Yale had made a mistake, we would have pursued it.
Understood. I guess my question is, or I guess maybe my concern is, so the claims commissioner, it sounds like, conducted a full evidentiary hearing, and at the end of the day, he determined that based on the evidence before him, he could not find grounds consistent with negligence. Is that fair to say?
I think that's fair to say, but
Okay.
as I've stated, I think he ignored evidence.
Okay. So you're asking this committee to overturn without the benefit of doing a full evidentiary hearing. So what evidence specifically did he ignore, or what key fact or law can you point to that we would say there was, clear error by the claims commissioner?
Okay. He ignored the fact that Judiciary did well while at Yale on the 29th. It was like she rallied. And he ignored the fact that the hospital gave the social worker discharge instructions that said, and we submitted some additional information this morning, and in our initial request for this committee to review, we outlined those discharge instructions. And in general, they are, if your kid's not getting better or turns worse, you need to seek medical attention. The next morning, her head is swelling. Nobody seeks medical attention. The foster mother discusses it with her aunt, who's a foster mother, I think, in Georgia, and with the social worker. And they just say, well, it could be anything. Yeah, it was. And the commissioner is right. It's very sad that this baby died. She wasn't 4 months old. And she was brought to her mom's. This would have been the first visit since she was taken into care. Her mom was so distraught, she cut the visit short. She described her baby as a zombie, and she expected the social worker to do something about it other than just call and get an appointment. You could see Griffin Hospital from Milagros Hess's driveway where the visit took place. It would have taken 2 minutes to walk the baby to Griffin Hospital, to the emergency room. Her pediatrician was a 5-minute drive away. Nobody did anything. This was,
Okay.
the social worker was so concerned that this was a court-ordered visitation that nothing else mattered.
Did the social worker testify during the hearing?
Say again,
Did the
please.
social worker
Yes.
testify during the hearing? Okay. And what was the social worker's explanation?
It was a court-ordered visitation. The baby was sick. And as to specifics, I don't know if you remember the Hogan's Heroes TV show, but it was Sergeant Schultz. I don't know. I don't remember. It's just,
Okay.
this was the only child of these people, Jamie and Milagros Hess.
All right, thank you, sir.
Thank you. Comment or question from other members of the committee? Comment or question? If not, thank you for joining us and providing us with further information to consider.
Thank you.
Have a great day. All right. We'll next turn to Deborah Stevenson. Deborah Stevenson. Okay. All right. Okay. All right. Abbas Mohammadi. Slow down a little bit and say it. I'm sorry about that.
No worry about it. Good morning, member of Judiciary Committee, and thank you for the opportunity to speak today, our testimony, and thank you for all the people in the back. They came today in support of me. On October, I'm not going to read from my testimony, which already been is filed, so I'm trying to summarize it. On October 1st of 2020. Attorney General William Tong and then the Commissioner of Social Services, Gifford, published a press release that was false, fabricated, and defamatory. That was in the middle of the COVID, obviously. That was the time that me and my company, which, we saw a lot of emergency patients, and we got even referral from other state agencies like UConn to treat urgent or emergency visits during the COVID. So first I saw the press release. I thought is a mistake because the press release indicated that that they have in possession of substantial evidence that Columbia Dental committed fraud. That was not part of the settlement agreement that previously I reached. They never any evidence presented to me that was purely based on the negotiation that occurred between my former attorney, which happened to be a former prosecutor in the same department, and then an attorney general office. So at first glance, I thought that is just a mistake. I wrote, of course, I asked my former attorney. He didn't want to too much cooperate, so I took the liberty and wrote to the Attorney General Tong. I said, okay, you can retract the statement or at least modify it because you omitted the resolving allegation. This allegation being resolved, you are claiming you are in substantial evidence. And this is also inconsistent with what then Attorney Durham or U.S. Attorney Durham published. It clearly indicated that the allegation had been resolved in the press release. Attorney Tong decided to ignore, denied my request, and one of his staff has just responded to me that it is what it is. Okay, we're not going to retract it. This press release still is online. Everybody that Google my name still can go and look at it. I'm having doctor. Yeah.
So your time is elapsed. If you could just summarize your point, and then we'll see if there are any
The
questions.
point of view that the press release is still sitting online, and I interview doctors. They come, they Google my name, they Google the name of the company, discourage professional provider that I'm trying to get it from other even states to bring it here. My company is open 7 days a week, 365 days.
Yeah, appreciate that. Representative Staffstrom.
Thank you, Mr. Chair. Sir, the grounds for dismissal here was that the claim was not presented within 1 year, is that correct?
That's why they claim, but this is continuation course of action every day. Even today, you go, it is online.
All right,
So this is
when was the press release first published online?
first published on October 1st of 2020.
And then when was your claim with the Claims Commission filed?
I do believe in 2023, August 2023.
Okay, so nearly 3 years later.
I would say 2.5 years.
All right, thank you very much.
No problem.
Comment or question from other members of the committee? Comment or question from other members of the committee? Not, thank you for joining us and providing us with further information. All right, next.
Thank you.
Thank you. Next, we have Linda Wibby. Good morning.
Good morning. Thank you. Good morning to Mr. Chairs and to the members of the committee. My name is Linda Wibby. I'm an attorney. I represent Columbia Dental, Columbia Oral, and Dr. Who you just spoke with. I'm not going to repeat my testimony that's unfiled, but I would like to give you a little extra background and certainly answer any questions that you may have. Just to give you some background, in 2015, the Office of the Attorney General began investigating a whistleblower False Claims Act investigation concerning the dental providers. The complaint was filed under seal and confidential, and for 5 years during that investigation, the complaint and the investigation remained under seal and confidential. It was not an investigation that was open to the providers. During that time, the providers did enter into a settle agreement and decided to stop spending the hundreds of thousands of dollars and resources going to producing witnesses, documents, and the like. They did not have any of the investigative materials, and to this day, they still do not, because under the False Claims Act, that investigation is confidential. Despite repeated Freedom of Information requests, despite requests for the information, it has never been made available to the providers. And even though we have gone to the FOI and they've identified the anomaly of hiding behind the confidentiality provisions of the false claims, the Attorney General made a press release disclosing his opinion and statements of facts of that investigation. And the providers can't fact check it. They can't prove the falsity because then they're shielded by the confidentiality provisions of the False Claims Act. Now, your question was whether or not it was timely filed. We believe the Claims Commissioner erred as a matter of law and saying that it was untimely. Each publication of this press release and each access is a separate injury. That injury continues, and the case law is clear that it is an ongoing injury or an additional injury. Defamation law and falsity and republication is very clear. Each republication is a new act, and therefore we believe the Claims Commissioner ruled improperly and contrary to the law, as it is and was timely filed. The injury continues, each republication continues, and there is no redress for the providers to prove the falsity while everything is hidden behind the confidentiality of the False Claims Act. The providers exercise reasonable care. They ask for it to be retracted. They ask for it to be modified. They've sought the proof to prove the falsity and have been denied that information. We believe the providers should have their day in court. We don't ask for an award of damages. We're not asking for anything other than an opportunity to prove the statements are false and seek redress in a court of law impartially with a full examination of the facts. I thank you for your time. If you have any questions, I know that Attorney Amato is coming after me. He is the attorney of record and will answer specific legal questions concerning the claims, but I'll do my best if you have any.
Thank you. Representative Jacobson.
Thank you, Mr. Chairman. Good morning. Thank you for coming in today.
Thank you.
Just a first question. So you mentioned that the next speaker is a counsel of record. Is that in connection with the ongoing, there's an appeal that's ongoing, is that right? Is my understanding correct?
That's a separate lawsuit. That is a state action that has been brought against the individuals. The state actors issuing the press release under constitutional law. What we're asking for is a claim against the state of Connecticut. The action for intentional conduct against the individuals is on appeal. They're separate claims and they're separate causes of action. I do believe that the claims commissioner did get that wrong. They're not the same claims and they're in different capacities.
I understand that there's a distinction of parties. Does the factual predicate underlying the claim arise from a similar nucleus of operative facts?
The operative facts are the same, yes.
Thank you. Okay, thank you.
They have immunity, they have governmental immunity, and that issue is on appeal, is whether or not the claims were dismissed under the guise of governmental immunity.
And do you recall what the basis, the Superior Court case, the underlying Superior Court case?
Governmental immunity.
Is that the sole and exclusive basis?
I believe every claim was, and if I'm wrong, I'm sure Attorney Amato will correct me, but yes, I believe it was governmental immunity, qualified immunity, and sovereign immunity.
Okay, thank you very
Thank
much.
you.
Thank you, Mr. Chairman.
Thank you. And just so I'm clear, so this stems from a release that was done by the Attorney General, is that?
Correct.
And is this the 10/1/20 release that the Attorney General did?
Correct.
And just so I'm aware, it's the Attorney General Tong announces a $300K settlement. Is that release?
Yes,
okay.
and where Attorney Tong goes on to state that there was substantial evidence of misconduct that was uncovered in the investigation. The investigation has never been made available to the providers, and we believe that is a false and defamatory statement, and there's no evidence to support that. We would like the opportunity to prove that, but we can't at this juncture because the investigation, according to Attorney Tong, is confidential, and he will not produce any of that information. Yet he's able to make the statements without any fact checking, without any ability to prove the falsity of it. And it is ongoing conduct. Each time that press release is accessed, it is an ongoing claim. And we believe that is the time frame that starts. Under law, each publication is a separate defamatory act.
Okay. Further comment or question from members of the committee? Further comment or question? There are none. Thank you very much.
Thank you. Thank you for your time.
Patrick Phelan. Hope I didn't mess that up.
Yes, good morning, members of the committee. My name is Patrick Phelan. I represent Carol Falcone, who is seated behind me this morning, and we have appealed the decision of the Claim Commission to deny her claim. Each day, as many as 5,000 people attend the Department of Motor Vehicle facilities in Connecticut. We filed the claim because she was injured seriously when she fell on a poorly maintained parking lot at the Department of Motor Vehicles. The state law on claims commission matters provides that permission to sue will be granted if the state entity could be held liable as if it were a private citizen. Well, if the DMV was Target or Stop and Shop and they didn't maintain their premises, they could be held liable. The Deputy Claims Commissioner held a full hearing on the case, and at the end of it decided that the evidence supported a finding of no liability against the Department of Motor Vehicles. And there's two things wrong with that. First of all, he did not apply the law, which is simply to apply that gatekeeping function to determine if the Department of Motor Vehicles could be held liable if it were a private citizen. Secondly, and somewhat paradoxically, by conducting a full-blown hearing on the merits, weighing evidence and considering the testimony, he implicitly admitted that, yes, the state could be held liable, but he would take the position that he could decide whether to impose liability or not. That is a violation of the law. The law only requires a gatekeeping function. It's for the Superior Court judge, after permission to sue has been granted, to make the factual findings as to liability. So we are here today to ask you to set aside that decision denying suit, authorizing suit, or reversing the decision of the Claims Commissioner. And interestingly, when we filed this claim, the Attorney General called me up and said, listen, this is clear cut. I'm going to recommend that the permission to sue be granted so we don't waste our time at the Claim Commission level. Ms. Falcone sustained serious injuries requiring surgery. She's never filed a lawsuit before. She is a retired school teacher who's lived in Connecticut her entire life, and all she wants is a chance to have her case heard in accordance with the law, decided on the merits, and to have the law applied as it should be, since Governor Ribicoff signed this law into Act 1959 to see that the state could be held liable if it were a private citizen. That's what we're here for today. The decision of the Deputy Commissioner was wrong. the discovery we conducted in the Superior Court, we filed a lawsuit against the property owner, and a lease was produced in discovery which said that the Department of Motor Vehicles has sole and exclusive responsibility to maintain the parking lot. That had been a lease that was signed a number of years beforehand. There was testimony by the property owner as to what the Department of Motor Vehicles does every day to go around fixing the premises, cleaning the premises, and in this case, they could be held liable as a private citizen should, so I'm asking this committee to set aside the decision of the Claims Commissioner. I'm happy to answer any questions that you may have.
Thank you. Representative Jacobson.
Thank you, Mr. Chairman. Good morning, sir.
Good morning.
Thank you for coming. So you said a full-blown evidentiary hearing was undertaken.
Yes,
Can
right,
you
yes.
elaborate on that, please?
I'm sorry?
Can you elaborate on that?
Yeah, what I mean by that is the function imposed by law on the Claims Commissioners to determine simply, could the entity be held liable for a private citizen? Well, at the Claims Commission, evidence was taken, testimony was presented. There was a expert witness, a submission made, a report of an expert witness that detailed 6 code violations, and it was uncontested. And Ms. Falcone's testimony, for all intents and purposes, was uncontested because they didn't present any evidence or testimony that the premises was not safe. But we should not have gotten to the point where we had a full-blown hearing with witnesses and testimony and evidence. The Claims Commissioner's legislative duty is simply to determine if the entity could be held liable if it were a private citizen. I submitted my testimony, and I also submitted some evidence that was produced at the hearing, including the report of a code compliance officer who said that there were 6 violations that he determined when he inspected the premises. But we should not have gotten to the point of having a full-blown hearing at the Claims Commissioner. The only task of the Claims Commissioner was to determine if the entity could be held liable if it were a private citizen.
Thank you for that. Can you also made reference to comments made by the Attorney General's office? Can you elaborate on that as well,
Yeah,
please?
Mr. Grolu was assigned to defend this case, and when he appeared, he contacted me and we discussed the case. He said, listen, I'm going to recommend that permission to sue be granted because this is obviously a situation where the state could be held liable if it were a private citizen. We're not saying that Ms. Falcone has a right to win the case. We're simply asking that the law be applied, which allows her to get to the Superior Court. So what he said was, I'll recommend that it be permission to sue be granted. Next, he got back to me saying, my superiors have overruled me on that. We're going to go to the Claims Commissioner route.
So just correct me if I'm wrong in terms of my understanding of your position. Your position is that the Claims Commissioner's determination was ultimately merits-based relative to the underlying claim, and your position is that's a deviation of the gatekeeping function of the statute that constitutes reversible error. Is that understanding correct?
Yeah, that's right. Yes, the section 4-60 says permission to sue shall be granted if the state could be held liable as if it were a private citizen. And as I say, the irony is by having this whole hearing on the merits, it's an implicit recognition that yes, the state could be held liable, but I'm going to make a factual finding that they're not liable. We shouldn't have gotten to that point. So that's all.
Okay, thank you. Thank you, Mr. Chairman.
Thank you. Senator Kissel.
Thank you very much, Chairman Winfield. Did anybody object? Like, I mean, you say that the Claims Commissioner went through this full evidentiary hearing, and you're stating now that that was actually something that should have been done in the Superior Court, and they should have just acted as a gatekeeper. Did something take place prior to the commencement of this hearing where you put on some record that I object, this is beyond the authority of the Claims Commission?
Prior to the hearing, we did not object because we went to the hearing fully expected that the scope of the hearing will be that defined by section 4-160, which is to determine if the state could be held liable if it were a private citizen. At the time of the hearing, there was an objection to proceeding past that gatekeeping function into taking evidence and weighing and considering the evidence. So
There was an objection.
Yes.
Okay, thank you. Thank you, Mr. Chair.
I would also add, if I may, the statute lays out what the responsibility is, and I don't think it's something that would be waivable in any event, but that's all I have.
Thank you. Representative Fishbone.
Thank you, Mr. Chairman. I guess procedurally, one doesn't know what the fact finder is going to do when they render their opinion. So, questions are asked, evidence is taken, and it's up to the fact finder to determine where the line is. But certainly, I'm certainly sympathetic to the argument here today that the determination as to actual liability lies perhaps not with the claims commissioner on a case like this, but the Superior Court should it get there. So I do agree generally that that is the function of the claims commissioner, and then we let the process be what it is. So thank you, Mr. Chairman.
Thank you. That is the literal language, and that's a strict construction of the law. So thank you.
Thank you. Question, comment from other members of the committee? Question or comment? There are none. Thank you very much for joining us.
Thank you all. Appreciate it.
All right, next we have Milagros Palak-Hess. Milagros Palak-Hess.
That's our client, but it looks like she was unable to make it
Okay.
this morning.
Okay, thank you. Thank you
Thank
for
you.
that. Janine Lavoy. And then I'll go back to Jennifer Tao. Sorry to skip you.
Good morning, all chairspersons and General Assembly. My name is Janine Lavoy, here for claim SJ 61. Thank you for allowing me your time to speak with you. So I feel the denial of the claim should be reconsidered. I'm here on a fight for my daughter, Anastasia Paul, who is no longer with us, who is only 22, who also got brutally murdered in the town of Vernon in her own apartment by her child's father, Abdul Mboob, who strangled her to death in front of my grandson, who was 1 at the time. He has a long prior history, Abdul, of getting arrested, assaults, abuse, violating protection orders, and many more. My daughter applied for restraining orders and called the police on several occasions because she was scared for her life, and nothing was done. He was incarcerated this last round for abusing her while she was pregnant with my grandson, and came out released May 2023, and 2 months later killed my daughter. I think her death could have definitely been prevented and controlled if the system wasn't as lenient with his punishments, and should have had an automatic protective order put on him in his release in May 2023. He shouldn't have been released on a $50 bond after he came out on another arrest after May, which was in July 2023, literally 2 weeks before murdering my daughter. Laws should definitely be enforced, and innocent citizens should be protected. My autistic grandson, who is 3 now, is without parents for the rest of his life. And yes, we are asking for the ability to proceed with this claim and explore more discovery.
Thank you. Representative Fishbein.
Thank you, Mr. Chairman. Very sorry for your loss.
Thank you.
I get involved in a lot of cases where women especially are abused, and I totally am sympathetic to your situation. What I'm trying to look at here is what did the state, in your opinion, do wrong that led to your daughter's death?
Well, like I said, she applied for restraining orders. I'm not sure if they were heard or noticed. She called the cops in her town of Vernon from her apartment over and over, saying that how scared she was, that he was out, this and that. And, they never acknowledged that. So I just feel a lot could have been prevented, like lawfully.
So you mentioned
They released him, the DOC released him, like without I feel the state should have definitely have had a automatic protective order of him getting released instead of walking out on a simple probation or just.
the matter that he was last incarcerated for before her death, was she the victim in
Yes.
that? Okay.
Yeah, he brutally beat her up when she was pregnant with my grandson.
And what was he originally sentenced to?
I believe he did like a 1.5 years.
Okay, that's what he actually did, but was his original sentence something more than that and it got reduced?
Sure, I'm not too sure about that, but
Okay.
I know he did a whole year and a half, and
Yeah,
I just feel like I know the protective order is just a piece of paper with, but I feel like some people would definitely get intimidated by that. And maybe if he would have had a protective order on him, maybe he would have thought twice in his head, like, let me not do this. Like, it, I don't know. You
yeah,
just
but
never know.
for those really bad people that for whatever reason are going to inflict bodily injury upon someone, piece of paper doesn't mean anything, but
Yeah. And then like after that release in May, he got arrested again. I believe it was for another incident with my daughter, but this time it was like a breach of peace or something like that. And he got released on a $50 bond
yeah, I
on
mean,
top of, just getting released out of prison for domestic violence, and has a history of violating protective orders that my daughter had on him before. So it's just the list goes on.
yeah, once again, very sympathetic. I will tell you, not that it'll, bring your daughter back. We do have a bill this session that has to do with the issuance of criminal protective orders upon conviction for the court to either issue one or to say why they aren't.
Yeah.
And perhaps if that law was in place at the time of his conviction, perhaps that would have solved that. But I thank you very much for, putting a face on your case.
Yeah.
Thank you, Mr. Chairman.
Thank you.
Thank you, Representative Jacobson.
I'm so sorry. Thank you, Mr. Chairman. And I too, my condolences, my sympathies for your loss. Can you, the perpetrator, what consequences, if any, did he face as a result of
We're still going to court.
criminal court?
Yeah.
So is
He's still incarcerated. We're still in the works of things almost 3 years later.
is there a trial date set?
Nope.
Do you know what you said here today, what he's been charged with?
There was a couple of different: strangulation, murder, risk of injury to a minor, being the baby was there, my grandson, tampering with evidence. So.
Okay. Thank you for sharing that. And again, I'm sorry for your loss. Thank you, Mr. Chairman.
Thank you.
Thank you, Representative. Are there any other questions from members of the committee? Any other? I do have one. I know that I actually have seen this case. So I know that at one point he was talking about hearing certain things, voices, spirits, etc. And I know that came after the murder. Did any of that type of behavior happen prior to the murder? No? Okay.
No.
All right. Thank you very much for sharing your information. It will help us to make a determination here.
Thank you.
Thomas Amato. Oh, no, I'm sorry, Mr. Amato. My eye is slipped and I don't want to further skip over. So let me try for Jennifer Tao. Let's see you on there.
Okay, can you hear me?
Yes. And then you will be next, Mr. Amato. Yeah, you may proceed, Ms. Tao.
Good morning, co-chairs and members of the committee. My name is Jennifer Tao, and I am here in opposition to SJ 45. On April 4th, 2022, I submitted a long letter to the Superior Court of Rockville in a DCF case involving my now adult niece, who I refer to as S, and my sister, Joanne Connolly. This is from that letter. It has been my greatest fear for well over a year now that one day I will receive a phone call that my niece has murdered my sister. I've even rushed to her house when I could not reach her, fearing the worst. I called last year to find out how to file a complaint with the state police for their neglect, because I told them that their casual approach to my niece's behavior had emboldened her and would lead to my sister's murder. I do not use that word as hyperbole. I firmly believe S is capable of murdering her mother and anyone else who gets in her way, and I do not say that fearlessly by any means. So moving from that letter, that horrific domestic violence situation in which the state took the side of a violent, phone-addicted, mentally ill teenager over that of her victim mother, who relentlessly spent time and money in search of help for her daughter, should speak volumes to this committee as to how deeply dysfunctional and riddled with poor judgment the system itself is. Taking it to the next level, the state has undertaken a campaign of terror and revenge on Joanne for refusing to be further victimized, for refusing to admit guilt where there was none, because DCF and animal control colluded with the daughter and the estranged father to illegally enter the home, a home that was full of boxes in the midst of being packed for a sale, a home soaked by a water leak that occurred while the daughter was hospitalized after an attack on her mother, a home badly damaged by the violent outbursts of the daughter, a home where the daughter had staged scenes she hoped would land her mother in prison. Because the state took none of that into account, they have worked tirelessly for 4 years, spending taxpayer dollars to destroy the health, life, and reputation of an innocent resident of this state. As the Judiciary Committee, you are surely sensitive to the concerns any citizen rightly has over our constitutional rights to privacy and safety in our own homes. In 2022, Joanne's Fourth Amendment rights were trampled when DCF, Animal Control, and the state police knowingly, illegally entered her home while she clearly denied them permission. They proceeded to use the conditions I described above, along with false testimony from those agents to secure a warrant, and 2 days later entirely obliterated the life she had worked for since she was 14 years old. The violence against her evident in the body cam footage should outrage any citizen. Yet even after all of that, her greatest losses have been that of any hope to heal her daughter and the personal companion animals she adored. It baffles me that the state grants any paid official this kind of power, the power to obscure their own errors, their own lies, their own egregious attacks on a citizen of this state, then grants them the power to deny redress. So that power is left with you. The state of Connecticut, acting as DCF, Animal Control, and the state police, should be expected to answer for their actions. And you have the power to at least ensure that the opportunity Joanne has to seek that recourse is not one more right stripped from her. Unfortunately, you also told her that you don't have that right. And I just think that has to be unacceptable. There has to be some way when someone is suffering so much pain and trauma and PTSD and incorrect information from their lawyers that an exception can be made and allow that person to proceed. Thank you.
Thank you. Question or comment from members of the committee? I'm going to go first. Representative Jacobson.
Thank you, Mr. Chairman. Good morning, ma'am. Thank you for joining us this morning. Is my understanding correct that the Claims Commissioner dismissed the case for a question of timeliness?
Yes.
I see in the notes that I have here that you requested that the Assembly waive the requirements of timeliness. Is that accurate?
Well, you mean what I just said to you? I'm asking for an exception to be made on her behalf because the situation is so extreme. I mean, we're 4 years later. She's not even had a criminal trial yet. The charges against her, it's so bizarre to me that a person can be charged with criminal charges against them because of the consequences of severe domestic violence. It makes no sense to me. And the courts, I'm sorry, DCF, I had written this letter to DCF, much longer letter, that bit I told you, but that the police knew what was happening. They were multiple times called to the home, multiple times arrested the daughter. And yet during that day that they arrested my sister, they called her horrible names and claimed that they knew that the daughter was never the problem. I mean, it's shocking. My own children would not allow my niece in my home because she was so dangerous. The whole situation is so shocking to me. It's hard for me to believe that something like this could happen until I saw it happen in my own family. There has to be some kind of redress for such a horrific situation.
Thank you, ma'am. Thank you, Mr.
Thank
Chairman.
you.
Thank you. Representative Fishbein.
Thank you, Mr. Chairman. Morning, ma'am. Ma'am, is there something, we're getting an awful lot of echo off of your audio. Is there something you can do? Do you have like 2 systems up or something?
Is it better now?
It's a little better. Okay.
I just put in my earbuds.
That's much better.
I'm actually at a doctor's appointment. He stepped out so that I could give my testimony.
Okay. Well, I hope everything works out well with you there. Can you just, the Connecticut Constitution prevents what's known as a public emolument, and that's a personal benefit given to a particular individual. separate and apart from others. So what I'm hearing is that you're asking us to give you a benefit that would not be provided to others.
So this is not for me personally. I'm testifying about my sister's case, which you heard earlier. And what you may have missed in what she said is that her case is being used now as precedent to harm other members of the state of Connecticut. It is being used against other people. And that has been her argument, that this was done intentionally. They would not acknowledge their mistakes. They would not acknowledge their errors, because to do so would allow other people who are also being subjected to this inappropriate invasion of privacy would have to be stopped. So her argument, which I think you heard in her case, is that at least one case now has been dismissed because of her case, but her case should never have proceeded as it did. So somehow this landslide has to be stopped.
Yes, and I offer that if perhaps the matter was filed on a timely basis, that there would be a remedy. I'm just trying, the sole issue before us right now is whether or not to waive the statutory timing. And I'm just trying to wrestle with that. I'm certainly sympathetic to the claims, but I can't identify why we should be giving that particular benefit
Can,
to the
can I
single.
urge you to look at the full testimony that she submitted? Because when you see the degree, I mean, I assume if you had somebody who was, hospitalized for a long period of time, that might have been a rationale. If you look at the testimony she submitted and you look at the injuries that she sustained, the PTSD, and the fact that, again, we rely on our attorneys to give us accurate information. She was told repeatedly by her attorneys that she could not file until the case was resolved. I don't know how a citizen is supposed to wade through this kind of information and not make an error. And then the state can make many errors, do many things that are intentionally harmful, but a citizen is held to a different, almost higher standard in terms of how they are supposed to respond to that kind of damage to their own lives. That makes no sense to me. I'm just asking that you please look at the full submission of her testimony before you make a decision, because a lot of people can be harmed by the consequences of this action, not only my sister.
No, I understand. And really the issue before us is not the gravity of the damages, it's the procedure itself. So perhaps if you relied upon legal advice and you hired an attorney, which you said there was an attorney involved, and that attorney didn't give the right advice, perhaps as a claim against the attorney. But I'm just looking at the Constitution and the confines of the statute. So, but I thank you for coming here today and telling us your story.
Thank you.
Thank you, Representative. Comment or question from other members of the committee? Comment or question? There are none. Thank you for joining us and providing us with.
Thank you.
Now, sorry about that, Attorney Yamato.
And members of the committee, my name is Thomas A. Amato. I'm a lawyer in Manchester, Connecticut, and I represented the claimants regarding HJ number 47, and that is entitled Resolution Confirming the Decision of the Claims Commissioner to Dismiss the Claim Against the State of Columbia Dental PC, Columbia Oral Maxillofacial Imaging LLC, and Dr. Abbas Mohammadi. I'm testifying today in opposition to that resolution. The Special Deputy Claims Commissioner issued a decision on June 26, 2025, dismissing the claim on timeliness grounds. But that decision, we contend, is illogical, inconsistent, and flatly contrary to prevailing state law on basically two grounds. The commissioner found, and by the way, I just wanted to clarify that under the statute, claims against the state have a 1-year limitations period, as the committee knows, after the date when the damage is discovered or sustained or reasonably could have been discovered. This claim was filed on August 3rd, 2023. The decision, page 4, finding number 10, the Special Deputy Claims Commissioner found that the state published a press release on October 1st, 2022. Regardless of what other documents said, that's the finding of the Special Deputy Claims Commissioner. August 3rd, 2023 is certainly pursuant to the calendar within 1 year after October 1st, 2022, thus making the decision logically inconsistent and contrary to the prevailing state statutes. Now, I also want to expand and supplement very slightly the very cogent and incisive testimony of Attorney Wibby. I want to add some excerpts from some state Supreme and Superior Court decisions regarding the single publication rule, which the Deputy or Special Deputy Claims Commissioner misapplied. In this situation, there were multiple publications. Every day, the AG has issued this defamatory press release. Every day, the cause of action accrues. Our state Supreme Court stated, quote, "With each publication, a new cause of action arises," unquote. Other cases have said that each time a party makes or repeats a false allegation, such act constitutes a distinct event that supports a new cause of action for defamation. The operative phrase, the salient phrase, are those two words, quote, "or repeats," unquote. That implies that if something is repeated, it must have been alleged before. So if it's repeated, whether it's the second, third, fourth, or dozenth time, if it's, I just have one more comment to make, if it's permissible.
Good.
I just want to quote for this committee one of my favorite U.S. Supreme Court cases, and only take about 10 seconds. In 1979, the U.S. Supreme Court decided the case of Hutchinson versus Proxmire. It was a defamation case. Reported 443 U.S. Reports, page 111 from 1979, and the court said, quote, "No man ought to have a right to defame others under color of a performance of the duties of his office," unquote. That's the law of the land. We're asking this committee to find that the commissioner made an error in misapplying that single publication rule to authorize us to sue the state in the Superior Court. Let the Superior Court sift through the factual and legal
Okay.
issues.
All right. Yeah. So a little more than 10 seconds, but I do have a question for clarification because I'm a little confused now because when I was interacting with Attorney Wibby, I asked about the press release on 10/1/2020. So I understand the argument, the continuous course of action argument you're making, but explain to me how 2022 is the publication date.
Well, that's what the commissioner found. That was his finding. Now, I don't know how he came up with that. I'm not sure on what evidence. Again, there was no hearing. It was just a ruling on the papers that the claim was tardy. But because the finding was October 1, 2022, then internally, the claim has to have been timely.
Okay. Representative Fishbone.
Thank you, Mr. Chairman, for the peripheral vision on that. I thought you were looking that way the entire time. No problem. So there's many things that we could do here. One of which, you mentioned that there wasn't a hearing. You didn't have an opportunity to argue before the claims commissioner this date issue. We do have the ability to send the matter to, essentially remand to the claims commissioner to have some sort of a hearing in that vein. Would that be acceptable to you and your clients?
We had really preferred that and I think the better option would be that we just seek authorization just to sue the state and just let the Superior Court decide that, because there are a lot of factual and legal issues that we think would be better suited for the Superior Court than it would be for a remand to the claims commissioner.
Okay, and I understand your position, although I don't know that we are suited to do that either. Same sort of review on the papers, right? But I appreciate the exchange. Thank you. Thank you, Mr. Chairman.
Thank you. Representative Jacobson.
Thank you, Mr. Chairman. Good morning, Council.
Morning.
I have some questions regarding the, I guess, the pending appeal
Correct.
and
there is one.
the underlying litigation. Can you distinguish for me, please, the allegations and the parties in that case and how that differs from the matter presently before us?
No, certainly I'll try. In the state constitutional case, we brought an action against William M. Tong and Deidre S. Gifford in their individual capacities under 42 U.S.C. Section 1983 for constitutional violations under a number of theories, the stigma plus doctrine, interference with illegitimate governmental activities that had no justifiable purpose, and invasion of privacy. Those are actions against those individuals in their individual capacity. Now, the distinction between that case and this claim is that this claim is against the state under state law theories, defamation, civil conspiracy, also invasion of privacy, negligent infliction of emotional harm. They both arise out of the same nucleus of facts, but they are distinct remedies with distinct focus in mind. Again, both cases, and I think maybe what you might be asking is, well, what if we allow this to go forward and authorize a lawsuit against the state in Superior Court? Will that overlap with the other case? And there's a remedy for that too. It's called a stay. And if one case resolves first, then of course it'll be subject to the prior pending action doctrine or res judicata. So both cases cannot proceed and get remedies in both cases. One will have to take precedence over the other. But on the contrary, if the appellate court affirms the Superior Court decision dismissing the case, and we don't have any authorization to sue in Superior Court, we're left without any remedy whatsoever.
The underlying 1983 civil rights case, is that pending in Superior Court or is that in federal court?
That is pending in state Superior Court, actually now in the appellate court. The Superior Court dismissed it on qualified immunity grounds and on the ground that the plaintiffs consented to the issuance of the press release, which we claim is incorrect because the settlement agreement prohibits the disclosure of information, in our estimation, about the underlying fraud investigation. They did not consent to that. So that's on appeal right now in state appellate court.
And what is the status of the appeal right now?
We conducted oral argument on January 6, 2026, and we are now awaiting a written decision. I'm imagining sometime 4 to 6 months after oral argument.
Thank you, counsel. Thank you, Mr. Chairman.
Any other questions?
Thank you. Any further questions from members of the committee? Any further questions from members of, there are none. Thank you, Mr. Amato, for joining us today.
Thank you all.
Patricia Calvelli.
Good morning, chairpersons and General Assembly. This is also in regard to SJ number 61. I wish to appeal to you to review and reconsider the commissioner's decision to dismiss this claim, which is based on the state's actions and lack of actions preceding my granddaughter Anastasia's violent murder in July of 23. Anastasia had a prior off and on relationship with Abdul Makboob, and she had a son, Major, on 3/25/22. This person has been incarcerated in the state's custody 15 times since 2019. Many of his charges were due to violence and abuse to Anastasia. The state knew of Makboob's violent history with Anastasia, inclusive of unlawful restraint, threatening, assault by punching, dragging, choking her, including when she was pregnant. He as well had numerous charges for violation of probation and protective orders, both associated with Anastasia as well. On 7/3/23, he was once again arrested, still on probation, and released on just the $50 bond. 2 weeks later, on 7/17/23, in Anastasia's apartment, he assaulted her and choked her to death, all with 1-year-old Major right there. The state should have taken more responsibility, steps to protect my granddaughter, and they did not. It was their duty to do so. They were well aware of Makboob's violent history, violent tendencies, and is danger to Anastasia. How many protective orders does it take to realize that the abuser is a threat to the victim's survival? Vital changes are needed. There needs to be and should have been automatic mandatory protective orders in place that are required for repeat abusers upon their release from prison. So on behalf of my family, I am imploring for your reconsideration to the dismiss of this claim. Thank you.
Thank you. Representative Fishbaum.
Thank you, Mr. Chairman. Ma'am, I'm very sorry for your loss.
Yeah.
It's the last phone call we ever want to receive, right? I, one of the things I'm trying to drill down on here, the last conviction, we know that he was released May of 2023. Do you know what he was originally sentenced to for that conviction?
In May, no, but his actual last arrest was July 3rd, 2023. It was a misdemeanor. That's when he was re-released once again on a $50 bond.
So when he was released from incarceration in May of 2023, I would expect that he would have been on probation or something.
Right.
So the arrest that happened 3 months later would have been a violation of probation.
Exactly. It was.
But as a result of that, he wasn't reincarcerated. They left him out.
Well, yeah, he bonded out on the $50.
Yeah. Okay. And then when did she pass?
2 weeks later from that date.
And what was he arrested for in July?
It was a misdemeanor. I think that was the breach of peace.
So was it a breach involving her?
I'm not sure about that because he was arrested so many times.
Yeah, I see. I
for
looked up.
her abusing her, so I don't remember.
Well, I thank you for bringing us the facts here, and once again, I'm very sympathetic for your
Thank you.
loss.
Can
Thank
I also add that his charges pending currently, like my daughter said, murder, strangulation, interfering with officers, resisting, false statement, risk of injury to child, and the tampering with physical evidence. So there's actually 5 charges.
No, I saw that. I saw that in the system. Unfortunately, the murder conviction alone, you get 60 years, but it ain't gonna bring your daughter back.
Right.
So, I mean, I totally got it. So, but thank you, Mr. Chairman.
We actually have a meeting with the prosecutor this week, and we're told that he's possibly ready to plead guilty to murder, so we'll see.
Thank you.
Thank you.
Don't leave yet. Representative Jacobson.
Thank you, Mr. Chairman. It's okay. I don't have any questions. I just wanted to express my condolences and I wanted to share that I appreciate the position that you've come here today to put a face and a voice behind this. It's not easy. And I just wanted to state and look at you in the eye and directly say, we appreciate it. We hear you. Again, I'm sorry for your loss.
Thank you. Representative, comment or question from other members of the committee? Comment or question from other members of the committee? There are none. I too want to thank you. It's important that the committee understand fully what's in front of us. Thank you very much.
Okay, thank you.
Kenneth Krajewski.
Good morning, members of the Judiciary Committee, Senator Winfield, Representative Staffstrom, Representative Jacobson. I'm here. I want to take a moment of my time. Omar Miller tried to testify earlier, and I've been texting with him. I know him. I support his claim. I don't represent him, but I would encourage the Judiciary Committee to vote in his favor. He was texting me and asking me when he would be brought back in. He was the first, if you recall, Senator Winfield. The second,
I'll just say briefly, if he's around at the end, he should be able to testify.
Okay. Number 2 is I'm listening to Ms. Calvelli and Ms. Lavoie testify, and I'm reminded of Tiana Notice. For those of you who've been in the state for a long time, we may remember Tiana Notice. She begged the Bloomfield and Plainville police departments and Waterbury police departments for a restraining order, and her boyfriend killed her on Valentine's Day in like 2009. And 17 years later, or 15 years later, I'm hearing the same thing here, and I'm really hoping that we can get a solution to violence against women. I know I am here on House Joint Resolution 35, and I asked the Judiciary Committee to overturn the decision of the Claims Commissioner. In 2018, Patrick Camara was incarcerated, and he came to me and asked me to file a claim. The Claims Commissioner had a many year-long backlog. So rather than going directly to the Claims Commissioner, we went directly to the federal court, and we filed a 4-160 claim with federal court, and it was rejected. We were confident that we would win in federal court. However, the Department of Corrections attorneys in the Office of the Attorney General withheld evidence. We asked for it 8 different times, and it wasn't until 2 years after summary judgment was granted in favor of the Department of Correction personnel that I realized, and I uncovered in a different deliberate indifference claim, that the Department of Correction had hidden evidence demonstrating that Mr. Camara was among the 45 worst cases of medical care in 2016 and 2017. If the members of this committee will recall, last year in Senate Bill 1543, which was the Omnibus Prison Reform Bill, we had a provision that got out of Judiciary Committee saying, if people recall the Criminal Justice Institute report that came out, where that former Commissioner Scott Semple commissioned, and the CJI report asked or documented the worst cases in the DOC, and then the DOC continued to make a list, and there were 45 cases. Last year, the Judiciary Committee did a joint favorable on this portion of Senate Bill 1543 to both notify the members, or notify the people whose loved ones died that were investigated in the Criminal Justice Institute report, and to repeal the statute of limitations on those cases so those families could get redress of grievance. Those families still do not know that the DOC identified their medical care as negligent. This is one of those cases. Patrick Camara was one of those cases, and I only learned about this through another case.
Comment or question, Representative Jacobson.
Thank you, Mr. Chairman. Good morning, Council. It appears that the basis of the dismissal was one made on timeliness. Is that correct?
Well, yes, because we didn't file with the Claims Commissioner until 8 years later, even though we filed a Claims Commissioner claim in the federal district court. If you recall, in 2018, the process in the Claims Commissioner was so mucked up, and eventually in 2021, we changed it and we added 4-160F, which allows plaintiffs to take a certificate of good faith and go directly into Superior Court without getting permission for the Claims Commissioner. In 2018, that's essentially what I tried to do in federal court, because we were like, Patsy's alive. We want to move his claim as fast as we can. And Patsy died in March of 2019. So we just didn't send the federal complaint to the Claims Commissioner. The state had notice. The state knew in September 2018 that we wanted to file in negligence, but that we just, it was sort of a protest because the Claims Commissioner situation was so broken. So we filed, and at that time, Judge Thompson dismissed the Claims Commissioner claim in federal court. I know it sounds strange, but if you recall, like, I still have a case from 2018 that was in the Claims Commissioner for 7 years that just got adjudicated. We've all heard of the Pavonics claims, which I represent, where Pavonics sat in front of the Claims Commissioner for 17 years. So in 2018, we were like, Patsy needs to get justice, and we need to get it quick so he can see. I mean, Patsy had a tumor the size of a baseball in his sinus cavity that wasn't diagnosed. He had photophobia. He had proptosis. He had nosebleeds. And that wasn't enough to vindicate his Eighth Amendment rights under the United States Constitution, the United States District Court, which is upsetting, because I'm not sure if early cancer screening isn't part of the panoply of healthcare provided by the Eighth Amendment to the Constitution. What is? So this is why we're moving in this forum. We've tried, and as I said, this is in line with what the committee did last year in granting the people who were identified in the Criminal Justice Institute report the right to sue, but then Governor Lamont stripped that provision out of. I think I turned my microphone off, sorry.
So I was not in the building in 2018. I'm not too familiar with what the applicable law was that governs this issue. Is it your position, or is it my understanding that your position is that while the claim was timely filed in the federal district court, for whatever reason, it wasn't filed with the claims commissioner, and that to uphold a decision on that basis is akin to elevating form over substance?
Yes.
Talk to me about the negligent concealment argument, please.
So I asked 8 different times, 8 different ways. There is a long history of the Department of Correction and its attorneys in the Public Safety Division of the Office of the Attorney General concealing negative reports about healthcare. Commissioner Semple has, through the state, paid me personally a $22,000 fine for discovery sanctions in the case of William Bennett. And that's a federal case pending in front of Judge Shotney right now. Because of that $22,000 fine, Judge Farish, a magistrate judge, overturned the state's claims to deliberative process privilege, which is a species of work product privilege, and overturned attorney-client privilege documents. And I was able to see these. I was able to see them in 2024. When I got these documents in 2024, I found portions of the CJI report and its investigations from 2017 and 2018 identifying Mr. Camara as one of the worst cases of medical delay. And that was hidden from me throughout Mr. Camara's case. I moved to reopen under Federal Rule 60, and Judge Merriam was like, well, the rule is 12 months. If you don't give me the evidence in 12 months to open judgment, I can't under Rule 60B. And I'm like, well, I didn't get it until 2.5 years after you entered summary judgment, Your Honor. So I don't know what I can do when federal rules tend to benefit people who destroy or conceal evidence. So the negligent concealment claim there is that the state had evidence. I asked for it because I absolutely knew, but I couldn't prove it. I knew in my bones that Patsy's case was so egregious that when Tim Bombard and Kathy Maurer saw it, they would have flagged it. And I asked for it. And Terry O'Neill said, no, it doesn't exist. And so here I am today, sitting here saying this has been a 9-year odyssey or an 8-year odyssey, and we're really trying to bring justice to Mr. Camara.
So what I'm trying to understand, the bridge I'm trying to gap here is I understand that the doctrines of concealment are not standalone claims, but rather are a tolling doctrine for statute of limitations purposes, right?
Yes.
So help me understand how the implication or the invocation of that doctrine as applied to these facts would relate back to make this claim potentially timely.
Well, so had we known, so they gave this document they made the document that we're claiming was negligently concealed in 2017. Okay. In December 2017, Tim Bombard made a spreadsheet that identified Patsy's case as one of the worst. We asked for it throughout litigation in 2018, 2019. Mr. Camara did not die until March of 2019. Had I gotten the document when we asked for it in 2018 and 2019, I could have refiled with the claims commissioner. We could have done something else, or I would have survived summary judgment in front of Judge Merriam. And the concealment hobbled my ability to do a case. And I would note, Alex Taubes is going to testify later on this morning. I think he's like number 33 or something on the list. He is asking the Judiciary Committee to reject SJ 41, which is a claim against, or the claims commissioner ruled against Alex's client. And it's the same issue. It's the Department of Correction hiding evidence. I have another case right now where the Department of Correction is hiding evidence. This is a systematic issue. This is a constant theme that we deal with. As I said, it's a personal trophy of mine that I got a $22,000 check because the former commissioner of the Department of Corrections was found liable for violating federal rules and hiding discovery. And I asked the Judiciary Committee to respect that what we do on a daily basis, lawyers like Alex and I, and help us in our fight against the executive branch. We need people power. We need the legislative branch to stand up to the executive branch. We were close last year. with SB 1543.
Thank you, counsel. Thank you, Mr. Chairman.
Thank you. Representative Fishbaum.
Thank you, Mr. Chairman. I guess the claim of hiding evidence is not just Department of Corrections. We just had the same issue with Pura and, hiding, destroying, all of that stuff. So, rampant through a government that I'm in the minority. But
Representative Fishbein, I have read Judge Buzzick's decision numerous times and say to myself, how does this not apply across the Attorney General's entire practice? And as the Attorney General training his attorneys to respect what Judge Buzzick wrote.
I totally agree. Just want to get a little bit more granular here. When did Patsy know that he had a claim?
We filed in
No,
federal
that
court.
wasn't, no.
When did he know he had a claim?
Yeah.
I would say, without violating attorney-client privilege, they reached out to me sometime in early 2018. And at that time I was doing a couple other claims but they reached out to me in early 2018.
Okay. And when did you eventually file the claim with the claims commissioner?
So I filed, as I told you, I filed a claim in federal court.
No,
we didn't file it until after Judge Merriam rejected my Rule 60B motion, which would have been in 2024.
Okay. So,
or 2025, I'm sorry. She rejected my Rule 60B motion in 2025, and I filed this immediately because I thought we would get redress in the federal court.
got it. So is it your position that the Attorney General's office or Scott Semple in some way prevented you from filing with the claims commissioner?
No.
Okay. So I'm just trying to figure out, because I'll give you an example. When I sued the state of Connecticut regarding face masks in schools successfully, I filed two actions. I filed an administrative appeal because the regulations review procedure was not followed to create the regulation that made face masks in schools, and I filed a lawsuit in state court. I did both. I knew the administrative appeal would be going away, but I had to do that to exhaust my remedy. Why didn't you, and I know hindsight is 2020, but if you had filed the claim with the claims commissioner and gone to federal court in 2018, then you would have had the doctrine of futility that you could have argued before Judge Merriam in federal court. I don't see anything here that precluded you from just filing it and have it sit there.
It was an oversight, and generally, if you recall at that time, Representative Fishbein, the claims commissioner's office was it had a huge backlog. And the aim was to try and push Patsy's case as fast as we could through. And, the claims commissioner, as I said, I have a case where Alan Altarisi died in May of 2018, and the claims commissioner only heard it in 2024, 2025. So we would be in the same position if we had sent it to the claims commissioner in September of 2018.
No, because you wouldn't be sitting here today. But
the claims commissioner could have rejected it. Right. You're correct.
Yeah. So thank you, Mr. Chairman.
Thank you. Question or comment from other members of the committee? Question or comment? Just one more time for clarity. So you are putting forward that the information that was withheld from you affected your claim. How again?
In federal court, we were unable to win because the state withheld evidence, and the federal court said under Rule 60B, well, you waited 2.5 years, and how am I supposed to get evidence that the state is hiding in it and pursue a case? I can't. If the state hides it so effectively that they can best the rules of federal civil procedure, then what am I supposed to do? So as I said, this is in keeping with what we already asked the Judiciary Committee to do last year, and the Judiciary Committee agreed, which was notify everybody on the CJI report that their families were victims of state negligence in medical care, and relax the statute of limitations so everybody in the CJI report could sue. And Patsy's case was contained within parts of the CJI report and the investigations that are part of it. And so we're asking the Judiciary Committee to do what we did last year. And instead of all 45 cases, let's just try and get one through.
And just for my notes, when did you discover that had happened?
The evidence?
The evidence portion of it, yeah.
In February of 24. And we filed the Rule 60 motion in like June of 24, and then Judge Merriam rejected it in October of 24, and we filed this claim with the Claims Commissioner in June of 25, I think. So we tried to move quickly on it.
Okay.
Thank you.
Representative Fishbone.
Mr. Chairman, but just to go back, the claim that you would have this body allow you to pursue is the medical malpractice claim back from 2018.
Yes, Representative Fishbone.
You're not looking to bring an action or authorize us to allow you to bring an action to sue the Attorney General's office for, and I'm sure you could bring a grievance or something like that, or this has nothing to do with the hiding of evidence. This has to do with looking back to 2018, at which time you did not file a claim. You didn't file it until 14 years later.
No,
What?
8 years later.
8 years later. Okay. Well, I thought you said, so if the claim,
2018 to 2025, 2019 to,
Okay.
so it's like 7 or, but we were trying to vindicate Mr. Camara's rights within the federal court, because if you recall, in 2018, the line for the Claims Commissioner was so outrageously long. And what we did was essentially a precursor to 4-160F, which we just filed in the court. And I would ask this body to respect that we just were a couple of years ahead of statute.
I understand. Thank you, Mr. Chairman.
Thank you. Question or comment from other members of the committee? Question or comment? There are none. Thank you for joining us again.
Thank you, Senator.
Let's see. Austin Burskick Johns. Sorry, sorry if I mutilated your name.
Not too bad. Austin Bursick Johns. Good morning, representatives. I'm here on behalf of two claimants, two different matters. First and foremost would be SJ 61, the matter regarding Anastasia Paul. You heard from her family already earlier about her tragic murder. This claim was dismissed at the very first stage, in my opinion, of the process for the Claims Commissioner. The state actually filed a motion. The principal ask in the motion was to stay the proceedings while the criminal case against the perpetrator proceeded. And then, sort of as an add-on, in my opinion, asked the commissioner to dismiss the claim for immunity purposes. And the claimants agreed that a stay should enter because they were at a severe disadvantage in prosecuting the claim and even in responding to the motion to dismiss without having access to any of the state's records regarding the perpetrator, both the murder, but really prior to the murder. And the claimants made that clear that they would agree to a stay of the proceedings. We also made several legal arguments that the immunity claimed by the state was not absolute. There are exceptions to that. And we believe that the claim would support those exceptions, but it's pretty hard to prove that when the state, only one side, has all of the records that would speak to those exceptions to immunity. The state also argued for immunity. The primary argument was with regard to the state's attorneys. They also argued for it with regard to the state police and the DOC, but there really wasn't much of an argument there in their motion. Again, the motion was primarily there asking for a stay. And the Deputy Claims Commissioner sort of put all those things into one bag, all those arguments into one bag, found that it applied to the state's attorneys, and then sort of summarily concluded it applied across the board and granted the motion to dismiss. So it's the claimant's position that that decision was both wrong and premature. If it had to occur, the claimants should have been given the opportunity to explore discovery and argue their case. It was like having two hands tied behind your back to respond to a motion to dismiss when you don't have any discovery to argue for the exceptions.
Okay.
One more comment, Representative, is that the state made factual arguments regarding the timing of the perpetrator's incarceration and cited two records that they said in their motion, we'll disclose these with a protective order, but it sort of went hand in hand with the request for a stay. We don't want to disclose these. There's an ongoing investigation, and they're relying on these records to then support their motion. And the claimants didn't even have access to them before the claim was dismissed.
Yeah. Representative Fishbaum.
Thank you, Mr. Chairman. You mentioned that you're here on two claims?
That's correct.
What's
There
the
is
other one?
second claim. It's not the tragedy that the first one is. It was HJ 42 regarding Evan Clark. That was a high school student who had a sort of standard negligence claim against the state. The claims commissioner ruled in favor of the state, and our appeal and argument is that the claims commissioner got some of those facts wrong, got some of that law wrong, and we should have had an opportunity to proceed to court.
So turning back to the Anastasia case, there are exceptions to qualified immunity, the major one being intentional act. What intentional act was undertaken by the state government so as to provide liability in that case?
We have to make this argument in the dark without access to those records, but based on what we've been able to glean, the state, both circumstantially and directly, we believe, knew of the perpetrator's likelihood, intention to harm Anastasia once he was released from the state's custody. And the state could have kept him, we believe the state could have kept him in custody longer. That was part of the argument in the motion to dismiss. The state addressed that with those factual arguments and citations to the record that we didn't obtain. But even their argument stopped around April, if I remember correctly, and didn't take us through why he was released in July on the $50 bond. So in terms of intentional acts, I think that the immunity doesn't apply when the state's attorney is performing investigative functions or if there was an intentional decision to release him when they could have and should have kept him in custody.
So would you agree, based upon the pattern practice, that even if the gentleman had served, any amount of time, that he was intent on doing severe harm to Anastasia and or killing Anastasia, no matter what the sentence?
I can't answer that directly, but I think that there was certainly evidence to conclude that he was a danger to Anastasia, and the state had multiple opportunities to prevent that violence from occurring.
So did you represent Anastasia in the underlying, we know that there was at least a criminal protective order. Were there restraining orders also through like the family court?
I was not involved at that time. So my understanding is that there were several applications for protective orders, but I can't speak to much more detail than that.
Was a claim or a suit brought against the town?
Yes.
And what's the status of that?
That is pending.
Okay. When was that filed?
That was filed last year.
Okay. When you say pending, have you gotten past a motion to dismiss on qualified immunity?
That argument hasn't been raised yet.
Okay. All right. Thank you, Mr. Chairman.
Thank you. Representative Jacobson.
Thank you, Mr. Chairman, and good afternoon, Council. Was the basis of immunity from the claims commissioner one of qualified immunity or absolute immunity?
If I remember correctly, Representative, the commissioner cited to very little law in the decision. I'm looking at it here. You know, I think there were references, literally very vague references to the state and federal constitutions. And from what I recall, that was really the only legal citation in the decision. So it just sort of bought hook, line, and sinker the immunity argument that was only half-heartedly raised in the motion to dismiss.
Haphazard as it may be, it was nonetheless dispositive. And correct me if I'm wrong, but my recollection is that the distinction between qualified and absolute immunity is one with a significant difference. They're not interchangeable. And to the extent that the basis of the dismissal was one versus the other, I think that'd be important for me as I sit in my role today in trying to reach the conclusion that you're urging me to reach. So to the extent that you can shed any light to me, particularly to the extent that it was that the commissioner's determination was one based on absolute immunity as opposed to qualified, that would be helpful.
I have the decision up in front of me. It is not quite 3 pages. And, you know, there's a reference to the state's argument for prosecutorial immunity, again, which wouldn't even apply to all of the departments that we were bringing claims against. And then the conclusion is, you know, immunity applies. That's really all it is.
Okay, thank you, counsel. Nothing further, Mr. Chairman.
Thank you. Question or comment from other members of the committee? Question or comment? Seeing none, thank you for joining us today.
Thank you, Senator.
Catherine Camera.
I'm not even sure if it's morning or afternoon at this point. I'm sorry, I haven't looked at a clock.
You just pull that mic down a little closer to the one with the red in front of you. Yeah, there you go.
Is that better? All right, Senator Winfield, Representative Stafferstrom, honored members of the Judiciary Committee. I'm here to ask to vote no on Joint House Resolution 35, and in doing so, overturn the Claims Commissioner's ruling against the estate of my late partner, Patrick Camara. Kenny Kraske, his lawyer, was just up here talking about what had happened during the time that Pat was incarcerated in the DOC at Osborne. During that time that he was there, he had arrived and was standing 6'4" and healthy. Within 2 months, he had began mowing the lawns at Osborne, and symptoms seemed to look like allergy symptoms. And quickly they changed to nosebleeds that were lasting 4 and 5 hours, clots the size of his hands. He was going to the infirmary on a daily basis and was being denied any type of testing or any medical care by the defunct UConn review committee at the time for MRIs or anything. So he basically sat for 9 months while a tumor grew behind his mouth and nose the size of a baseball up into his brain, pushing out his eye. He continued to have migraines that would last for weeks at a time, and at this point was no longer coming out of his cell. He was not taken to an ER. He was not granted any type of testing or anything of any kind. And finally, what happened was he became basically cognitively impaired in his cell. He didn't know his name. He didn't know where he was. He was incontinent, and that is when he was taken to UConn and diagnosed with stage 4 nasopharyngeal carcinoma with a tumor-sized baseball. behind his mouth and nose and into his brain. During the time that Pat was still living, which was 16 months from the time of diagnosis, he had many instances of neglect by the DOC. He had brain surgery, and the day he returned to MacDougall, he fell in his cell and hit his head. This was reported, and nothing was done. And 2 days later, he was once again found in his cell and was not making any sense. He thought he was in a college dorm decorating. They took him back to Yukon, and because of the swelling from the fall, he had to have a second brain surgery that would have been unnecessary. It was recommended that Pat get physical therapy due to an unsteady gait and so many falls because of the heavy doses of steroids that he was on. It had broken down the muscle in his body, and it was denied. Physical therapy was denied. He ended up in a wheelchair for the rest of his life at 52 years old, the rest of his life being 16 months.
Thank you. Question or comment from members of the committee? Representative Jacobson.
Thank you, Mr. Chairman. Good afternoon, ma'am. I don't have any questions. I just wanted to express my condolences.
Thank you.
Say I'm sorry for your loss, and I value that you've taken the time to come here and express your position to this committee today. So thank you and my condolences.
Thank you.
Thank you, Representative. And similarly, I think we asked pertinent questions of the attorney on this matter, but want to express to you the condolences for your loss and the importance of you being here today to, in addition to Attorney Kraski, further help the committee to understand what happened here. Thank you.
Thank you.
Daniel Freeze. Daniel Freeze, followed by Yari Ija. Is Yari Ija?
Yes,
You may testify.
thank you. Good afternoon, Senator Winfield, Representative Staffstrom, and distinguished members of the Judiciary Committee. I'm testifying in support of House Joint Resolution number 57. My name is Jadi EJ, and I'm the Interim Executive Director of Youth Continuum, a nonprofit organization based in New Haven that provides housing and services to vulnerable youth who are homeless across Connecticut. I'm here in support, which concerns a claim submitted to the Office of the Claims Commissioner seeking reimbursement for damages caused by a youth placed in our care by the Connecticut Department of Children and Families. On September 24, 2023, a youth placed in one of our residential properties caused extreme water damage throughout the building. The flooding affected multiple floors and required extensive remediation to restore a facility to safe and habitable condition. Photographs and documentation submitted with the claim show the extent of the damage, including water flowing through ceilings, floors, and hallways, and the resulting conditions that required professional restoration and mold remediation. The total damage to the property exceeded $360,000, including water damage, structural repairs, and mold remediation. Insurance covered much of the repair costs, but Youth Continuum was left responsible for $50,000 in uncovered expenses, primarily related to the mold remediation. These repairs were essential to ensuring the property met health and safety standards and could continue serving the young people who depended on us for stable housing and support. As mentioned, the youth involved was under the custody and provision of the Department of Children and Families. Youth Continuum accepted the placement in good faith as a state licensed provider working in partnership with DCF to serve vulnerable youth. The damage that occurred was not the result of negligence by our organization, but rather the actions of a youth under state custody. Organizations like ours partner with the state of Connecticut to provide critical services, including housing, behavioral health support, and stabilization for young people experiencing homelessness. When nonprofit providers must absorb substantial costs for incidents beyond their control, it places additional strains on organizations already operating with limited resources and can divert funding away from services to serve for the youth we serve. Reimbursing this claim would help ensure that organizations like ours can continue providing these essential services without jeopardizing our financial stability. For these reasons, we respectfully ask that the Judiciary Committee support HJ 57 and authorize payment of this claim. Doing so will recognize the financial harm experienced by Youth Continuum and reinforce the partnership between State of Connecticut and nonprofit providers. Thank you for your time and consideration.
Thank you. Question or comment from members of the committee? Question or comment from members of the committee? There are none. Thank you very much for joining us today.
Thank you.
Granville Watson. Granville Watson. Okay, I see you on there. We're gonna check to see if Dr. Emily Knox is here while you figure that out. Dr. Knox, you come up, and Mr. Watson, if you can get ready, I'll call you after.
Can you hear me? Can you hear me?
Yes, we can hear you. I'm sorry, Dr. Knox. We'll go right back to you. Yes, we can hear you. You may testify.
Okay. Good afternoon, chairpersons and member of the Judiciary Committee. My name is Granville Watson. I respectfully ask that you vacate the Claims Commissioner's dismissal of my wrongful incarceration claim. I was wrongfully imprisoned twice in Connecticut, first in 1991 for possession of a handgun, and again in 1997 for a probation violation, even though I was not serving any term of probation. In 2023, the United States Court of Appeals for the Second Circuit acknowledged both convictions were wrongful. At the time of the 1991 arrest, I was working, attending college, and I had been accepted into the United States military. I was scheduled to begin basic training until weeks before I was supposed to report. I was arrested for a series of robberies and a firearm charge, and ultimately sentenced to 5 years in prison. That wrongful arrest destroyed my chance to serve my country and the future that I had worked hard to build. Both convictions were handled improperly, and later in 2009, instead of vacating the conviction, state officials issued a pardon. To vacate the sentence would have admitted wrongdoing. A pardon implies forgiveness. It was used to avoid acknowledging misconduct. The Pardon Board and state officials produced documents in 2009 because no legitimate police reports existed for the alleged probation violation. That creation of documents, years after the events, constitutes fraudulent concealment. As documented in court records, these facts have never been disputed. For more than 20 years, I've tried to obtain records. I was repeatedly told that records for any arrest did not exist. I managed to acquire the necessary documents I needed in 2020. The delay in filing my claim was entirely due to state concealment, not lack of diligence. I followed the direction of attorneys. I contacted the state's attorney's office numerous times. I filed lawsuits, and I repeatedly asked that the records I needed to prove the truth. Connecticut's fraudulent concealment statute makes clear that a party should not benefit from concealing wrongdoing. A statute of limitations cannot protect a party that hides the truth. The 1997 wrongful conviction stemmed from the police trying to associate me with the man's death. To link someone to this type of crime, the police should have taken extra precautions, not fewer. My life had been destroyed by these wrongful incarcerations and accusations. I have spent decades pursuing justice, and I ask that my claim be allowed to proceed and be judged on its merits. Thank you for your time and consideration.
Thank you. Question or comment, Representative Jacobson.
Thank you, Mr. Chairman. Good afternoon, sir. Thank you for joining us today.
You're welcome.
So I'm reading the decision from the Second Circuit Court.
Yeah.
And there's a piece in here which talks about how that the claimant failed to show that he's been diligently pursuing his rights, given that he waited over 10 years after he was pardoned to sue on his claim. That was part of the decision in your underlying case, right?
Yes.
All right. So help me understand, as I sit in the position that I sit now, as to why that decision should not apply here.
Because my sentence should have been vacated. It was never vacated. I received a pardon. This pardon was only given to cover up the fact that crimes occurred in how I was sentenced. If my sentence would have been vacated, then the state would have admitted at that time that my sentence was improper. And I still haven't been vacated to this day. So the way it should work is the sentence should be vacated and it should never have been pardoned.
You also made reference during your presentation to fraudulent concealment.
Yes.
Can you elaborate on that for me, please?
Yes, there was a fraudulent document that was created that says I violated probation. I was not serving any term of probation. So when I went to the Board of Pardons and Parole in 2009, they told me that I was not serving any term of probation. So they worked together with the Board of Pardons and Paroles. They worked together with the prosecutor, a woman named Cynthia Bayer. They all worked together to create documents that stated I was serving a term of probation and that I violated probation. I was not serving any term of probation. I did not violate anything. There was no crime and no violation of anything. The state worked together to create documents, fraudulent documents, to cover up the fact that I went to prison for no reason at all. So that is fraudulent concealment. And they did that in 2009. I was released from prison in 2001. And they did this only so that I could be given a pardon instead of vacating the sentence, because if they would have vacated the sentence, then that would have admitted there was state wrongdoing, and they wanted to cover up that fact.
Did you have possession or access to that document in or about 2009?
I did not, no.
As part of your claim to the Claims Commission, did you present any type of argument relative to the doctrine of fraudulent concealment to him when you made that claim?
No, I didn't have all the documents that I have at the time. I have more documents now. I've been acquiring documents over the years, and I have a lot of documents that have been created that I just didn't have at the time. So I don't believe I mentioned fraudulent concealment at that. I don't know if I mentioned fraudulent concealment at the time, but
sorry.
Mhm.
I didn't mean to interrupt you. Please proceed. I'm sorry.
No, but there was fraudulent concealment. Like I said, state actors worked together to cover it up, but I just received all of the documents around 2020, and I received some after. And I received some maybe in 2019. But when I first filed, I did not have all of the documents at the time. But while the case was ongoing, then I received more documents.
So is it your claim, sir, that after the Claims Commissioner dismissed your claim, you obtained documents that you believe would lend to an argument on your end that the fraudulent concealment doctrine should be implicated in this in your case?
Yes.
And what documents are those that you obtained subsequent to the decision that we're considering today?
Well, there were documents again about the violation of probation, and also just an admission by the Manchester Police Department. They were contacted by the state's attorney, and they said they were going to compensate me because of the fraud. And they contacted me with their attorney, and they started to compensate me. This was, I believe, in 2020, or no, this is, I believe, in 2021 when they contacted me. So they admitted at that time that they knew there was fraud, and that there was a cover-up.
Okay, thank you, sir. Thank you, Mr. Chairman.
Thank you, Representative. Comment or question from other members of the committee? Comment or question from other members of the committee? There are none. Thank you very much for joining us and providing us with your testimony. Let's see. Sorry about the mess up before, but Dr. Knox, is your opportunity.
Right, thank you. Good afternoon, Senator Winfield, Representative Stafstrom, Senator Kissel, Representative Fishbein, and esteemed members of the Judiciary Committee. My name is Dr. Emily Knox. I'm the Research and Policy Director at Connecticut Voices for Children, a research and advocacy organization working to ensure that one day Connecticut will be a thriving and equitable state where all children reach their full potential. CT Voices submits testimony in support of SB 343, an act concerning fees charged for criminal history record checks. At its core, this bill makes a relatively small change in statute that could have meaningful impact in people's lives. SB 343 addresses a financial barrier within the pardon process by requiring the Department of Emergency Services and Public Protection to waive the $75 criminal history record search fee, along with certain related processing and pre-registration fees for individuals requesting their criminal history for the purpose of applying for a pardon. In practical terms, this bill recognizes a simple reality. If we want the pardon process to function as an opportunity for second chances, it has to be accessible to the people who need it most. For individuals living with a criminal record, the ability to obtain a pardon can be life-changing. It can open doors to employment, housing, and professional licensing, as well as stability overall. But many people seeking to move forward, even relatively modest fees, can present a real obstacle. Justice-involved individuals face disproportionately high rates of unemployment and financial instability. Research has found that formerly incarcerated individuals experience an unemployment rate of about 27%, roughly 5 times the rate of the general population. At the same time, having a criminal record is estimated to reduce annual earnings by about 16 to 26%. In that context, the cost of obtaining the documentation required to pursue a pardon can become a barrier that prevents people from even beginning the process. The evidence also shows that record clearance policies work. One study found that individuals who had their records cleared experienced a wage increase of more than 20% within 1 year. Another analysis found that over 90% of individuals whose records were sealed remained crime-free and gained greater access to stable employment. Employment is one of the most reliable predictors of successful reintegration and one of the strongest protections against recidivism. Policies that remove barriers to employment ultimately strengthen public safety and economic stability for communities. From a policy perspective, SB 343 represents a targeted and cost-effective step in that direction. By removing unnecessary financial barriers within the pardon process, the state can support economic mobility, improve employment outcomes, and reduce the long-term costs associated with unemployment and recidivism. This is a small change in statute, but it reflects an important principle that second chances shouldn't depend on somebody's ability to pay. So for these reasons, Connecticut Voices for Children respectfully urges the committee to support SB 343. Thank you so much for your time, and I'm happy to take any questions.
Thank you. Representative Fishbein.
Thank you, Mr. Chairman. Very good on the timing. I do share your support. Have you been advocating in this space for a while?
I've been in the criminal legal system space for several years. I've been in Connecticut since 2024.
No, I just had, because I could have sworn we had the same bill out of public safety, like last session or the session before. Are you aware of that?
I was able to, yes, there was at least in 2025 a similar, if not identical bill that was passed out of public safety, but I believe stalled in the Senate.
Yeah, especially with the clean slate debacle that we've faced in this state, I get calls from people, I want to apply for a pistol permit, is this a statutory disqualifier? Is it, I just had one a couple days ago. A guy got convicted years ago, it was 22 years ago of, I forgot what it was. It was one of the misdemeanor disqualifiers. And he asked me, can I apply? And I said, well, clean slate might apply to that, but they have no idea what they're doing with the system. I know there was recently a press conference, but there are people out there that have no idea what's been erased, what hasn't been erased. I don't think anybody should be charged a fee. Quite frankly, pardon, you apply to exercise a constitutional right, shouldn't be charged a fee to get your own records. So I'm certainly in favor of what's before us. And agree with your comments about people getting employed, part of being a productive member of society, and this is one of the barriers. So thank you for your advocacy. Thank you, Mr. Chairman.
Further questions or comments from the committee? Yes, Representative Capro.
Thank you, Mr. Chair. Can you just expound a little bit on the unemployment, the facts of those folks with a record, just what some of the challenges are, a little bit more in detail there?
Sure. For folks with a criminal record or with experience in the criminal legal system, there are a number of barriers to creating, to accessing and being able to attain reliable, stable employment. One of those that's more of a niche is in regards to what licenses they're able to attain, but also we know that there is a tremendous amount of discrimination in the space, even once for when these folks apply for jobs and roles that they are otherwise eligible and well suited for, that there is a role that kind of fundamental inequality plays. And this eliminating these fines and fees would just eliminate one more additional barrier in these folks being able to attain a pardon, move through that process, and move to a place of greater long-term financial stability and broader options writ large.
And did you say there was 5 times the rate?
Yes,
Is that
national
approximately?
study showed that folks with criminal records had an average unemployment of 27%, which is around about 5 times the national average.
All right.
Yeah, thank you so much.
Thank you, Mr. Chair.
Representative Fishbein?
Yeah, just briefly, along those lines, when I first became a state representative up here, I met a young lady. Well, actually, she was middle-aged. She was from Bridgeport, and she had been convicted of some very serious drug offenses years ago. She had a couple felonies on her record, and she had changed her life. She had turned her life around. She was going to be a productive member of society, and she went to school to learn to be a licensed clinical social worker. She graduated at the top of her class. She went to go apply for a license to practice in that space. We were told she couldn't apply. She couldn't get a license because she had the felonies on her record. And I didn't believe her. No, that can't be the law. And I was on the labor committee those days. And about 2 weeks later, she came before the labor committee and she testified. And she had found the law. And she showed me that that was there. And I was happy. I actually got her a pardon. And, now she's practicing in that space. So I'm certainly very sympathetic to what's before us and the opportunities for people. So thank you, Mr. Chairman.
Further questions or comments? Seeing none, thanks for being with us.
Thank you so much.
Charles Ryan? Charles Ryan with us?
Good afternoon, everyone.
Good afternoon. Go ahead, sir.
Sorry, my apologies. My name is Charles Ryan. I'm an attorney out of Watertown, Connecticut. I represent condominium associations and common interest communities throughout the state. And today I'm here on behalf of CAI and our Connecticut chapter of Community Association Institute. There are 2 bills in front of you today, 5433 and 5437, that we are opposed to. I do know I will be short on time, and I'm going to start with 5437. This is a bill that seeks to change how special assessments are adopted, how budgets are adopted. I do need to oppose this bill. I completely respect and understand the viewpoints as to why this would be positive, but in fact, it will be detrimental to our communities. And I do also want to point out that the current law follows the uniform laws. Connecticut's Common Interest Ownership Act is governed after the Uniform Common Interest Ownership Act, which the Uniform Laws Commission did adopt the current budget and special assessment approval systems. June 24th, 2001 at 1:30 in the morning, 98 people lost their lives in Surfside collapse down in Florida. The victims, they ranged from 98 years old down to just 1 year old. I've been there. I visited, I read the memorials, and I've seen what happened. And the reason I bring it up is that one of the major issues there was deferred maintenance. They couldn't, when the buildings collapsed, the board had evidence of issues. They had tried to pass special assessments, and the owners, they rejected them. And we saw what can happen. There's a lot of laws that have been coming out of that. This is an extreme example, and it's sad, but it's real and it did happen. The current procedure allows for associations to raise capital, and they need to raise capital. There's a lot of notice that goes out to the community, but ultimately, owner apathy is our biggest problem. If owners are not happy, they show up, but if they are content, they don't show up. And what's happening is that we can't, even though we send lots of notices out to the owners, they have chances to reject special assessments and budgets. They don't. Currently, the law provides that they are approved unless rejected by a majority of the votes in the community. And this is important. That's what allows us to pass these things. The associations, these condo associations, and whatnot, they are consumers in the marketplace. We are subject to inflation. We have cost overruns. We run very tight budgets as it is, and unfortunately, when things run shy, we need to be able to access funds, and that can be anything from paying an insurance deductible, which is 25,000 on the average these days, whereas it was 1,000 when I started practicing law. It could be paying for trash, electricity, and go down the list. But our board members are also owners too, so they are subject to these budgets and special assessments. They pay them too. And the deferred maintenance is one example. Even settling litigation, sometimes we need assessments and whatnot. I knew that I would run extremely short on time. I didn't even talk about the other bill and whatnot, or the other sections to this bill. But I welcome any questions whatsoever. And again, I am here on behalf of a nonprofit, CAI, in our Connecticut chapter, and we have submitted written testimony as well on this. Please, if there's any questions, I'm happy to answer them.
Thank you. Questions or comments from the committee, Representative Fishman?
Thank you, Mr. Chairman. Sir, with regard to 5437, there's a lot of towns in Connecticut that have very similar provisions in their charters. And I don't see the parade of horribles happening in those towns in Connecticut. Why? I used to live in a condo. I would have wanted to have these rights. In fact, I think my condo, the bylaws had very similar rights. So I just wanted to give you another opportunity. Why, instead of a very close, a board decision, and then putting it to the people to challenge the board, why that would be a good process here?
The process here is really focused on the ability to raise capital. And that's what happens. And a lot of times our associations run extremely, extremely lean budgets as it is. There's no fluff in there. Our reserves were already underfunded. I would say 95% of my clients, if not more, are underfunded in their reserves, which means that when they need money in the future, they'll need loans and things like that, or special assessments. It's tough out there. The economy is tough, and it's hard. A lot of times people are voting with their wallets, even though they know something needs to be done. And this can also create safety issues. For example, we have fire marshals that come in and tell us that we need to do code upgrades, put fire doors on common hallways, and my clients just don't have the money. And I say my clients, it's the state, all of our communities. And so not being able to raise that capital is a problem, and it can be detrimental. Even if we have something, slip and fall in a parking lot, we want to fix it. We have to borrow money from one place to pay for it over here, take it out of the pool budget or take it out of a trash dumpster day. I can go down the list of things that we could do, but when we don't have the funds and we can't raise it, it can be a big issue. And that Surfside Miami case is real. I mean, that is deferred maintenance where they couldn't get the work done, and that's had impacts across the nation from a lending perspective. So it's something where the legislature has already identified that the board members need to serve at the will of the people, and it's extremely easy to remove the board, extremely easy. And they should do so if they're not serving their people correctly, right? That's okay. But the unit owner apathy and having to have such a high vote or even have this additional vote of the owners to come forward and raise the capital, it's a lot of hurdles. And I think we're going to see associations basically not be able to pay their bills. We have long-term contracts that increase, such as snow and landscaping. A lot of associations don't budget for snow removal, which many have needed this year. And if we can't have these things done, if we can't raise the capital, we could find ourselves looking at bankruptcy, litigation, receivership, all things that are bad and going to cost our communities more money, which means the homeowners.
No, I'm glad you brought up the example of the snow removal, because municipalities deal with that too. You know, you budget $100,000 for snow removal, and you know, you have a year with a lot of snow, and yeah, you didn't budget for it, so you gotta transfer money. I will tell you, in my experience, it's not easy to remove board members. A lot of times people don't want to serve on the board. It's just like getting people to run for office. You know, people want to complain, but they don't want to run for office. Very similar with boards. And right now, in my experience, you know, some of these boards don't even require that board members live or are a resident at the condo association. We don't have a statute that requires that, and I think we should. But you said that you wanted to testify about another bill that's before us, and I don't think you had the opportunity. What other bill was that?
That was 5433, an act concerning limitations on the provisions of gifts to board members of the association. But I will keep this very short, and I appreciate that opportunity. At line, I'll start at line 141 and 132 of the bill. It uses the term contracting services. It says no person providing contracting services on behalf of the association may directly or indirectly provide any item of value in excess of $50 to the board members. I think first we do oppose the bill because we have laws in place that address these already. But the big issue here is I don't know what contracting services means. I don't know if that's meant for plumbers and people providing services to the community, landscaping services, or if that covers me as the attorney. I just have no clue what the contracting services means. And again, we have laws in place, duties of care and loyalty, conflicts of interest that apply. So I don't think that this is necessary, but if it is going to go forward, I think we need to narrowly define contracting services in this. We already have a provision that says property managers cannot campaign on behalf of owners. I think that's great. I have no problem with anyone providing services not being able to campaign either. That's not an issue. The real issue I have, and it goes to a great point that you just made, are sections L and M. They're new. These two sections go on to say that the elections, and I want to actually specifically get into a little bit. This says L and M, these provisions require those involved in elections, as well as those providing contracting services to the association, to be held to the same degree and care of loyalty to the association and owners when conducting the election as that of a trustee of a governmental body or municipal official who is responsible for the conduct of a state or municipal election. That's a very high standard, and the comment that was just made is that it's hard to find people to run for the board. This is going to make it very hard to find people to run for the board. But a lot of times, they're all volunteers. We have property managers that assist, attorneys that assist, but I'll be honest, I don't even know what this standard is. And to put trustee liability on me and to put my family at risk because someone wants to sue me personally because they're upset with an election result, I take an issue with that. And I probably will not be able to assist my clients in these elections. Some of them are contested. There's laws that require us to save the ballots, save the proxies. There's records that are available to the owners. There's grievances against attorneys if they do something. Managers are licensed by DCP. There's lots of avenues, but to put such a high level on someone, and respectfully, I don't even know what those requirements are myself. I think we're gonna have a chilling effect, and I have a real concern over this, getting people to be able to serve on the board, assist with elections, and things like that. I know I probably went way over how long you had asked me to go with that question, so I apologize. I just am very passionate about this one.
No, I very much appreciate the exchange and you informing the committee as to your concerns. With regard to the first one, line 133, would you feel more comfortable if it said no person providing contracting services to an association made directly? So that would require a contract, some writing, and it ties up the relationship. Because I do understand on behalf of could be various things. Does that avail your concern?
Not completely, because I don't know what contracting services means. So just by way of example, is it the snowplow contractor? It probably is that person. Is it me, the attorney? Right? I think that'd be very foolish. But is this intended to be the attorney handling? Where does this line, and what are we trying to achieve? I think that's really where my concerns come in. for example, if you have, I would rather see a disclosure or some sort of, because we have laws in place, but I'd rather see something that says anyone providing services to the association, if there is something done, you have to disclose it. There's many board members that have properties elsewhere, and they might want to hire the same contractor to do work over there, right? And that contractor doesn't. But what we really have, and what I think comes up more, is we have homeowners who are contractors and that do provide services to their communities and do so at a discounted rate because it helps their communities. And they know they have a vested interest. And this goes on to say that anyone contracting services would not be able to essentially campaign for or against someone. I think that's a problem. If I'm a homeowner and I am providing services to the community, I should not lose my right to campaign for or against someone for the board. I just think it goes a little bit farther. I'd rather see disclaimers, a requirement that the association receive a written notice, basically the way conflicts of interest are handled naturally. I think that would help, and we wouldn't lose out on certain services and things like that. I just selfishly, I can see myself handling an eviction for someone and what someone challenges me saying I didn't charge enough for the eviction. It just seems like we're opening up the door to more litigation, more issues where disclaimers might be a better approach.
Thank you. Thank you, Mr. Chairman.
Further questions or comments? Further questions or comments? If not, thanks for being with us.
I appreciate everyone's time. Thank you very much.
Crystal Lupo. Crystal Lupo. Robert Levin.
Members of the committee and chair, thank you for the opportunity to speak. I'm here on a matter that you heard Attorney Sterling speak on earlier this morning, which is Senate Joint Resolution 48 on behalf of the Hess family. I've heard a good deal in previous testimony regarding the intent of 4160 and how the commission is to conduct its inquiries. I've also heard recently, past several months, from a lot of lawyers that they don't feel that that's being carried out. Certainly I don't. There's no question if you can establish negligence, damage, duty, you got a pretty decent case to be heard, and the fact finder decides from the facts and awards damages if appropriate. What we had in this case was an extended evidentiary hearing with selective evidence. There was an example of a redacted document, and the commissioner wanted to take the state's counsel's word for it that there was nothing in the redacted material that applied to the case. Now, that may well be true, but I think there was a reference earlier today to Pura and to the Department of Correction. I mean, the reality is people lie. I'm not saying anyone in this case lied, but I'm saying it's a possibility, and I thought it was inappropriate that Commissioner Shea couldn't have an in-camera review where he took a look at the page. Simple. Eliminates any question, but he didn't. It's just one example. The case really turns on September 29th to 30th. On the evening of the 29th, the child was returned home to the foster parent's home. All night, the child was going downhill. In the morning, the child was critical, unbeknownst to the foster mother. She spoke to the aunt, she spoke to the caseworker. What she didn't do, which probably would have meant we would never have seen each other today, is dial 911. If you call your pharmacy, they tell you if it's an emergency, dial 911. Don't call your aunt. This case should be reversed. This family should get its day in court. And that's my testimony.
Questions or comments? Seeing none, thanks for being with us. Antonio Bennings? There wasn't any questions.
Okay, thank you for your time.
Antonio Bennings? Antonio Bennings? One last time, Antonio Bennings? Bennings, you online there?
I'm Antonio Bennings. I've been a patient at Whitefield Hospital for 22 years. And I, Antonio Bennings, am a previous 7-year state officer and a military 82nd Airborne paratrooper and a former federal employee. Addison Antonio Bennings filed a lawsuit suing Office of the Chief State's Attorney for wrongful prosecution in the amount of $250 billion against the state of Connecticut. Also, the FBI Federal Bureau of Investigation. We are willing to settle, asked Robert Shea. We were denied the right to testify in person at the hearing today. Addison Antonio Bennings are pro se. Lord Thurston is the state attorney, not our attorney. We're requesting that the claim be reopened and scheduled conference to be scheduled. We request that both claimants be immediately discharged. I have filed this notice for the purpose of notifying the General Assembly that Antonio Bennings and Addison Bennings filed lawsuits within a 1-year requirement. First filed between the dates of October 2003 and April 2004 at the federal courthouse in New Haven, Connecticut, Hartford, Connecticut, Bridgeport, Connecticut, New York, and Washington, D.C. Both Antonio and Addison Bennings have had been very chip device placed in our bodies by the FBI. I filed for my claim on 6/11/2023. The reason for the delay is that I was traumatized due to being victimized by the FBI. I submit a copy of the emergency injunction to this panel. On or about 6/2003, Addison Bennings met with FBI agent Martin McBride at FBI headquarters located in Orange Street in New Haven, Connecticut. Agent McBride asked Addison if he had any siblings. Addison told Agent McBride that his brother Antonio, me, I lived in Chicago, Illinois. And Antonio, visited the VA in Chicago, the West Side VA, where 2 FBI nurses implanted a very chip in my arm. I began hearing voices and telling me to kill and harm people. In March of 2004, less than 30 days prior to the index offense, Satan showed up and I began having thoughts of Satan to control me and my brother Addison. The FBI and Satan caused us to take the life of Vonda Bennings. That's all I have.
Thank you, sir. Questions or comments from the committee? Seeing none, we appreciate you being with us.
Okay, thank you.
Bruce Wood?
Good afternoon, Chairman, members of the committee. Should I start? Okay. I think this is about time. I've given you a written outline of the claim we made. We were architects working on the new Litchfield Judicial Center, and our period of work was extended. My communicator was the state project manager. He was the only one that I communicated with. So I claim not knowing your process with the Claims Commission and all of those things. Our work was extended, and he said, we'll deal with this at the end of the project. At the end of the project, really nothing happened. It eventually went to the SPRB, which I also didn't understand, for which I apologize, where ultimately there were objections raised to it and it languished. And I was told over many years that it is always about to be solved. And this is from the project manager. And probably my failing was believing him and waiting for it to be solved. Ultimately, it came before the SPRB, who approved it. And then when it came to the AG, they were required, I believe I understand, they were required to refuse it because it was late. My point has been, at any time we were asked for information, we gave it within days. All of the delays that occurred happened because of this kind of nebulous process that we weren't allowed to come to the SPRB until maybe a year and some ago. And then when we got very little in writing from them, when they finally, it was approved, I thought it would be resolved. And then I found out verbally that it had been denied by the AG. So we finally filed a claim, which is was not our goal in the beginning. Our goal was just to sort of resolve it as it was. I understand that because it was late, because it was after the completion of the work, is why it was delayed. And I'm requesting that, I understand that the legislature can still approve payment. I think if I understand that correctly from Bob Shea. So I'm asking.
Which claim number are you here?
It's, oh, sorry, 046. It's claim number 27513, Coleman McKinley Wood Architects.
What's the resolution number on our agenda today? Do you know? I see it, SJ 46.
46.
Okay. And in your case, there was a recommended payment?
Yes.
And how much was the recommended payment?
$106,000.
Okay, and your contention is that's too low?
No, that's enough.
Oh.
I'd like to, what our original claim was, I've been listening to long stories all day. I'll try to keep this short for you, but our original claim was larger. The state architect said, the budget has this much in it. Will you take it? And I said, yes, because I want closure. After all these years, quite a bit less. It's about 2/3 of it. I thought that was the end of it, and then it was denied. As he mentioned, there was a struggle between the courts and the DAS, which is none of my concern, but it ended up being part of what confounded it in the SPRB.
All right, let me just
I'll stop there. Sorry.
Yeah, let me make sure. So, because I don't have the note from our intern here. So, so SJ 46 is what you're here on.
Yes.
In that case, the claims commissioner has recommended the payment to your firm of $106,000.
That's correct.
Okay. And you're here today to ask us to approve that payment?
He said it would help to come and give testimony.
Okay.
Because it has to be approved by the legislature.
It does. I just wanted to make sure because
I'm just
the way the first few minutes there, it sounded like you were here, saying the claims commissioner got it wrong.
He's been extremely helpful. Absolutely extremely helpful.
Okay.
All right. Yeah, I just came to speak in favor and whatever. Answer any questions.
All right. Are there any questions on this? If not, thanks for staying with us.
Thank you very much.
Nikos Mahamadi.
Hi, good afternoon to the commission. I'm speaking in relation to HJ number 47. So on October 1st, 2020, there was the release of, or Attorney General Tong released a statement on the settlement agreement, which had occurred. At the time, I was only 13, actually. And as a young kid, I obviously very clearly saw my father in distress, saw people around him in distress, not really understanding why the language had been written in the way in which it had been written. As a young kid, you know that there's really not much you can do, but I guess I had enough motivation to send an email to the Office of the Attorney General. The response that I got from it was, or that I got from the office, was a shoddily constructed email that essentially told me that my father had to speak to his counsel and that they wouldn't really speak to me. The damage that has come from this press release, to me, is very clear. It continues to this day. This is something that I see whenever I'm at the office. It's something that I see just in terms of the doctors that, for example, are coming in, want to be interviewed, and then all of a sudden cancel, in terms of the bad reputation that this press release continues to bring every single day to patients, potential patients, even to people that I know, friends, acquaintances, just a brief introduction of the practice. It is unfortunately caused this bad reputation. It's something that I have grown up with, and it's very clear to me, for the past couple of years that this is something that every single day it is republished on the website continues to cause damage. Thank you.
Maybe I misheard you at the beginning, but which claim number were you hearing?
This is HJ number 47.
Questions or comments on this one? All right, thanks for being.
Thank you.
Canara Potiet? Canara Potiet? Canara, can you hear us? All right. How about Ronald Barba?
Okay, is this is about my claim against the claims commissioner.
Okay, go ahead, ma'am.
With the claims commissioner against the HRO.
Go ahead, ma'am. You can go.
Can you? I'm not sure if I can be heard.
We can hear you, ma'am. Go ahead. We can hear you. Go ahead. All right, we're gonna try to work on that. Ms. Potiet, can you hear us? All right, we're gonna move on to Ronald Barba then.
Thank you, Mr. Chair. I'm here today to testify in strong opposition to raise bill number 5437 and if there's time, 5433. My colleague Chaz Ryan, I think did an excellent job of describing some of the problems that are created by 5437, and I want to sort of address those. I'm here today just to allow the committee to understand that the passage of budgets is not done in secret. It is subject of a board meeting, which is open to the entire ownership and to which they can comment. It is a process of over a month or two of discussions. The board votes an open meeting. That vote is also open to owners. They receive notice of that budget and a summary of how they got to the numbers they got.
I am a plaintiff in this case, so I don't know what you're talking about. I'm a plaintiff. The claims commissioner had my case, and he did not take into account. I thought it was my time to speak.
We're gonna come back to you. We couldn't hear your audio. We'll come right back to you next. We're gonna let Mr. Barber go first.
And while the bill's intentions to enhance the transparency and unit owner involvement are admirable, the amendments really, I think, could not be more dangerous and more destructive to the financial viability of common interest communities. Because what you are asking these volunteer boards to do is to go out and politic in favor of a budget, which is extremely difficult to do. It's hard enough to staff these full boards, and now you're asking them each year to go out there and gain approval from people that have very individual interests. And I get the timing of this. The economics are horrible. Everyone's struggling, but boards don't make any money. These are communities that generate their own operating income, and without that, they will not be able to pay their bills, which are increasing sometimes exponentially in terms of insurance and other costs. So the original wording of the statute allows for a tremendous amount of oversight And believe me, when a board passes a budget that is so uniquely out of line from its previous ones, you'll get that kind of attention at these meetings. I've been there. And but for the pitchforks and torches, the board gets the message. And very often when those budgets are unacceptable, the board is left to go back. It's rejected by a majority of the owners because there's enough groundswell of support against it that they go back and have to rework the numbers. But to put on them that obligation every year is extremely difficult. So I can tell you right now that what you will do is, I think, leave these communities underfunded. I think Mr. Ryan was exactly right, and I don't think it's hyperbole to bring up Surfside. They didn't raise the money because they didn't want to pay the money, and that board was left completely powerless to do anything about it. And that's what you're going to do here, because each person is going to look at their own personal finances. I'm happy to continue with this because it is that important.
You got cut off. We'll give you another 30 seconds.
Thank you. So there are states that, if you look at the other states that do this, Florida, Texas, California, some have special assessment statutes such as we do, where it doesn't require a vote at all. That we have a 15% margin for the annual budget. Florida and the like have, I think, California, Texas, have 5%. So we do have the ability to raise funds. Now, this passage of this particular bill will do away with that. So now, in the event of an emergency, in the event of unexpected costs, where associations are almost invariably underfunded in their reserves, you're going to put these people in tremendous harm. I think health and safety harm.
Is there questions from the committee? Questions from the committee on this? If not, appreciate you being with us.
Thank you. And just a word on the other 5433.
This is the one about the
gifts and whatnot. It's really trying to solve a problem that doesn't exist. All right. You have small communities that are neighborhoods. They give each other gifts. I've been to plenty of board meetings where the board will pass out bottles of wine to people that have distinguished themselves during the year, or they have relationships that are such that you're going to create almost a litigious atmosphere if somebody gets a gift they think is inappropriate. How do you, it's just amazing to me. Attorney Ryan spoke to
They put similar rules in place for the legislature.
Yeah, but the thing is that
right,
these communities are always looking for a fight.
Thanks for being with us.
Thank you.
All right. Eileen Meskel.
Okay, I can speak now. I'm sorry about this.
There you go. Okay, yep. Ms. Patel,
Well, this
go
case
ahead.
is about egregious dismissals, collusion, retaliation for over 15 years with the Claims Commission, with the CHRO, Commission on Human Rights and Opportunities, and the people they work with. I have all of my evidence. I have cases I had to file in federal housing because the CHRO have delayed, ignored me, and dismissed multiple complaints. I have documents to prove I have over 15 complaints, I'll say. 8 of those were with Hartford Housing Authority back to back to back to back. Mind you,
All right.
against Hartford Housing Authority and the people they work with, CHRO would take and dismiss my complaint. She would be very aggressive with me, threaten me. She would not enforce settlement contracts. And for over the 15 years, she's always been the one to take and keep my complaints, knowing she was a supervisor at the time. The claims commissioner told me to prove that I requested for her to not only file complaints, but complained on them for years with the legislative constituents. They have emails. I have email documentation that I've been complaining on CHRO and HUD. They've been colluding with each other. And during my February 5th hearing with the claims commissioner's office, he requested evidence that Miss Diane Carter lied about, did not tell the truth. She lied about me requesting to file a complaint. And when I told him I recorded the conversation, me requesting for her to file the complaint multiple times, I proved it to him. He said, okay, at the end of the the February 5th hearing for me to prove that I requested that. And I sent him a video hearing. He said, even though I proved and I showed all of my claims were valid, even claims that he did not address. He only addressed the fact that he wasn't holding her liable for filing a complaint against my Section 8 worker, which was very maliciously and willfully, and it caused me so much harm. I could not sleep. I was homeless for multiple times over a year, multiple times each time I was homeless. Couldn't administer my Section 8 voucher. They allow Hartford Housing Authority to breach each contract they ever mediated. CHRO allows Hartford Housing Authority to breach each contract, which over 7-8 complaints with Hartford Housing Authority. And 2 of them, they only found findings. The other ones I had to take to federal court, housing court, and I won. I won over, after multiple times of them breaching each contract. CHRO never enforced them. What they did was constantly let Diane Carter pretend to be a caring person towards me, pretend to act like she cared, and violate my rights, dismiss my complaints, threaten me, tell me to get out of apartments, say she, it's just so much that I've been through, so much that I went through, and for the Claims Commissioner's office to tell me to prove these cases, knowing that I filed timely, none of my complaints were labeled as frivolous. They all had evidence backed by them over years, decades of years of evidence I submitted to the Claims Commissioner's office. He did not address any of them. Right now, I have another complaint against CHRO with the Claims Commissioner's office, and they're trying to claim jurisdiction and sovereign immunity right now, knowing that they did not claim it the first case, but now they're trying to claim it this time. So there's a lot that's going on.
Thank you. Your time has elapsed. Are there questions from the committee? Seeing none, thanks for waiting for us. All right, we are going to skip Deputy Attorney General Meskel and let her go at the end to address any questions the committee has. Richard Wechter.
Hi, can you hear me?
Yep, go ahead, sir.
Thank you. My name is Richard Wechter. I'm a certified manager of community associations and a senior vice president at Westford Real Estate Management, a community association management company in Connecticut. I am also a member of the Connecticut chapter of CAI, and I am going to add comments just briefly to those that were heard from Charles Ryan and Ron Barber. With respect to both bills that we're opposing, raise bills numbers 5437 and 5433. With respect to 5437, I was on my own board for almost 17 years. I was treasurer, vice president, and president. I was intimately involved in the budget process as a board member. And I can tell you that a good association run under the structure that's been in existence for over 40 years, these budgets are presented months ahead of their need to be approved at an owner's meeting. All right. They are disclosed. They are available for unit owners to see and to, with the open forum portions of the owner meetings, have an opportunity to make comments before the board acts on a budget and approves the budget, usually a month before the annual meeting. So there is transparency. The structure has worked for over 40 years. There really needs to be no change to it. If the community doesn't like it, then they can gather and by majority voting interest reject it, and then the board would have to start over again. And so I don't see any need to change that whatsoever. Eliminating the ability of boards to have that 15% special assessment in case of emergencies, the proposed legislation would eliminate that. And that is as dangerous as been cited by both Charles Ryan and Ron Barber. There is a lot of apathy. And so having the burden on the majority interest to vote down the budget is necessary. These communities would be dysfunctional and chaos would ensue if they didn't have the presumption that a board approves a budget, and unless it's rejected by the majority voting interest, it stays approved or ratified. If that changes as proposed in this legislation, the consequences are dangerous. There's one other aspect of 5437 has to do with publishing personal information on owners. We think that is just not appropriate given privacy security issues that we all have in 2026. Finally, with respect to 5433, my comment relates to the amount. $50, you can't get anything for under $50 these days. Gas prices are jumping up 10, 20 cents a day. So someone giving a gift basket, how is a board member or anybody to know how much it cost at that point? How did he declare something like that? I think the possibility of having some kind of disclosure requirement would be acceptable if it could be, the wording could be figured out that would make sense to everybody. But as proposed in 5433, it's unmanageable, unnecessary, and again, it's a solution in search of a problem. So for those reasons, I appreciate the opportunity. I thank the chairs and ranking members of the committee, and I'll leave out the members of the committee, and I'm here to answer any questions if you should have any.
Thank you. Question or comment from members of the committee, Representative Fishbein.
Thank you, Mr. Chairman. Thank you, sir, for coming here to give us your perspective. As I look around the room, it's 5 against 1. I'm used to that. I feel like I'm in court. I just, as to the donation aspect, I guess we hear that it's difficult to fill these boards. And if we just have a disclosure thing, and let's say the snowplow company gives the board chairman $1,000 gift and discloses it, but nobody's willing to be the board chairman, is that good relations? As opposed to just saying, can't get the $1,000 gift.
I thank you for the comment, and I'd like to respond. It's a great comment. I think that a disclosure requirement at a level that makes sense is not unreasonable, and that's something that our group and legislature and this committee and others can certainly work on. It's not unreasonable because, frankly, $1,000 gift should be disclosed. I wouldn't fight that. I think it's unreasonable to fight something like that. But $50, someone takes you out for lunch, you take them out for lunch, you get a gift basket. We have St. Patty's Day tomorrow, cookies, whatever, soda bread. I mean, this proposal right now is unworkable and unreasonable and not logical. But I do think there is an opportunity somewhere down the line to come up with a disclosure process along the lines of what you just mentioned that I think would be doable. Absolutely. Because that should be disclosed and frankly shouldn't even be done. I mean, from my time on the board, I would never accept that, ever, not even close. And
Yeah,
I would encourage boards never to touch something like that. But $50 for for a gift card or a bottle of wine, and then how do you know how much it really is when you get it? I just don't think it's workable. But going forward in the future, Representative Fishbein, I think that is something we could all look at. Absolutely.
Yeah, I guess it's the appearance of impropriety here, because the $1,000 gift, my point is that, okay, it's disclosed. What's the remedy for, the senior citizen who's living in the condo association and, there's this, what looks like a quid pro quo going on, she's probably not going to oust the board chair as a result of it. She knows about it. It's going to make it even worse. And I think at some level there should be a bar. So that's what I'm wrestling with on the other side. So, but thank you, Mr. Chairman.
Thank you, Representative. Comment or question from other members of the committee? Comment or question from other members of the committee? There are none. Thank you very much for joining us.
Thank you, Senator.
You're welcome. Alexander Thomas.
Good afternoon. I'm here today in opposition to Senate Joint Resolution number 41, Senate Joint Resolution number 49, and House Joint Resolution number 46. I want to start with Senate Joint Resolution 49. Leonard McLaurin of New Haven, Connecticut, died after being released from DOC custody at age 45. He had just finished serving a 30-day sentence. While he was incarcerated, the DOC was instructed by a Superior Court judge to bring Mr. McLaurin to his dialysis treatments. But the state of Connecticut sent Mr. McLaurin to prison on dialysis at the peak of COVID for a 30-day sentence. And during that 30-day sentence, they didn't get him to his dialysis. He contracted COVID. the COVID unit wouldn't take him to his dialysis. And on April 17th, they released him to his elderly parents while he was running a fever, his heart rate elevated, blood pressure dropping, COVID positive. He went straight from DOC to Yale New Haven Hospital and never left, and died at age 45, 23 days later. The commissioner called this a medical malpractice claim. It is not. Putting someone on a van to dialysis is simple negligence. Failing to do so, such that a 30-day sentence becomes a death sentence, is simply negligence. And Mr. McLaurin's family deserves a day in court regarding his untimely and tragic death. Michael Graham also died of COVID at age 60 at McDougall Walker, where I will note there have been 5 recent deaths at that institution this year, and the warden should be fired from that institution as a side note. Michael Graham's mother spent 3 years trying to find out what happened, and DOC wouldn't tell her. When she got the records through FOIA, she filed a claim within weeks, and this claim is now being called untimely. You heard earlier from Attorney Krajewski, the DOC doesn't take responsibility. That's what they ask inmates to do, but they don't do it themselves. Instead, when they commit misconduct, they hide the evidence, and the Attorney General's office complicitly enables and allows them to do so. And unfortunately, strict court rules sometimes prevent people from getting justice. But you, legislators, you are not constrained by those strict rules. You can do justice and also allow the Graham family to have their day in court and permit them to sue the state. Finally, Marvin Minter, House Joint Resolution 46, was pinned to a broken elevator at New Haven Whaley Correctional Facility, and his arm is permanently injured. He asked for $35,000. He was denied because he didn't complete a DOC grievance form, which, even if he had filled out, would have not enabled DOC to provide him with any relief for his injuries, because it's not a system that awards money. Judge Clow in the Superior Court has ruled that these strict rules regarding the grievance forms are not fair when you can't get relief from the grievance form because they don't award damages. So there are 3 people here I represent in state custody, 2 dead, 1 permanently injured. Oppose these resolutions and give them their day in court. Thank you.
Thank you. Question or comments from members of the committee? Question or comment? I think, what was the last name of Michael? I think it's Senate 49.
41. Oh, House. So Senate 49.
Yeah, I think the second one.
Senate 49 is McLaurin. Senate 41 is Graham.
So that one, Senate 41, that's the one where there was an FOI involved?
Yes. So there was an FOI involved. And the question was, had DOC done any investigation? Were there any facts that could be obtained regarding why DOC failed to quarantine him, delayed his transfer to a hospital? And the FOIA request came in, and what we found was that DOC had done an internal investigation, which they had been withholding from us, called a death review. And this is not the only family I've represented where it's taken years after they're completed for DOC to release these death reviews. And as soon as we got the death review and actually had facts from which we could, in good faith, file a claim, we did so. And so there was no untimeliness here or lack of effort or diligence. What was going on is this misconduct of DOC where they hide the evidence because they know that families give up, that they want to move on, and that there are strict court deadlines. And so if they can bury the evidence long enough, their misconduct can be covered up and concealed. And I think that one thing that that this committee should seriously consider is requiring the Attorney General's office to bill the Department of Correction for the legal services that they provide, so that each year you as legislators could see how many hours the Attorney General's office is devoting to defending the DOC, for which the DOC doesn't have to pay anything for that legal defense. It comes out of somebody else's budget. And that's creating this perverse incentive that Attorney Krajewski and I have to fight against in all of these claims. And that's frankly why not many other attorneys want to take these claims.
Okay. All right. Comment or question from any other members of the committee? Comment or question? And now, Attorney Thomas, thank you for joining us again and your continued work.
Thank
All
you.
right. Rosemary McGovern. Okay. Addison Bennings.
Good afternoon, members of the Judiciary. My name is Addison Bennings, and I filed claim number 26383 with the Claims Commission on July 20th, 2021. Both my brother, Antonio Bennings, and I met and satisfied any requirements of notice to the Claims Commission by filing suit at the U.S. District Court of Connecticut and New Haven, even though at the time little to no facts were substantiated in late 2003. After being very chipped, implanted, and drugged, to date, little to no facts have been confirmed. We are attempting to subpoena 2 judges to confirm what we believe happened to us. The federal lawsuit was filed without any hard facts. We did confirm the existence of the Verichip products. We filed for investigation with the U.S. Attorney Nora Dennehy, District of Connecticut, but they refused to give the results of the investigation. Addison did not know about Claim Commission until mid-2021. Brothers claim exemption from any laws, rules during times when Verichip devices were in their bodies. Brothers did question Martin McBride, Federal Bureau of Investigation Supervisor at New Haven headquarters in New Haven. He claimed he did not know anything about the Verichip or the devices. The FBI implanted us with Verichip. Devices caused index offense. After FBI agents were arrested for implanted and assaults on claimants. State prosecuted claimants for index offense for 22 years, even though the state was aware of FBI arrests. State contradicted itself by saying following: A, Verichip incident did not occur. B, claimant failed to file a claim within 1 year of incident. Both cannot be true simultaneously. Incident, prosecution of claimants after arrest of FBI agents. 2 things are true, but truth has not been exposed. A, U.S. Attorney Nora Dennehy knew of FBI arrests. B, as State Supreme Court Judge Dennehy and Richard Robinson knew and hid facts of FBI arrests when claimant's case was before their court. Request that the claim be reopened and returned to the Claim Commission for settlement conference. 2, that both claimants be ordered released from custody immediately. June 28th, 2021, the Office of Chief State's Attorney is a receiver of your correspondence postmarked June 10th, 2021. Your correspondence concerns your request to have this office assign an investigator to review facts and circumstances surrounding related to the theft of the lottery tickets, employment of certain individuals by the federal government, and the implementation of electronic transmitters into you and your brother by agents of the federal government. These matters were the subject of your trial in 2004 death of your wife, Vonda Bennings. You were found not guilty by way of mental disease or defect. You are currently under the jurisdiction of the Secretary Security Review Board. The Division of Criminal Justice has determined that your allegations are without merit, and DCJ will take no further actions. We were denied the right to testify in person today. Attorney Thurston is the state's attorney, not our attorney. We are pro se. We're suing for $250 billion each. Thank you.
Thank you. Comment or question from one of the members, from any of the members of the committee? Comment or question? I do not see any. Thank you for joining us today.
Thank you.
Cassandra Campbell. Cassandra Campbell. Cassandra Campbell will be followed by Joan Todd. One more time for Cassandra Campbell. Joan Todd.
Good afternoon. Good afternoon, Senator Winfield, Representative Staffstrom, and distinguished members of the committee. My name is Joanne Todd, and I am testifying in support of HB 5431, an act concerning cooperative corporations, which proposes targeted amendments to the Cooperative Associations Act to better reflect the governance needs of cooperatives operating in Connecticut. I'm a member and former treasurer of the Willimantic Food Co-op. To summarize the relevant proposed changes, HB 5431 would modernize the Cooperative Act through several practical updates, adjust the quorum requirements for member meetings, adopting balloting provisions from the Non-Stock Corporation Act, and implementing technical updates. With these changes, the Willimantic Food Co-op could consider changing from its current legal structure, which is a Connecticut non-stock corporation, to a Connecticut cooperative. As a legally chartered cooperative, it would then be possible to distribute patronage rebates to members, which is really a hallmark of cooperatives. Patronage rebates are distributions of a cooperative's net income, profit, returned to member owners based on their volume or usage of services or purchases. The board of directors determines the amount of patronage rebates, which are only paid when the cooperative has net income, and only a portion may be paid. Section 33-193 limits the distribution of patronage rebates to 40% of net profits. The remainder is retained for working capital. I explain all this because it's not altogether familiar with people who aren't familiar with cooperatives, but as a profitable cooperative, having the ability to pay patronage rebates would allow Willimantic Food Co-op to operate as a true cooperative. Without the changes in HB 5431, the Willimantic Food Co-op, and really any organization considering becoming a Connecticut cooperative, will not do so because the current legal restrictions. Currently, Connecticut cooperatives must follow quorum and voting standards modeled after the Business Corporation Act. These requirements are designed for investor-owned companies with relatively small groups of shareholders and are really impractical for large member-based cooperative organizations like the Willimantic Food Co-op, which has 7,000 members. As a result, cooperatives can face unnecessary procedural barriers when conducting basic governance functions such as member meetings and elections. HB 5431 addresses this issue by aligning cooperative governance provisions with those used by non-stock corporations, which are designed for member-based organizations. Doing so will improve administrative efficiency while preserving the democratic, member-driven structure that really defines cooperative enterprises. In conclusion, HB 5431 makes modest but meaningful updates to Connecticut's cooperative statute. By aligning governance rules with the realities of member-based organization, the bill removes unnecessary barriers, supports democratic participation in modern. Am I out of time? Okay, thank you. I respectfully urge the committee to support HB 5431. Thank you very much.
Thank you. Comment or question from members of the committee? Comment or question? There are none, so I want to thank you very much for joining us today.
Thank you.
Sarah Parker McKernan. Sarah Parker McKernan. Okay. Thomas Hernandez. Oh, there you are. Go ahead.
Sorry.
Yep.
All right. Good afternoon, Senator Winfield, Representative Staffstrom, and distinguished members of the Judiciary Committee. Thank you for the opportunity to testify today in support of SB 343 and to highlight the positive impact it will have in increasing access to pardons. My name is Sarah Parker McKernan, and I am a legislative policy advocate for Connecticut's legal services programs, which include New Haven Legal Assistance, Greater Hartford Legal Aid, and Connecticut Legal Services. The legal services programs provide free legal services to low-income individuals in civil matters throughout the state. SB 343 addresses the fees involved with the many aspects of a pardon application. Recognizing the burden these fees can place on low-income pardons applicants, the 2021 legislature authorized fee waivers for indigent clients seeking a pardon but unable to pay the $75 fee associated with obtaining their required criminal history records. While this was a substantial step forward in increasing access to pardons, there remains a multitude of fees associated with additional aspects of the process. In 2022, the legislature passed PA 22-7, which authorized third-party electronic fingerprinting submissions through the Connecticut Criminal History Recording System, as well as a $30 convenience fee. Fortunately, SB 343 addresses all fees associated with a pardons application. Although a $30 fee may seem negligible for many, for our low-income clients, it could be insurmountable. Many of legal services clients do not have a credit or debit card or access to the internet. In this case, not only is income a barrier, but technology also is an obstacle. Our clients are typically living at less than 125% of the poverty level. Successful pardons applicants must show through an online application requiring significant documentation that they have changed their lives, stayed out of trouble, and given back to their community. Cases that have come through our offices over the years include multiple clients who are trained CNAs or personal care attendants and are now in nursing school and need pardons in order to become RNs. Individuals with convictions from their teens or early 20s having to do with marijuana or other minor convictions. Multiple clients who are now staff in sober houses, substance use programs, or reentry programs. And single mothers with convictions arising from being trauma victims who are now struggling to care for and support their children. Additionally, Connecticut's clean slate law has further allowed individuals with certain older convictions to benefit from the automatic erasure of those records. Unfortunately, Connecticut is still working on creating and implementing a notification system to formally let someone know that their criminal record no longer legally exists because of clean slate. Legal Services has found many clients that will start the pardons application process, save up funds to be able to pay the applicable fees, and then find out that their records have been erased through clean slate. Having to pay a fee to find out you no longer have a criminal record can be yet another setback to moving forward. So I thank you for the opportunity to talk about this some more. And can I just wanted to respond to comments from Representative Fishbein, who had wondered about the past history of this bill. And yes, that was a good catch. This bill, similar version of this bill, has been raised in public safety for several years. And actually, that only passed out of public safety, but also passed out of the House unanimously twice, but was failed to be called in the Senate. So it's time for this to actually go through. So thank you very much. And I think there's something screwed up with my video or audio or something here, but
your audio's fine. We didn't see you in terms of the video, but let me just check. Are there any questions or comments from members of the committee? Question or comment from members of the committee? There are none. Thank you very much for joining us today and providing us with your testimony.
Thank you.
All right, Thomas Hernandez Hans.
Hello. Thank you to the Judiciary Committee for letting me speak. My name is Thomas Hernandez Hans. I'm speaking in support of SB 343, an act concerning fees charged for criminal record history record checks. I am a staff attorney at Greater Hartford Legal Aid. I work directly with our indigent clients who are applying for a pardon for their Connecticut criminal records. GHLA has represented hundreds of pardon applicants. Applying for a pardon is a lengthy and detailed process. There are also numerous charges and fees associated with the pardon application and obtaining the correct documents. Pardon applicants are often seeking to expunge their criminal records to better their employment opportunities, often in service to their communities. Most pardon applicants that GHLA represents are employed, but in lower paying jobs, where they still struggle to support themselves and their families. I thank Dr. Emily Knox from Connecticut Voices of Children for bringing up a lot of great stats earlier regarding the extreme difficulty that formerly incarcerated folks face in achieving stable employment. The fees that the pardon application process does require may seem modest or nominal to a middle income earners, but they can be really significant barriers to our clients. These hardworking indigent individuals must have access to this extraordinary second chance program provided by the pardon process, and thus continue their personal rehabilitation and contributions to their community and increased financial security. I'd also like to thank Representative Fishbein for bringing up comments regarding the clean slate erasure. And as Sarah Parker McKernan also noted, many of my clients, especially in the last 6 months, do seek out our office seeking a pardon. And after we've cleared the first hurdles and costs of getting the pardon application started, only then can we realize and actually officially check whether their record has been cleared by clean slate. So a few of my clients have come seeking a pardon, had to pay the fees or had to navigate the fees, only to learn that it wasn't necessary in the first place, and their record has already been cleared by clean slate. So I appreciate you bringing that to the committee's attention, Representative Fishbein. We strongly support Greater Hartford Legal Aid, as well as the other legal aid services in Connecticut, strongly support SB 343, which lowers the financial barriers for people seeking to apply for a pardon. Without the changes proposed, the pardon process will continue to present unfair obstacles for indigent people seeking to start again. Thank you.
Thank you. Questions or comments? Any questions or comments? Seeing none. Thanks for being with us.
Thank you.
All right, next is Judge Beverly Street.
Good afternoon, Senator Winfield, Representative Stastrom, Senator Kissel, Representative Fishbein, honorable members of the Judiciary Committee. I am Beverly Strite, the Probate Court Administrator. I'm here this afternoon to offer comment on House Bill number 5441, an act concerning revocation of non-probate transfers and appointments by dissolution of marriage. I have submitted written testimony. In essence, my office takes no position on the policy behind the proposal, but we would offer request for clarification of two provisions, one with respect to designation of conservators and the other as to clarification of the term relative of the former spouse. I have spoken with the Connecticut Bar Association. We will continue to work together to come to agreeable language, and I'm happy to answer any questions.
When?
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 We have already begun conversations today, and we'll continue them today and report to the committee.
All right, so the committee needs to vote bills out next week.
Yeah,
So,
we understand there's a tight deadline.
so we need proposed language by Wednesday morning.
Okay, will do.
Thank you.
Thank you.
Further questions or comments? Seeing
I
none.
just committed my Bar Association people that will be testifying after me, but I'm sure we'll do it.
All right,
Thank you.
yep.
Cassandra Campbell's ready to testify.
All right, we're gonna get back to folks who weren't available when we call them at the end. Carlos Holden.
Thank you, Senator Winfield, Representative Staffstrom, and esteemed members of the committee. I'm a board-certified emergency physician in practice for more than 20 years and president-elect of the Connecticut College of Emergency Physicians. I speak in opposition to HB raised bill number 5430. The malpractice climate in Connecticut is already a challenge for practicing physicians and for resident physicians considering a career in Connecticut. For years 2020 to 2025, Connecticut ranks in the highest 10 states for number of malpractice suits per capita, according to the National Practitioner Data Bank. When you consider only the highest payout cases with verdicts of greater than $2 million, Connecticut is still in the top 10 in absolute numbers, not per capita. Despite our population of 3.7 million people based on 2025 data, we had more malpractice verdicts greater than $2 million than Ohio with a population of 11.9 million, or Texas with a population of 31.7 million. And again, that's in absolute numbers. Expanding the malpractice climate here in Connecticut to allow people to sue the state is the wrong answer for the healthcare workforce, for the insurance industry, and for the people of our state. Data from the Medical Professional Liability Association demonstrates that the majority of liability claims are dropped, dismissed, or withdrawn. And of the small minority that go to trial and are decided by a trial verdict, the majority of those are won by the defendant. These meritless claims increase stress and burnout on physicians at a time when Connecticut needs its physician workforce more than ever. These lawsuits also raise costs for the entire healthcare system and the insurance industry. Apart from the obvious legal costs associated with defending meritless claims, a hostile malpractice climate increases the practice of defensive medicine. Tests or treatments ordered not because they are necessary, but because they will bolster a defense in the event of a claim. A head CT ordered even when we know it will be negative increases costs, potential complications, and radiation exposure. That's bad care for patients, more costs for insurers. The CBO published a paper finding that states with malpractice caps spend on average 4% less per Medicare beneficiary. In summary, Connecticut's aggressive malpractice climate is a deterrent to physicians remaining in the state or choosing to begin practice here. Further, it raises the cost of care and lowers its quality. This bill, as it is written, incentivizes more malpractice exposure, more billboard lawyers, more unreasonably high payouts, higher costs for insurers, and worse care for the people of Connecticut. Thank you for your time. I welcome any questions.
Questions or comments from the committee? Seeing none, thanks for sticking with us. Rosemary Payne. And is Cindy Robinson going to join you? Okay. Well, your microphone in front of you there. You just have to hit the button.
Got it. Thank you. Good afternoon. Thank you for pronouncing my name right. Good afternoon, Ranking Member Fishbein and distinguished members of the committee. I am here with my client Nervis Diaz, who lost her son in 2009 when he drowned at Squance Pond. August 31st, 2009, 8-year-old Edward Torres Jr. was playing with other children. He was playing in a designated area of Squance Pond that was roped off with buoys and gave the impression of a waiting area, safe for children. Unbeknownst to Edward and his parents, that roped off area was deceptively deep in specific places.
Wait, I don't mean to interrupt you, but what claim number?
Oh, I do apologize. I'm providing testimony in opposition to Section 2 of House Bill number 5430. And my apologies. I've also submitted written testimony that clarifies in more detail.
All right.
But Edward and his parents had no way of knowing of that condition. There were no warnings. There was no necessary safety signage. There were no lifeguards on that day. Had they known, had they been aware, they never would have allowed him in the water without them. Sadly, Edward wandered into a section well over his head. He disappeared underneath the pond water and drowned. In the year prior to his death, the state was well aware of these risks because they hired a safety audit, and an aquatic expert identified substantial risks, and many among them in this designated area. The state hired the expert and asked the expert to define substantial risks as risks that should not be, activities that should not be started until the risk has been reduced. Considerable resources may have to be allocated to reduce the risk. Where the risk involves activity already in progress, urgent action should be taken. Those were the state's definitions. They got an expert to give them guidance, and they ignored it for over a year. They also ignored their water safety director and the director of Squance Pond that found no cost or low cost ways to remediate these issues. And I bring this to your attention because this was a case that was brought before the claims commissioner, and we have a release to sue, and the claims process was thorough and it worked as it should. We had a very extensive hearing at the claims commission. There was a motion for summary judgment. The legal issues were addressed. We went to a full hearing. Thousands of pages of testimony were reviewed, 4 days of testimony. And again, I refer you to my written comments, but the system has worked the way it should. It should not be changed.
All right, thank you. Yes, and we do have your testimony in front of us. Questions or comments, Representative Fishbein?
Thank you, Mr. Chairman. So just to be clear, you're not here on a contest of a claim. You're opposing the public policy that is created by the second section of 5430.
It is my understanding that the Attorney General's office wishes to change the language of, and that's the section to include the state as a identified owner. That change would significantly change the law as it exists. And I'm here to offer the experience of, this is a necessary claim, but the Claims Commission work process and now the Superior Court process has worked the way it should. And there is no need, nor should things change, because if they did, I think the balance between allowing public access to these areas versus holding the state accountable when necessary would change if the law were changed.
So this is a policy decision. So looking at the language before us, by way of policy, why is it good public policy to have a municipality in here, which is a creature of the state, but not the state?
Because the state has
its own process, which is slightly different, but very, very robust in terms of dealing with this. We have a claims commissioner who is well able to deal with these claims. So as you are aware, this law changed to add municipalities. We had the recreational immunity statute to encourage private landowners to open their land. And then in 2011, the change was to allow or to name municipalities. But municipalities do not have the whole process by which, again, existed in this case, where the claims commissioner considered all of the legal issues and all of the factual issues. There was robust discovery, numerous depositions, and then testimony before the claims commissioner. I referenced that decision in my written materials, but it was found that this claim had merit. So my point is that this process does work. That I do not believe there are a lot of claims like ours, thankfully, that have to get addressed, but this process addresses them when necessary.
But there is no similar process for a municipal claim. So for instance, in my town, we have a few parks that have bodies of water. Not actively for swimming, but I could see, well, I could certainly see a few of them being used in that fashion. If a child drowned in a municipal park, giving the same facts that you present here today, they're barred under the statute from making a claim, right? There is no claims process.
I respectfully, I do not believe that that would be the case because there would be a similar, there are exceptions. And again, our case dealt with the exceptions. There is also the issue of open body of water versus in our case, in our particular case, there was a roped off area, which not only did the aquatic expert hired by the state say gave the appearance of a waiting area, but the state's DEP water safety person and the park, the person in charge of the park ranger, all indicated that that was the case. So it was more of a created area, not an open body of water. But I do think the issue of municipality versus state, the state has the claims commission process, which clearly the municipalities do not have.
Yeah, which you're proving my point. So anyway, okay. Thank you, Mr. Chairman.
Further questions or comments on this? Further questions or comments? If not, thanks for being with us.
Thank you.
Cindy Robinson.
Good afternoon, Chairman Staffstrom, Chairman Winfield, Ranking Member Fishbein, Ranking Member Kissel, and distinguished members of the Judiciary Committee. My name is Cindy Robinson, and I'm here today on behalf of the Connecticut Trial Lawyers Association to oppose Section 2 of Raised Bill number 5430, which would extend recreational land use immunity under Connecticut law to the state of Connecticut. Connecticut's Recreational Land Use Act was enacted for a narrow purpose to encourage private and municipal landowners to open undeveloped land for public recreation by limiting their exposure to negligence law. It reflects a simple policy trade-off: provide land and avoid liability and allow the public to use that land. The state of Connecticut does not need this incentive because it already operates parks, forests, beaches, campgrounds, and recreation facilities as a core function of its government process. Extending immunity in this regard to the state would not open a single additional acre of land. It would simply remove accountability for negligent maintenance of facilities the state already is charged with. Significantly, as discussed by Attorney Payne, the state is already afforded substantial legal protection through sovereign immunity in the Office of the Claims Commission under state law. Negligence claims have to go through a very strict process. They have to be screened before a lawsuit can proceed. This system protects the state from meritless claims while still allowing injured persons to have some limited pathway for recovery when negligence occurs. Extending the statute would shield the state from claims arising from natural land conditions and effectively bar claims involving the ferry infrastructure that the state has built and maintained: staircases, docks, boardwalks, pedestrian bridges, and public facilities like restrooms and changing areas. Under this immunity, the state would have no duty to inspect, maintain, or warn of hazards unless it was willful or malicious, a standard that can almost never be met. We have heard from Attorney Payne the incredible legal process that she and her client have been through for well over a decade. And to reference the 2026 Oscar-winning movie of the year, it has been one battle after another. We've seen it both in the claims commission process, and if you look on the docket for this case, again, motions upon motions. And that's the way it should be to protect the state. It's part of the sovereign immunity. However, the proposal being sought is not a clarification of existing law. It is a substantive change, and I submit that the citizens so affected would be among the most vulnerable in our community. So on behalf of CTLA, we ask that you please reject Section 2 of Raised Bill number 5430. Thank you.
Thank you. Further questions? Representative Blumenthal.
Thank you, Mr. Chair, and very nice to see you, Attorney Robinson.
Thank
We're here. Thank you for sharing your testimony on this bill. Had a couple questions. One of the things I've noted about many of the state campgrounds, less so the parks, but is that you have to pay to use them often. And so the state is actually taking money from the public, much in the same way a private amusement park or campground owner would. And so how, if at all, do you think that should affect how we think about the state's duty to provide a safe environment and ensure against unreasonable risk, and what the sort of incentives this bill would create would do to that incentive?
Well, I think it would diminish that, and candidly, right now we have a situation where in any such case under the Claims Commission, that situation comes up where there's always an argument as whether payment was received. Oftentimes, it's payment for parking, and there's always arguments in these cases. There's not that many of these cases, but there's always an argument that, well, is that really payment? Does that really constitute payment? Overall, it seems that the courts have decided that that is payment. But it seems the way the system works at present, it's covered. In other words, there's a review process that handles that and figures out whether the claim has enough teeth to go forward and be admitted to Superior Court.
Appreciate that. And as you did note the intent of the previous act was to encourage the provision of additional land for recreational purposes, which the state can, of course, decide to do on its own at any time with its lands. Is there any real difference in terms of a state park or a state campground from a kind of policy background that you can tell between the state and a private landowner that's offering their services to the public for paying customers?
Well, I think from a policy, the difference would be that the state does that. That is part and parcel of what it does as part of a government function, but that's not necessarily the case with the municipality. And I think that's the whole reason that the recreational use statute was put into place, was to give them an incentive, to give them a trade-off, to encourage them to make open lands available so that the public could have the benefit of that. And so that's where I think it makes a difference, is that there is you have the incentive of opening up public lands to the communities and the people for the state of Connecticut for beneficial reasons, for recreation, which is a good thing.
Thank you. Well, I certainly appreciate your testimony, and thank you, Mr. Chair.
Further questions, Representative Fishman?
Yes, thank you, Mr. Chairman. Sorry. Thank you, Mr. Chairman. Good afternoon.
Good afternoon.
Just want to extend that. Now, 52557G exempts property. You probably don't have it, it's the one that follows the one that we're talking about here. If a fee is charged for accessing the property, then that's an exemption.
That's my understanding.
So how about two similarly situated individuals, one who's a Connecticut resident and one who is a New York resident? They both come to Connecticut to utilize a park, and unfortunately, each one's child gets injured. We'll just leave it at that, right? Would you think it to be fair under the statute that the New York resident didn't pay the passport to fee of parks fee, whereas the Connecticut resident did? And that there would be a difference there, that one would be able to sue and the other would not?
And are you talking about a state park?
Yes, that's because as we're talking about state liability, right, in the statute.
Right. There could be some injustice in that.
So even if the statute is changed to add the state, which would bring them in line with the municipality, because the municipality is already in the statute. With regard to a state park and the story we heard before, it would be my opinion that because the passport to parks fee was more than likely paid by the individual as part of their registration, that 52557G would kick in and they would be able to bring a lawsuit.
Well, that same provision is always talked about in the state claims. They're always looking to argue whether or not there was payment made, and a lot of times it comes down to the parking aspect of it. But I guess it's really the underlying policy as to why this change was made, because prior to the 2011 discussion, legislative history discussion, neither the state, the municipalities weren't part of it. There's all case law regarding that. So during that 2011, all of that legislative history focused solely on, although state liability did come up, but it focused solely on the fact that this was to encourage municipalities to open up land and had nothing to do with the state. So I think the underlying policy for the recreational use statute is directed at opening up land, which just doesn't apply to the state of Connecticut. And the state of Connecticut already has a very strong policy in terms of weeding out cases that might be considered meritless.
Yeah, I mean, I guess so this came up originally last session. We were dealing, it was Claims Day, public hearing. We were talking about people that had been injured in our parks, and the question came up, why is municipality in there and state's not in there? So that's the genesis of where we are. But then I come back to the equal protection thing. So if you have a park that's owned by a municipality, park that's owned by a state, you get injured in the park that's run by the municipality, there is no relief. Whereas you get injured in a park that's owned by the state, you have the possibility of surviving the claims process and therefore ending up in Superior Court. So how is that fair?
Well, I think it's a different focus. The state has sovereign immunity, and the towns and municipalities have governmental immunity. And I'm not so sure whether you could never make a case. I think there are exceptions as well in the recreational use statute, payment, malicious or willful, which again, I would say is very difficult to kind of prove in these kinds of cases. But there are differences between the state and municipalities. And I think that's the whole purpose or the underlyings as to why the recreational use statute got passed in the first place.
I appreciate that. So thank you, Mr. Chairman.
Further questions, comments? If not, Attorney Robinson, good seeing you as always.
Thank you.
Marissa Dungy.
Good afternoon, Senator Winfield, Senator Kissel, Representative Sastrom, Representative Fishbein, and members of the Judiciary Committee. Thank you for the opportunity to speak in support of House Bill 5441, an act concerning revocation of non-probate transfers. and appointments by dissolution of marriage. My name is Marissa Dungy. I'm a practicing attorney in the state. I'm also on the executive committee of this Connecticut Bar Association's Estates and Probate section, which proposed this legislation, and I was on that committee. I'm also a fellow of the American College of Trust and Estate Council, and I'm on the governing council for the American Bar Association's Real Property Trust and Estate section. We have been working towards this legislation for some time. We think it's important in conforming the treatment of non-probate transfers, which are basically transfers on death that occur outside of the probate process, with probate transfers. Connecticut law has long held that on the dissolution of a marriage, automatically revokes provisions in a will for a surviving spouse, surviving former spouse, as well as the appointment of executor, their appointment as a healthcare agent, their appointment as an attorney in fact under a power of attorney. All of that has been in the law for some time. What isn't captured are other revocable appointments, beneficiary designations, accounts with rights of survivorship, things like life insurance policies, IRAs, appointments of trustees of a revocable trust. This legislation seeks to sort of provide consistency with the statute in the state of Connecticut in order to cover both probate and non-probate transfers and treat them alike. Clearly, it's a policy in Connecticut that these probate transfers be revoked on divorce. Stands to reason that non-probate transfers, would feel the same way about it. There was a question, I think, of whether or not the contracts could be changed, by state law. There was a Supreme Court case in 2018 on a Minnesota statute that is similar to the one that we've proposed here. And the Supreme Court did find that revocation of non-probate transfers on divorce did not violate the contracts clause. So that's now been resolved. As said, that was a Supreme Court case from the United States Supreme Court case from 2018. And so we have been working on this legislation since shortly after that and trying to address concerns that have been raised by everybody. As Judge Straight mentioned earlier, we've been communicating with the Probate Court Administrator's Office, and we'll submit slightly revised language on definitional terms. And happy to take any questions that are here.
Other questions? Representative Doucette.
Thank you, Mr. Chair. Thank you for your testimony. We had the opportunity to have a brief conversation outside. I wanted to ask you, though, and maybe talk a little bit more about the objections of the Bankers Association with regard to just the operational problems that may occur with sort of automatically converting joint bank accounts. I think, again, their concern was that it's difficult to do that, and the repercussions of doing that vis-a-vis their customers and the owners of that account are difficult. But I guess from my perspective, of more concern, I think, is the fact that it may contradict an order of a divorce court. All of those assets are going to be listed on a financial declaration. The court's going to make orders with respect to those assets. It seems to me that a bank account is actually the easiest one to deal with, and that the funds can be readily transferred. So I don't know. I guess it seems to me that it has to, the court order or what's in the divorce decree has to be consistent with what we're trying to do here. Could you comment on that a little bit, and why it wouldn't be better to have the court directly direct the disposition of those assets according to the divorce decree, as opposed to having this sort of default rule that we're creating in statute?
Yes, I'd be happy to. Thank you for the question. I understand the Bankers Association of Connecticut submitted a written testimony in opposition to it, raising a similar point. I would say in response to it is that first case, the divorce agreement always governs. This is just simply the default rule. And specifically of concern is that these accounts are joint with rights of survivorship. And so while a court may have concluded the appropriate ownership of the accounts, if somebody dies while the account still exists as joint with rights of survivorship, the rights of survivorship would withstand unless there was already a court order saying that this needed to pass on death. For the most part, the only provisions, as I'm not a family lawyer, but the provisions that are dealt with are the division of property, how payments are made after a divorce, but while a person is still alive. So they don't necessarily address, other than possibly the need to hold a life insurance policy or need to do this or need to do that, are included in a divorce agreement. The specific issue with respect to these accounts is that if they simply say how the account should be divvied up, if somebody passes away during that period, that the rights of survivorship would overcome as how the account is titled. Because if any two people own an account joins with rights of survivorship, it will pass to the survivor by operation of law. And so what this does is it seeks to create a default when it's not mentioned in the divorce agreement as to what happens to this account. Obviously, it would be better for all parties if it's mentioned in the divorce agreement, so everyone's on the same page with respect to what happens to it. But they're not always mentioned in the divorce agreement. If they are, it does trump the default language of the statute, which says that the divorce agreement is the controlling document.
Okay, so that is in the bill.
Yes,
currently.
it is. I can't cite the exact statute, but my colleague, I'm sure, can do that for me in two spots.
And then as a practical matter, how would the bank, or if it's a life insurance company, how would they take notice of that? Would it have to be, is that spelled out?
What is spelled out is that payers, third parties are not liable, right? So the issue is if a spouse goes and seeks the sum, if they hand it over, there isn't an issue. It's just that they become legally entitled to it on a rights of survivorship or on a beneficiary designation, and the bank or the institution is obligated to pay it to them. This is really about the person who took the funds, not necessarily going after the institution. So there is language in here to protect a third party who's not aware of it. I would say that this particular provision that has been cited to around severing from a joint account with rights of survivorship into tenants in common is the exact language used in the Uniform Probate Code, which has been passed. There's some 30 plus states that have this legislation, half of which have it because of the Uniform Probate Code. And it's the language from there. So I think there are other institutions that are managing this, how the assets should be allocated. But there is third-party protection that's already provided in legislation to ensure that it's not the bank or the insurance company. It's the person who took the funds that should not have taken them based on a new default rule that we passed here, that non-probate transfers are not can't pass to a former spouse absent an agreement in the divorce agreement to the contrary.
Right. I think that's important. I'll take another look at it, but I think, yeah, that's got to be spelled out carefully, and then just the way that works as a practical matter, vis-a-vis the party and the financial institution, that's got to follow those directions.
I agree. As I know we discussed in the hallway, but Massachusetts is the state with the Uniform Probate Code. New York has a law very similar to this. There's more than 30 states that have it, and obviously there are some institutions that are exclusively within the state of Connecticut. But nationally, I think that because the majority of states have this legislation already in place, they're sort of used to dealing with it and are aware of the implications. I'd also mention that because we have this power of attorney statute that's already on the books that says if you're, on a divorce, it's automatically revoked as to a former spouse. Those are most commonly used in the course of banking institutions. So there's already some, it already touches on these institutions in the event of a divorce. And, I think this is, it's capturing the scenario where people, have fatigue following a divorce, don't go back to their estate planning attorneys, might not have an estate planning attorney, and just don't deal with the sort of administrative piece that comes with, updating beneficiary designations and the like. And I think those are probably more common, the life insurance policy, the IRA that's out there, that people just don't update their beneficiary designations in time. And it does pass to a surviving former spouse in that case. And this would seek to say that, no, that person should be treated as deceased in favor of whoever the successor beneficiary is or that person's estate.
Right, and that's fine. I appreciate that. But again, it's just if there's a contrary agreement in the divorce decree, because these things do happen, where you have a quadro or some sort of disposition of assets that's been negotiated, that we're not somehow acting in contravention of that. That's my only concern. So I want to take another look at it and make sure that those scenarios are dealt with, and if not, that we are able to improve the language that's in the bill.
Thank you. And I would just add two things to that, which is one is that this had the full support of the family law section, and also that it doesn't, the effective date is intentionally July 1st, 2027, in an effort to make sure that there's plenty of time to, address anything, appropriate and make sure that divorces that are occurring. So it's prospective with respect to dissolutions that are occurring on or after July 1st, 2027. And so I think the best case scenario is that these things are dealt with in the divorce agreement, and that we are, just thinking ahead of them. So.
Yeah, okay. Thank you. Thank you, Mr. Chair.
Further questions or comments, Representative Fishman?
Thank you, Mr. Chairman. I guess the exchange that I just heard gives me a level of skepticism as to whether or not this is ready for prime time. There's a case that I was recently involved. I heard that there's a divorce decree and somebody passes that the divorce decree would rule. But I don't think that's in here. I'm concerned about a third party not knowing whether or not there was a divorce decree. So I'll tell you, there was recently the Perez case. It was in the Meriden court. And parties got divorced after a trial. And the judge rendered her opinion, giving Mr. Portion of the wife's 401k. And although he was young, he died about 2 months after the divorce decree. So under this language, the ownership would have been affected by the statute. How would the administrator know about the court's order regarding the 401k?
So I did find the language while you were speaking. It is in section B. It says, except as provided by the express terms of a governing instrument, a court order, or a contract relating to the division of property made between the divorced individual and the former spouse.
Sure, line 62.
Yes, that's correct. And so I would say that the situation you described is a division of property on divorce that is not affected by this legislation. This would seek to say, I don't think this would come up here. I think the issue would be with respect to let's say that the wife had died in your scenario, and then the wife, before this account had been divided, didn't update her beneficiary designation, and it continued to leave property to the former spouse, and that that one of them died 2 months later before the account paperwork had been completed, that he would in fact get the whole account instead of 20% of the account because the beneficiary designation hadn't been changed. That's what this seeks to try to correct. And instead, if this legislation existed, that beneficiary designation, he would be treated. He would still get his 20% of the account, but he wouldn't get the other 80% if he had been the original named beneficiary. It would instead go to the successor contingent beneficiary.
But if the court had issued an order saying, let's just say she's got the 401k, he's entitled to half, there's going to be a quadro, right? That's the order of the court. He passes away. That ownership interest is actually legally a asset of his estate.
I agree.
How is one to assert that?
I mean, it's the same way that they would do it now, right? You would say, I have this court order, this money is mine.
Oh, they're
The
dead.
executor would go and claim the account.
So you would have to wait for the appointment of an executor or administrator for the estate. In the meantime, the wife could say, hey, statute,
This doesn't affect the ownership of property. This is around
it could
the
affect
beneficiary designation.
I understand the 401k, for instance.
But the beneficiary designation. So in his case, he would not have written a beneficiary designation yet, right? Because he hadn't taken over control of his share of the account. it'll end up passing to his estate absent a beneficiary designation. Her beneficiary does, like, she still has half of the account. It's still in her name. She has a beneficiary designation associated with it, presumably. If that beneficiary designation, as a lot of couples do, right, they name their spouse as the beneficiary of their retirement account. If the spouse who owned the account, this isn't a question of how the account is divided. I think, let's say they both died 2 months later, the account had not yet been divided. The executor of the estate of the individual who had not yet claimed his share of the account, you would have to have an executor appointed. That the executor is the only one who's capable of acting and seeking property that belonged to a deceased person. The executor would go and claim the 50% of the account. The account doesn't, his assets don't have a beneficiary designation, they would flow to his estate. The 50% of the account that remained the wife, whose name was on the account, in this example, they both passed away 2 months later. Her beneficiary designation, let's assume she hasn't updated it yet, and it still names the husband, former husband now, as the survivor or as the beneficiary. Instead of getting the 50% of the account that he was awarded in the divorce, he'd get the 50% of the account, and then he'd also get her 50% of the account because the beneficiary designation hadn't been updated yet.
But while we're waiting for all this stuff to happen, what's to prevent her from taking a loan against the 401k?
I mean, I think that's an example of an issue that exists currently, right? I mean, in theory, if you get divorced and you seek to, sort of use an asset that's not supposed to be yours under the divorce agreement, there issues. As I said, I'm not a family lawyer, but you're not, as I understand it, that property's not yours. You're not allowed to take it. There would be a claim against the person who used, who tried to take a loan against the property and take it in violation of the court order.
But isn't the bank in the middle of that? They have no knowledge about the decree. The owner of the 401k has asked to take a loan, which, but for the decree, they would be allowed to do. So are you opening the bank up to liability for doing that transfer?
So I think the example that you have is not addressed at all by this legislation because this is dealing with the beneficiary designation on that account, not the ownership of that account. I think this language does have third-party liability protection built into it in order to address the possibility that somebody who isn't supposed to take the property goes to the bank and says, I'm the beneficiary, give me the money, and they take the money. What would happen in the scenario where, you've gone and used your beneficiary designation, the bank gave you the money because they had no reason to think that you shouldn't have it. You were the named beneficiary on the account. It hasn't been updated. Then you would go after the person who has the money, not the banking institution. The example you're describing, though, is people are still alive and the divorce order has been entered, property has been divided, and despite the court order, somebody seeks to take or use property that's not theirs as a result of the court order, even though it's technically still theirs in the bank. This doesn't touch on that at all. I don't think that this legislation would have any effect on it. The example that it gets to is sort of like, what if people die before the beneficiary designations are updated? How do we, how can we make Connecticut law with respect to these beneficiary designations the same way that we deal with the estate? If, for example, that account had no beneficiary designation associated with it, but she'd had a will that said, leave everything to my spouse, under Connecticut law, now we're talking about the old example where both couples died 2 months after the divorce, the account hasn't been moved yet. The executor for the husband comes in, he takes his 50% of the account, goes to the estate. The wife, there's no beneficiary designation in place, goes to the estate under the will, even though the will said everything to the husband, Connecticut law revoked that, and now it's going to pass the successor beneficiary. What we're saying is that what this legislation can do is say, well, it doesn't have to go through the estate and the will. The same outcome should happen, though, because there is a policy in the state that a former spouse, that, we assume that the residents of the state don't intend to benefit their former spouse unless they say so. They can say so in a divorce agreement. They can say so in their will. I intend to leave this here. They can reestablish their beneficiary designations after the fact. I actually do have a lot of couples who are very amicably divorced that do have provisions for each other. So it does happen, but the typical person does not want to benefit their spouse after a divorce. And a lot of times beneficiary designations are simply not updated in time. And this makes the beneficiary designation, the operation of that, consistent with what we already have under the law when it comes to dispositions of property under wills.
Thank you. Thank you, Mr. Chairman.
Further questions or comments? Further questions or comments? If not, thanks for sticking with us.
Thank you very much. Appreciate your time.
Gus Marks Hamilton.
Thank you. Good afternoon, Representative Staffstrom, Senator Winfield, Representative Fishbein, and all the distinguished members of the Judiciary Committee. My name is Gus Marks Hamilton. I'm the campaign manager for the ACLU of Connecticut, and I'm testifying in support of SB 343, an act concerning fees charged for criminal history record checks. We've already submitted written testimony supporting SB 343, so I will try to be brief. We support legislation that reduces the hurdles of background checks and helps people apply for and receive a pardon. For people who have earned the opportunity to apply for a pardon, the process can be difficult to navigate, technologically challenging, time-consuming, and not inexpensive. Even fees that do seem modest, like the $75 state police criminal background check fee, can be barriers for a person who might be eligible for a pardon. SB 343 addresses this barrier by waiving the cost of a criminal history search when a person applies for a pardon. SB 343 also prohibits independent contractors from charging a convenience fee to people who are applying for a pardon. I have watched many pardon hearings, and a frequent response to why an applicant is seeking a pardon is to increase their earnings potential through a job or promotion so they can better support their family. Most of the pardon applicants I've watched in pardon hearings are already employed. Sometimes they're literally at work during the pardon hearing, but in lower paid jobs, and are hoping to take on professional opportunities and development that might be unavailable to them because of their background. Some applicants are interested in starting their own business, but might be disqualified from receiving a business loan because of their background. I also know people who have applied for a pardon multiple times, and even though they weren't granted a pardon, they were told by the Board of Pardons and Parole to continue doing what they're doing and reapply in the future. Obviously, every time they apply again, they must pay the $75 criminal background check fee again, and that can become very costly. Previous versions of this concept have received widespread support, so I strongly urge the members of this committee to support SB 343 and continue supporting efforts to help people rebuild their lives and become productive members of our state. Thank you.
Thank you. Questions or comments? If not, thanks for listening.
Yes.
Abigail Demusis Apuzzo.
Good afternoon, Senator Winfield, Representative Staffstrom, Senator Kissel, Representative Fishbein, and members of the Judiciary Committee. My name is Abigail Apuzzo, and I am here on behalf of the Connecticut Bar Association's Estate and Probate Section to testify in strong support of Raise Bill 5441, an act concerning revocation of non-probate transfers and appointments by dissolution of marriage. I'm an attorney who's been primarily practicing trust and estates law for the past 13 years, current treasurer of the Connecticut Bar Association Estates and Probate Section, and I chaired the subcommittee that originally drafted this proposed legislation. I'm also a fellow of the American College of Trust and Estates Council. Want to reiterate that we work together with the family law section, the real estate law section of the Connecticut Bar Association, and also the probate court administrator's office on making sure everybody was aligned on the language in this bill. The bill was drafted by the Connecticut Bar Association, and we feel it's important to our constituents because it solves a problem. As Marissa Dungy just indicated, it creates consistency in the law, and it ensures consistency regardless of how the property passes, whether it's through probate or outside of probate. As an estate planning practitioner, we often see this issue talked about on our Connecticut Bar newsfeed and in the general estate planning community. A petitioner will commonly ask, my client died, appointing their former spouse as beneficiary of their life insurance policy, and that was not the intent. What do we do? And the answer is, unfortunately, there's nothing we can currently do. There is this inconsistency under law. And we feel like this legislation fills that hole in Connecticut law and supports the intent of what the majority of the divorced individuals do. I want to address your comments earlier today that I do think that this law and this legislation as currently drafted addresses many of your concerns that you just raised. As Marissa pointed out, it specifically does accept from its terms, the express terms of a governing instrument, a court order, or contract relating to the division of property. Additionally, just for your reference, starting at line 104, Part F of that bill addresses the protection for third-party liability. And Part G2 of the bill is where it says that you go after the party who basically incorrectly received the payment. You go after them. You don't go after the bank or the other third party. And so I wanted to note that. I also wanted to note that we will be reaching out to the Bankers Association to see if there's any way that we can work with them to address their concerns. We've already started those conversations and we'll continue to do that. And I welcome any other questions or comments you might have.
Thank you. Questions or comments from members of the committee? Questions, comments? I think you did a great job.
Thank you very much.
Okay, next is Edward Zielinski. Edward Zielinski. To be followed by John Carteris. And I see you're in there, Mr. Zielinski. Mr. Carteris is already coming up, so just hold on. You'll go right up after.
Mr. Vertefel, I'm here testifying on his behalf. We're calling in regards here in regards to SJ 55, asking that the committee reject the claims commissioner's finding. Mr. Vertifelli, while an inmate, fell and slipped and injured himself while incarcerated, he filed a timely grievance. The accident happened on August 1st. He filed a grievance on October 13th. In the evening on September 17th, his grievance was rejected. He would have had 5 days to rectify the grievance. However, at that time, he was immediately released from incarceration and did not have access to either his paperwork or the ability to rectify his a grievance, in that he was separated from his paperwork, kept in a holding area, and released the next day without any meaningful opportunity to follow up on his grievance. The commissioner indicated that he could have done it through his parole officer, but at that time it could not have been done because the parole officer did not have the authority to accept to rectify a grievance. So it had been done through the prison, which he could not have done. It was literally an impossibility.
Okay. Comment or question from members of the committee. Representative Fishbone.
Thank you, Mr. Chairman. Good afternoon. Am I to assume that the grievance or the claim was dismissed due to the failure to exhaust administrative remedies?
That was the stated reason. In the way he was presented, it was impossible for him to do it.
No, I understand the defense, right?
Yes.
So I just want to procedurally figure out where we are. So, and what is the claim?
The claim is that the area around the shower was slippery. It didn't have proper rubber matting or ability to have anything to protect him from the fall. He slipped and fell on a slippery condition that was noted by the division.
And what was the damage?
He cracked open the skull, had a number of stitches and staples in his head.
Okay. What was he being held there for originally? Was it a conviction or like?
It was
bail out?
it was a conviction of possession of a weapon.
And just so I don't hold that against him. I just trying to figure out procedurally where we are. But then was he coming down to the end of his sentence? I'm just trying to figure out.
He was coming down to the end of his sentence. He submitted his grievance, and then approximately 14 hours before he was released, the correction staff handed him a denial of his grievance, what he would have had to do was to submit file more paperwork within the institution. But is almost immediately after being handed his denial, his property was separated from him and he was put into a room to be released.
And I got that. That's like sort of like the back end. I'm just
Yeah.
trying to get to the back end. So he did fill out paperwork,
Correct.
but the paperwork, when you said the grievance was denied, that would be an exhaustion of administrative remedy. But what I heard originally was the papers were rejected.
They were
There's a
rejected,
difference.
which is a different policy. A denial, you'd have to file an appeal, which he could have done through the parole officer. A rejection, he would have had to take further steps within the institution.
So what was the basis of the rejection?
He did not speak with a proper staff prior to filing the about his complaint prior to filing the grievance.
Okay, so how much after the incident did he attempt to file the paperwork?
8 days.
Okay, so I would expect that somebody whose skull was cracked open would be of limited means that quickly after the incident.
May I say something? Sir, I followed.
Just identify, we kind of know who you are, but identify yourself.
In this, I filed with the counselor. You have to go through the counselor first before you do the grievances, and she directed me on how to do that. And when I did it the way she told me to do, I didn't hear anything back to the last day before I was released. And then they said, well, you have 5 days. Here's the paper. We're not denying you. It's the dejection or a kickback. You have to redo it correctly, but you only have 5 days to do it. And I was released and couldn't do anything inside the facility. And I went to the parole officer and they said, well, we can only start a level 2. You have to complete the level 1, which put me back at square one, and I couldn't do anything.
So, and just to do, I'm just want to focus on the procedure. If we were to find constructive attempt to follow the administrative procedure, that would perhaps put you in the hands of the claims commissioner on whether or not you have a viable claim.
Correct.
Okay. All right. Thank you, Mr. Chairman.
Thank you, Representative. Comment or question from other members of the committee? Comment or question? Seeing none, thank you very much for joining us today. Joan Avaletta. And Mr. Zelinski, you'll be next.
Thank you, sir.
I thank you for giving me this opportunity to submit testimony in opposition of House Joint 45. I had no idea when I started the process of securing an education for my sons in a safe school setting as ordered by 3 different physicians that I would be entering a battlefield. I was also seeking justice for all other children who were and would be harmed by the failure to provide a safe school setting. I would think our legal system was based upon the principle that no one should suffer harm without just redress, and to provide legal guidance for individuals who suffered a grave injustice at the hands of another. I pray and hope no other family ever experiences what I have been through for several years. It all started many years ago when former Attorney General failed to enforce the law after he sent a letter to the Education Commissioner stating her requirement was to educate children and to provide an alternate placement. It was her obligation to do so. She not only ignored him, but the Attorney General also failed to follow through by enforcement. Maybe I'm confused, but I thought his role was to protect children in the state of Connecticut. After that, after submitting volumes and volumes of supporting documents regarding building conditions and medical records, I was promised he'd help in obtaining an education placement. After several months of stalling, I was dropped and told to seek outside legal counsel. There's nothing more he can do. Subsequently, as a result of that, I've been in a war zone with the Attorney General's office ever since. What has led me here again today is the fact I've never had a fair and just hearing on the merits of my claim, period. I almost did, and a hearing was actually scheduled by the good intentions of this legislature, who remanded my claims back to the Claims Commissioner. However, former Attorney General George Jepson filed a declaratory judgment. That pattern in the Attorney General's office continues to this day. I would think our system of law should provide a person who suffers harm should be entitled to compensation in the form of monetary damages. In addition to providing compensation, causes such as this should cause the system to change their practices to prevent future injuries. I lost complete trust in the court system, but perhaps some of that could be restored. This could have all been avoided if the Attorney General office did what was promised and enforced the law. That's why you need to vote no and remand this back to the Claims Commissioner for a hearing that I've been denied many years. And then unfortunately, my lawyer couldn't be here this morning because she's in Stamford Court exactly 10 o'clock when she was supposed to be here. But she cited all the legal, their stuff, written testimony provided as to why she feels the Claim Commissioner erred in making a decision, which is all the reason why we need to revote. I hope you vote no.
Thank you. Representative Fishbone.
Thank you, Mr. Chairman. Good afternoon, ma'am. I can see that you've been through a lot. I really don't know, though, based upon what you told us here today, a lot about your case. So what happened? What's the case about?
So many years ago, my children were denied an education and I had to make a unilateral placement, place them in a private school. So I was seeking outplacement for them when 3 doctors said they could not attend these buildings. It'd be detrimental to their health. And so I made a unilateral placement, been fighting the school system ever since. Then I sought help through the State Department of Education, the Attorney General office and everything. They were basically denying education, so I had to place them in a school that was safe.
So are you looking to be compensated for the costs of
Yes.
educating the kids?
Yeah, initially, that's all I ever wanted.
Okay. So
And so it's been caught up in the court system, and the legislature here has remanded it back to the Claims Commissioner. Deborah, and in her testimony, you'll see it. It's on the, under this bill.
So is there a court case that
No,
presently?
it's over now. So with the support of Senator Hardin, he encouraged me to go back to the Claims Commissioner and file a new claim. And I was exhausted at that point, but I went ahead and went through the process.
Okay,
We
so
lost in Supreme Court, and Deborah Stevenson, the attorney, can go more into the legalities of that.
okay, I'm just trying to figure out procedurally. It may be that your claim was dismissed, and that's HJ 45 under the doctrine of res judicata. Does that does that ring a bell?
Deborah, I think the main things was untimely filing.
Okay,
And Deborah said the Claims Commissioner erred in that, and she backs it up with, on her written testimony.
okay, I'll look at her testimony, but if you're telling us that you've already had legal proceedings involving this
Yeah, we
claim,
went all the way to Supreme Court.
and you were unsuccessful for
Yeah.
whatever reason,
I think it says it right here. The Supreme Court ruling was issued on August 22nd, and the claim of injury based on that ruling was filed with the Claim Commissioner on December 9th, less than 4 months after the court ruling.
okay, so I heard about months, but what years?
Specifically to what?
Well, you said
This,
you gave us something July 9 or something like that. I didn't hear anything about 2024, 2020. Do you know what years you're referencing there?
you mean in terms of the timely filing
dates.
as the Claims Commissioner?
You just gave us months with days of the
Oh,
month
I'm sorry.
without a year.
August 2020, August 20th, 2023 is when the Supreme Court made a ruling. And then we filed the claim with the Claims Commissioner December 9th, 2023.
Okay, and just to be
As soon
clear,
as it became known, went to special, the injury that was caused was the failure of actually the legislator to include a public policy purpose in a special act 17-4.
but just to be clear, the claims that you're asking to go forward now are the same claims that were made in the case that the Supreme Court
Yes.
disposed of. Okay, thank you. That answers a lot of my questions.
I think, yeah, if you read Deborah Stevenson's testimony, that would answer a lot more questions
Thank you.
about different reasons why we feel it should be opposed.
Thank you.
Okay.
Question or comment from members of the committee? Question or comment from members of the committee? There are none. Thank you very much for sticking around and providing
Thank
us
you.
with your testimony. Edward Zelensky.
Yes, thank you. And thank you for listening to me. My name is Edward Zelensky. I reside at 1366 Grasso Boulevard in New Haven, Connecticut. And in fact, I'm speaking to you from that location, and I'm speaking to you because of that location. I, along with many of my neighbors concerned about the question of sober houses being concentrated in particular urban neighborhoods, offer qualified support to what is Bill 5490. This is an industry. It's a very lucrative industry. It's an industry that we are very concerned about. And it's an industry that right now is very much under the radar screen. We favor disclosure and information so that we can understand better what is going on. And in that respect, we support, or I support, 5490 with three important changes. Number one, technically, when a house, a sober house, is registered and is disclosed, we should know the address. That's a technical change that needs to be made to this disclosure. We're very concerned about the potential pattern of how these houses are being segregated in various urban neighborhoods. Second of all, we ask for what I think are very burdensome information requirements, but they should be satisfied by all sober houses, not just the sober houses that seek certification and registration, so that we have true information about what's going on. And finally, there need to be penalties for non-disclosure. This is a very lucrative industry, and if non-compliance is simply a cost of doing business, I think we're going to find that a lot of these operators are not going to comply. So with those three changes, I support 5490. At this point, it produces, from our perspective, information, but it's information that neighborhoods like ours is entitled to know.
Thank you, Mr. Zelensky. Representative Dillon.
Thank you very much for taking the time to testify on an issue that's of very high importance to many of our neighbors and many of your neighbors. And you've brought this to us because you support disclosure. Is there a broader concern about safety or about supervision requirements in any of these facilities?
Well, yes, there are broader concerns, and the current language addresses some of those concerns. The informational we're asking for is preparatory to addressing those problems. We need more information. Yes, there's great concern. When you, for example, go onto the websites for the people who are encouraging sober houses, these are not operations by Mother Teresa. These are operations that are described in very commercial terms. Get people, get them in for 30, 60, 90 days, and then roll them over. It's very troubling stuff. And so, yes, we are deeply concerned about the impact of this on the people who are living there. We're concerned about the impact on our neighborhoods. Right now, what we want is information so that we can undertake a deeper and more thorough analysis of what needs to be done. So the simple answer to your question, Pat, is yes.
Thank you. And I know many of your neighbors have raised this issue to me over the years, because they were concerned that at the same time we were talking about a housing shortage, we were losing residential properties. And they were being converted to other uses. And it wasn't clear to me what could be done at the state level unless we were going to do a moratorium in certain areas. Really didn't know. You've brought us something a little bit different, and I really appreciate that. Thank you very much for bringing it to us.
No, thank you for listening to me.
Thank you, Representative Dillon, and thank you, Mr. Zelinski. Rep. Dillon really has put in a lot of work here to try to get us to start regulating an area that we have very little regulation. So your input is extremely helpful as we move forward and try to figure out what the final form of this bill will be. Have a great afternoon. Okay, so next we have Omar Miller. Omar Miller will be followed by Paul Lewis. Omar Miller. Okay.
Good afternoon.
Okay. You may go.
Okay. Yes. Good afternoon, Connecticut General Assembly Chairman Winfield and Representative Stromsford, members of the Judiciary Committee. In 1997, I entered the custody of the Connecticut Department of Correction. And at that time, medical care was provided by UConn, University of Connecticut, who had a $100 million contract to provide medical care. Upon admission, I informed UConn medical staff that I had a serious right ear condition requiring routine medical care. I also presented them with a letter from Dr. James Herman Mabry outlining the care that needed to be given by a licensed ENT, ear, nose, and throat specialist. However, despite that, the fact that I gave them said evidence, they denied me medical care. And as a result, repeat infection set in my right ear, and I got paralysis. I developed facial paralysis on the right-hand side of my face, which I currently live with. Fast forward from 1997 to 2021, at which time that I was released from the Connecticut Department of Corrections and sent to New York to serve additional 2 years. Connecticut denied me medical care prior to that release. I filed grievances. They denied those grievances. As a result, I had to continue to live with facial paralysis. Facial paralysis causes the biting of the lip when chewing food. It also causes me to have an incomplete blinker. I cannot close my right eye without closing my left eye first. And you can see the deformity as I speak. Also, my speech was slurred. I had one surgery upon being incarcerated, but after a release of incarceration. But before I get to that, I would like to state that the Department of Corrections in the state of Connecticut was negligent because they claimed that surgery was cosmetic in nature and not medically necessary. However, upon release, the ENT who examined me stated that the surgery was medically necessary in order to enable me to speak better, and also in order to allow me not to bite my jaw when eating food and things of that nature, as well as to repair my right eye. The claims commissioner heard my claim and denied it based on the statute of limitations, saying that the statute of limitations had told. Nonetheless, the statute of limitations did not toll because this.
Mr. Miller.
Hello? Yes, sir.
Your time has elapsed, so if you could just summarize for us, that would be great.
Okay. My claim is that the statute of limitations in relation to my facial paralysis did not toll because the state of Connecticut fraudulently concealed evidence that would have supported that surgery on my face was medically necessary.
Okay. All right. Are there comments or questions from members of the committee? Comments or questions? There are none, Mr. Miller. I want to thank you for joining us and providing us with some context to your claim. Have a good afternoon.
Yes, sir. All right. Thank you. Thank you for the time.
Paul Lewis. Paul Lewis will be followed by Cassandra Campbell. Paul Lewis.
Technicality. Can you hear me now?
We do.
Great. Thank you for the opportunity to speak before the committee. Good morning, Senator Winfield, Chairman, Representatives Dubitsky, D'Amato, DiCaprio, Finley, Fishbein, O'Day, Delaney, Gilchrist, Johnson, and other members I don't have the names of. My name is Paul Lewis, and I am petitioner for Bill SJ 00047. Thank you for the opportunity to speak today. This matter arises from discrimination I experienced while I was a student at Southern Connecticut State University. I pursued my claim through the legal avenues available to me, including federal court, CHRO, administrative bodies, and the claims commissioner process. However, the underlying merits of my case were never fully examined, and that's the reason why I come before you now. And I refer you to the written documents that I have submitted already and the exhibits therein. As a result, the legislature is now the only place where the fairness of this situation can be still considered. My request today is simply for the opportunity for the merits of my claim to be heard. I'm asking that the claim be allowed to proceed so that the facts may be evaluated in a full and fair hearing, full and fair proceeding, which so far has not happened, even though I sued in federal district court twice, U.S. Court of Appeals twice, and the U.S. Supreme Court once. My cases were dismissed on procedural grounds without ever being heard, evaluated. For the goal of fairness and for the pursuit of justice, I come before you now to ask that someone would hear my case, that it would be allowed to proceed. My request is limited. I respectfully ask that the legislature allow my claim concerning Southern Connecticut State University to proceed.
Mr. Lewis, your time has elapsed, so let me.
Really?
Yes, we only get 3 minutes and goes faster than you probably believe it does. So
yes.
Let me ask you, because I didn't hear what your claim is, and I did a little research on these things, so I know that you had been banned twice from Southern Connecticut State University and then subsequently attempted to gain admission. So is your claim about the admission part? Where does your claim sit?
Well, the claim is that I was banned from Southern Connecticut for discriminatory reasons, and I want you to hear this one sentence. This is an ADA case, and it's not just for me, it's for other students to come who have a disability like I do. There's 7 classes of disability in the ADA, and I have a mental health disability with agoraphobia and panic disorder. It's an anxiety condition. And so I was banned. First I got a master's in special education from Southern with a 3.7 GPA. Before I was disabled, I had no problem with administration. That's how I can see the difference. And suddenly when I applied in 2005, I was banned. And then again, I was banned in 2008. And then CHRO allowed me to come back on campus. It was a conciliation agreement signed by Dean Piscatelli, Professor Tukey, who submitted testimony, can speak to that. He has spoken to that. And
So
then
I'm gonna ask you a question because
yeah, sure. I'm sorry. I'm just trying to.
I get it. It's fine. I appreciate that, but I know that there is the banning, and I guess my question is the banning what triggers your complaint, or is it the subsequent attempt to enter programs at Southern and being denied, or is it a combination? I'm just trying to figure out what.
Yes. No. Yes. Well, Senator Winfield, I'm glad to meet you. So the answer is yes to both questions. First, the ban that concerned me, and that was the basis of my first claim and my first lawsuit. But then the conciliation agreement was issued, allowing me back on campus, and so I applied 2 more times, and they did tricks to keep me from even applying. Okay. I don't have the time to go into it. It's like the memories stir up. That's why I'm not presenting as smoothly as I would want to. But
you're doing
thank
fine.
you for asking those questions. I appreciate
You're doing fine. I just wanted to see if I could get some clarity. Let me see questions from other members of the committee. Comment or question from other members of the committee. Representative Fishbein.
Thank you, Mr. Chairman. Sir, I'm looking at the document that the Claims Commissioner issued with regard to the dismissal of your case, and it indicates that your claims had already been filed with the CHRO and in federal court, and those, I guess, were disposed of through those processes. What would you have the Claims Commissioner do different now if it's already been through that process?
Well, it's been through that process, but there are 2 things I need to tell the committee. The CHRO does not provide the same remedy as a claim against for a claim against the state, and the federal courts, the other branch that I tried, dismissed my cases procedurally. So there's no way that anybody can say that my case has been heard, because it hasn't been. It hasn't been heard on its merits. And all I'm asking the legislature to do, which is my last chance at fairness and justice, all I'm asking them to do, all I'm asking you to do, is to allow my case to finally be heard, to give me another chance to have a forum which could provide for fairness and justice. And I'm not asking for anything except for another chance to finally present the merits of my case. I just never had a chance to do that.
And when your case got disposed of in federal court, did you appeal that proceeding?
Yes, I did. I went to U.S. Court of Appeals, Second Circuit, twice. And the first time was about the first banning that happened in 2005, 2008, and they affirmed the lower court's decision. And the second time, they wouldn't even allow my brief. They wouldn't allow me to send them my brief. I mean, I've never heard of anything like that before.
Okay, thank you. Thank you, Mr. Chairman.
Thank you, Representative. Are there comments or questions from other members of the committee? Comment or questions from other members of the committee? Seeing none, I want to thank you very much for joining us today. Next, we have Cassandra Campbell.
Hi there. Good afternoon,
Good afternoon.
Mr. Chair and Judiciary Committee. I'm here in support of House Bill 5431, and I am supporting the act. My name is Cassandra Campbell. I am currently the board vice president of Fiddleheads Food Co-op. And the HB 543 legislation is crucial to Fiddleheads because it resolves some legal terminology that we have been bound to, which is under the Connecticut statute. Most importantly, this legislation would allow the board of directors to continue to apply our cooperative principles through policy governance, and thereby Fiddleheads can provide member benefits, services, and collective good for our current and future members. This legislation fortifies our economic growth and development, and it is foundational to keeping Fiddleheads vibrant. I thank you for your consideration. If you have any questions, I'll be happy to answer.
Thank you. Comment or question from members of the committee? Comment or question from members of the committee? There are none, but I want to thank you for hanging in there and providing us with your testimony today.
You're welcome.
Okay.
Thank you.
So next, we have some folks from the Attorney General's office, Attorney Meskel, and I don't know if McGovern is coming up with you. I don't know how you all are doing it, but okay, great. But
Go. Good afternoon, Senator Winfield, Representative Sastrom, distinguished members of the Judiciary Committee. My name is Eileen Meskel. I'm the Deputy Attorney General, and shortly, Associate Rose McGovern will be back and will join me in case she can answer anything that I might not be able to answer, because given there's a large number of claims. I have obviously watched before I came and saw a majority. I did miss a couple in the middle when I was heading over, but I'm really here just to answer any questions you all might have.
okay. Comments, questions from the committee? Questions from the committee? I think that is not normal, but
It's okay with me.
Representative Blumenthal.
Thank you, Mr. Chair, and thank you, Madam Deputy Attorney General. I just didn't want to go in front of the distinguished ranking member if he had any questions. I had a couple questions on one of the bills today, and which was 5430, and in particular Section 1. And I guess I wanted, just for kind of fact-finding purposes, I had a couple questions. How many of these cases in state recreational areas are we seeing?
So if we were trying to get sort of an answer to that question as we were listening to the testimony. So prior to Commissioner Shea, from what we can gather quickly, and we're certainly happy to look further and get you some more definitive answers. This is just what we were able to learn today from our general lit section, which does a majority of those types of cases. But prior to Commissioner Shea, I believe we had 3 before Commissioner Christy Scott. In all of those, she believed that the state was subject or had the defense of the recreational land use statute. She did give her permission to sue in one that in which she found one of the exceptions applied. I know we heard about the exceptions today. But I believe there's some references in some of those decisions to earlier claims commissioner decisions in which also it was found that the recreational land use statute applied. Obviously, I believe it was last year because I was here. There were some cases. There was one that went through. We heard about one of those tragic situations today. Rose, I'm just being asked about the number of cases, and I mentioned the 3 from Christie on the recreational land use statute and the reference to the previous decisions. But in general, prior to that, in terms of actual numbers, we would have to try to run a search. But I wouldn't say there was a huge number, if that's fair.
Yeah, I think that's accurate. There was at least one from Commissioner Vance.
Okay,
that applied recreational land use immunity to the state and denied a claim.
Okay. So it doesn't sound like there's a huge glut of these cases, that's being complained about by DEEP or anything like that. It's a relatively small universe of cases.
Well, it's a small universe of cases, but they generally found that the state had the immunity. It's not the opposite, which I think there was some I believe misunderstanding about whether it applied or didn't apply previously. So the general rule of thumb had been that it did apply, with some outliers. One was there was an exception. There are some exceptions to the statute, and then a couple of recent cases from Commissioner Shea's era.
Okay.
Yeah.
So it's the state's position essentially that you all were covered as owners in the previous version of the statute?
That's correct.
And I guess my question is, I wasn't here in 2011,
Hmm.
but why didn't we include the state explicitly when we included municipalities, if that was the case?
Yeah, I certainly was around, although I don't think I was familiar with that legislation. Do we don't have any sense of that from the two? I certainly don't know the answer to that. We could try to find an answer, and if we get it, we're happy to provide it to you.
Appreciate it. And
Yeah.
have there been any reports that DEEP is planning to shut down parks or anything like that because of lawsuits like that, like these?
I cannot. I certainly haven't been that involved, obviously, or checked, so I don't know the answer to that. And again, I'm happy to check with our section that represents DEEP. I would think that the DEEP would have their own position on that. I don't know what that is right now.
Okay. And in terms of the charge exception to the immunity,
Right.
I guess one of the concerns I have is that there are state parks that do charge in some ways, not others. Has it been the state's position that parking generally qualifies as a charge under the statute?
It doesn't. Our position is it does not qualify as a charge. So a parking fee in of itself is not an admission fee. That's our position.
Okay. It's my understanding, following on a line of questioning by Representative Fishbein earlier, that there have been some cases in which the superior courts have found that a parking fee may qualify as a charge. And I guess I wonder if the exception, if we were to pass this and make essentially the state explicitly an owner or explicitly cover the state under the statute, my understanding is that most Connecticut residents don't have to pay kind of the standard parking charge because if they are paying the passport to parks fee through their taxes. And that might create a situation where you'd have, I know it's not your position, but at least the Superior Court might decide that, someone coming from New York who doesn't pay taxes in Connecticut for our parks, because they are charged a parking fee and then they're injured on the property, they might have a right to sue the state that a Connecticut resident didn't. It's a hypothetical and a complicated question, but is that your understanding? And do you have any comment on that disparity?
Yeah, I don't think that's my understanding, although I'm happy to look at those cases. We've had some cases in Superior Court. Sometimes people file directly in Superior Court, and we move to dismiss that for various reasons. I will say, obviously the policy is certainly for the legislature and the committee to decide. I think, keeping in mind the passport fee, I think what you're talking about, and the parking fee. I don't know if all the state parks charge a parking fee, but there's always the possibility that somebody doesn't come through by vehicle, or, is visiting somebody nearby, and that could be somebody from out of state. Obviously, I think we're all charged the passport fee, although I'm not sure people realize that. And so there is also the possibility, I bring this up because there's that somebody bikes in or boats into a park or walks over from, if they're visiting someone, doesn't pay the parking fee, and then they're at the park and having paid nothing. Or there's that scenario as well.
Thanks. I appreciate that. It was my understanding that we're all paying it as well. But,
Yeah.
out of lawyerly caution, I didn't want to, make too broad a statement. I want to ask you about kind of the policy because I don't think you're necessarily here to comment on that. You're here to defend the state's fisc and sovereign immunity. And, I do have a concern about this part of this bill. Liability to the state can be a powerful incentive for us to make things safer. I think of the individual whose case we heard about earlier at Squan's Pond, which had a historic problem. I think many more drownings than nearly any parks in the state. I think it was 13 or so during a relatively short period. And I think sometimes we need a fire to be lit under our rear end to actually take action, or maybe state agencies do, and that when wrongful conduct happens and people are injured, having it cost something to the state can make that incentive actually stick. So, I understand your position. I understand why you're here. And you're obviously ably defending the state against these and many other lawsuits. But I have a concern about giving a complete immunity in this area and what kind of incentives it could provide or deprive the state of to act in a safer manner. And, I will include us in this as well because, one of the reasons why I think Squan's Pond wasn't receiving all the lifeguarding perhaps it should have was because certain budget cuts were not paying for lifeguards there. So I think it can provide an incentive for state agencies to act more responsibly. It can provide an incentive for us to act more responsibly. So I appreciate you being here and answering my questions. And you're welcome to respond if you like, but feel no obligation.
Yeah, I really just wanted to say that, part of what we were looking at is, since the Claims Commissioner statute is about putting the state into private person, that's really what that was sort of the focus here, was putting us on even playing field with what else applies to everybody else, but understanding that that's how the case from our perspective had been up until recently. So, but I totally understand and appreciate, your concerns and the decisions you have to make. So thank you.
Thank you. And thank you, Mr. Chair.
Thank you, Representative. Representatives Blumenthal's, I'll get to you, Representative. Representative Blumenthal's comment about making it cost can provide incentive to do what some folks might think is the right thing takes me back to the exchange we had last time that you were here, and my question about what actually benefits the state. Is it just a defense, or is it thinking about the way in which some of these bad behaviors that are included in the behavior of the state that it feels to some people like you are defending should not be defended. And so I have a question, because a lot of the folks who testified today talked about bad behavior on the part of at least DOC. the hiding of information, and other things of that like. And as a person who does this work, where does how does what you do imagine that as you think about the defense of the state and the benefit of the state? What role does the part that the state has actually played here have to do with the way in which your office deals with these things?
So I totally appreciate that. And I think, you know, it's going to be understanding, you know, what you asked me last time in the context of these claims here. But not just that, in all of our litigation in state court and federal court as well. By statute, we are required to defend the state employees, officers, agencies. You know, there are some exceptions, of course. We get to make some determinations when individuals are being accused of intentional conduct. But generally speaking, that's our job. So we're not hired per se. We are the state's legal officer, right? So obviously, there are lots of claims about against the state and that they've done something wrong. Sometimes it's claims it's negligence. Sometimes it's claims of intention. Sometimes it's discrimination. It can be obviously run the gamut. And so we are ethically obligated to defend that within the confines of our normal other obligations, which is the rules of professional conduct, the Superior Court rules, and all of that. And, you know, it's often the case where people, and I understand it, get frustrated. They say, oh, you know, look at this case and maybe there was a verdict and the state lost and, you know, how could you defend that? Well, as long as we're not frivolously defending, like there has to be some merit to something we're doing, that is our obligation, just like with many other attorneys who represent clients that people don't necessarily feel happy about. But, you know, we do have the ability to make sometimes decisions that maybe the private attorney doesn't, but we still have to do that within our obligations to our, whether it's the individual staff member or employee that's been sued or the agency. But we do have conversations, those are privileged conversations with our agencies about, you know, lessons learned, things that, you know, we would like to see different. You know, we can't disclose those conversations, obviously, if we're giving legal advice. But, you know, I'm asked about that over the years. You know, there are many times we don't want the same type of things to come back to us, right? And so I don't know if that directly answers your question. What we aren't, though, are independent decision makers to decide which claim we think is more meritorious than another. We do make settlement decisions based on our assessment and based on other factors, lots of other factors. But we should be consistent in our defense and in our advocacy.
Yeah, and I will just say, I understand what the point that you're making, and I think there is a difference between some of the things that maybe some members of the public might think, why is there a defense for that? And some of the things we talk about here, like hiding stuff, right? And so they're not all the same, but I think, at least in my conversation with folks sitting here as the chair of this committee, lots of people are, as you know, engage with me about what are you going to do here? And I think it feels very much on the things that are more akin to the hiding of information. It feels very much like folks, when I talk to them, can kind of understand the other stuff, but when I talk to them, cannot understand how there's at least what seems to be a defense for that hiding of information. And so, you know, that, I think, in the minds of a lot of the members of the public that I've engaged with, frustrates, doesn't just frustrate them, but frustrates their sense of the reality of justice in the state of Connecticut. And so I think with you sitting in front of us, it is important to have a little bit of that conversation. I don't know that we resolve it. I don't know if there's a perfect answer. But I would say that, you know, even with the information I have and having sat here for a long time, I'm often, well, you know this, I'm
Yes.
often frustrated with the way in which we operate, and my sense that folks if we didn't operate the way we did, would more easily be able to access justice. And I guess that's something that we have to continue to wrestle with, but it is very real for a lot of the people of the state. And I won't finish there and not give you an opportunity to respond if you want to.
Yeah, I appreciate that. And let me say that either I, or if I'm not available, I'm always happy to sit down and try to, you know, have broader conversations with you or anybody else from the legislature, to get a better understanding, you know, certainly of uh, maybe not a specific case, obviously, if it's pending, but just in general, the concerns. You know, I obviously heard a lot today and a lot of things about, you know, I would say people sort of saying, oh, this was hidden and that was hidden. And I'm going to say I vigorously disagree with many of the characterizations, obviously, but I'm not here to, you know, go after or say anything. They're entitled to their opinions about what they believe happened. I think it's a little different, though, to say in at least one of the cases when they got an information or report through a FOIA request in which it has nothing to do with, and it was maybe it was done longer than they wanted to, but that's a very different argument about concealing something than something that's been withheld or not published. So you know, obviously there's a range of different claims that happen, but as I said, I'm always happy to have a conversation, and we take our responsibilities seriously, both ethically and what our role is under the statute.
Well, I appreciate that, and I will just say, even as the chair of this committee, sometimes I feel as though I can't get information, so I can understand the
Yeah.
general public
Right.
holding that as perspective. Representative Fishbone.
Thank you, Mr. Chairman. So I do appreciate that last exchange. I did recognize, I think the particular matter that you're discussing, a little difficult to understand. The case was dismissed and how you were doing discovery, because I know the state would have come in and said, you know, we got this motion to dismiss pending. You should stay discovery, and the federal court's going to do that. So I got the link up. You know, if I was in your position, I would be taking the position that the passport to parks fee is not an admission fee. But, you know, I look at Wadsworth Falls, which is a park that's in my district.
Yeah.
It's a dangerous roadway to walk along. I do walk it when I'm doing doors in the summer, but it's dangerous. Basically, you can't get to it unless you're driving there. So I think I would be able to argue that it's an admission fee. You know, at a certain level, in line with what Representative Blumenthal was talking about, I think we have almost a heightened duty here. When we spend millions and millions of dollars saying, come to our parks, it's almost like attractive nuisance. If you know or should know that somebody's going to get seriously injured and or die at your park because there's been complaints and there's been a situation, and yet you're spending millions and millions of dollars to say, come to our parks, I think we have an ethical duty to make sure that that doesn't happen. So I'm wrestling with this preclusion and exemption and all of that stuff, because I can't fit the puzzle pieces together where a municipality is given blanket immunity, but the state provides for a claims process. They don't make sense to me. Would you like to comment on that before I go to the next?
Well, I guess my only comment to that is there is an exception for willful and reckless. So I think what you're talking about is like when this, if, you know, arguably if the state is totally aware that something's going to happen and people are going to be injured, they're, you know, what we could always debate what's willful and reckless, but that's obviously different than negligence. So I would just point out that that exception already exists within the statute for willful and reckless.
So we had somebody come before us here today, where their son drowned. My understanding is that that claim was permitted to proceed to Superior Court. In that claim, in that case, and maybe you don't know, was the claim willful and reckless?
I don't believe so.
It would be negligence.
Yeah.
Right?
Right?
Sorry. So the claim, in that case, it was, I believe Commissioner Scott, she without question determined that recreational land use included the state, that the state was an owner. There was a question as to, in her mind, as to whether the fee that was paid for parking qualified as an admission fee such that it fell within the exception to recreational land use.
Okay, so that's how it got to the state court was, and I didn't know about that. I thought I was the first one to think of this thing. So, well, you bring me down a peg. The one I wanted to ask you about though is the Columbia Dental situation, which I think is a somewhat procedurally weird because it's a claim of defamation against your office.
Right.
So I would think there's a more vigorous defense that is poised in a case like that, as if somebody, sued me in my legal capacity, right? You gird your loins, you're ready for battle, right? My understanding is that procedurally, though, the claims commissioner found that while there may have been a course of conduct, that because the course started well before the claim was eventually filed, that it didn't have jurisdiction. That's where we are?
Yeah, so procedurally, there was a federal court action filed originally that got dismissed. That was brought. Then I can't remember, but the claim, so the press release was issued in whatever month of 2020. I think it was October 1st. And then I forget his name, so I apologize, but he wrote to our office shortly thereafter. That's all on the record. I don't think there's any dispute about the timing of that. And this was a joint federal state press release with the federal government. And then he brought the federal court action. That action was dismissed. I think he talked about that. And
What was the basis of that dismissal?
I believe that the basis was, I'm going to look because I wanted to say I think the federal court found that as a public official, he had certain immunity, but I'm not 100% sure. So I know it would be, but I sort of, there was some federal defenses based on press releases and public officials. That's my recollection, but I'm not 100% sure about that. And then subsequent to that, they filed the claim, but the claim is more than, and it may have also filed a 1983 action, but a corporation can't file a 1983 action. It may have been a combination, the defamation 1983 action, now that I'm sort of thinking back to that. It is a little complex, I know, because there have been other claims filed, right, in the Superior Court, which got dismissed. And then that's up on appeal as well at the appellate court. I think they testified to that.
But that isn't a defamation claim.
I believe it was a defamation claim against the Attorney General. Yeah. And the DSS commissioner, because she was at that time, whoever the commissioner was at that time, was part of the press release that was issued. So hold on, I'm going to see what my notes say, see if I can help you with the.
Then I'm totally procedurally
Yeah.
confused then, and just trying to figure out.
Right. So, because it was inconsistent, the press release was issued 3 years before the claimant filed the claim. Right. So, the claimant alleges intentional misconduct as well, which is one thing you can go directly to court about. Dismissed for untimely filing, because the press release occurred in October of 2020,
However, it was an ongoing course of conduct.
Well, that's their argument.
Is the representation, yeah, so
Yes.
assuming that their claim alleges a violation of law, i.e. defamation, within the 1 year, isn't it irrelevant? That's sort of where I started on this, right? So if it's, let's say that every year they issue the press release, right? So you have,
Well, we don't issue our new press
I know,
release.
but let's just,
Right.
we're assuming the facts asserted by the plaintiff
Mhm.
in the light, best favorable for the plaintiff, right? That's the claim that we've heard here today, that it was more than one, and that there was one publication within the filing of the claim within the 1 year, right? What-
So-
that's the claim that I heard early on.
Yeah, so what they argued, so the press release was issued in October 2020, okay? And then what their argument is, because you could go research and find the press release, right, on the website, that because it stays up as a record, that it basically each time, every day, I suppose, would be their argument, that every day it's there is a new claim.
Okay.
That's not what the claim, that's not what we are. Obviously, we disputed that, and there is no tolling provision, right, in our claims commissioner statutes, and the claim commissioner found that it was untimely. There were also claims of intentional conduct, but we'll skip over that for the moment.
But the court never got to that. So I'll tell you, I defended a case of copyright, trademark,
Mhm.
in the last 6 months. And in that case, my client had taken a photograph that was watermarked and they put it on their website. And it was on the website and didn't take it off the website. And I researched the issue, and basically that I came up with the opinion that yes, you leaving it up there was multiple violations of the copyright statute. So why here you have litigation, although dismissed in the federal court, involving a particular press release, why, just in good conscience, you wouldn't take it down if there was some color of defamation?
Well, so I think there's maybe some confusion about the defamation claim was filed in federal court. That was dismissed, right? And
But-
and
but-
I believe in state court as well. The claim at the claims commissioner can't really be defamation because that's an intentional conduct. It's negligence against the state, right? And so, but it's based on sort of the same underlying facts, which occurred in October of 2020. And so, in terms of why the press release, first of all, becomes a record. If we don't believe that we've obviously said anything incorrect, and this isn't the first time, I can't remember the other case, we've been, somebody's not been happy with a press release. So, are you asking like, why wouldn't we just take it down?
Yeah, well,
Not sure.
I'm assuming that the press release said, we have been successful in bringing some sort of legal action or enforcement against a particular entity, and that was determined to be inaccurate.
So I want to go, I think, I don't have it in front of me, but I believe, and I want to say this because this is, I didn't research the original underlying case, but I believe this settlement in this press release, because that's what the press release referred to, was based on a joint the United States government and state of Connecticut, based on a key TAM action, which was brought separately, and a resolution of that was then announced with both the federal government and our office, which is done pretty routinely. I say routinely, that's not an uncommon occurrence in those types of cases. And so that's the underlying claim about the press release.
All right, so now it's coming back to me. I think I read an article about this where generally the claim was that we settled this case, but we didn't know, or it wasn't part of the settlement, that there would be some sort of publicity about this.
That's,
that-
yeah, I think that's what they argued,
Yeah,
if
okay.
I recall.
It's coming back to me now. Okay. I just wanted to
Yeah, I understand. And,
discuss that.
and,
so.
and, you know, again, we can get you those pleadings and the decision if that
No, I
would
can
be
look all
helpful
that
to you.
up, so.
Okay.
But, the federal case is probably dismissed because a corporation can't bring the 1983.
Under 1983, that's correct, but
Yeah.
there was a separate piece related to the, I believe, the defamation as well.
Understood. Okay, thank you. Thank you, Mr. Chairman.
Further questions or comments for the Attorney General's office? If not, thank you for sticking with us. Appreciate it. I
Thank-
know it was a long day, but I
Yeah.
do think it's helpful to kind of
Yeah.
have
It was helpful. Thank
a
you.
wrap up at the end. So thank you. All right, we are going to invite, well, let me just check. Are there any questions for the Claims Commissioner? Do we have any questions for the Claims Commissioner? I know he's
Yeah,
come around
yes.
briefly.
Yep.
All right, I'm gonna invite probably Shay to come back up. Entertain a couple quick questions. Representative Fishbein, you have the floor.
Thank you, Mr. Chairman. Hi, Commissioner Shea. Good afternoon. I just want to ask you about the Vertife matter. It's number 21. The gentleman who had slipped at the prison had some significant injuries to his head. Was your dismissal a strict interpretation of the law? Is that your position?
Yes, sir. It was just, you had asked this, but again, I'm Robert Shea with the Claims Commissioner's Office. My colleague, Attorney Tamara Teed is with me. Yes, it was strictly a failure to exhaust under 4-165B.
Okay.
And it's an interesting claim. I mean, you know, I decided, I decided this claim. I decided that, you know, he didn't exhaust and he could have, as hard as it would have been maybe where he was outside of a facility, but he was still on parole. And he had talked to a lawyer 17 days after he was released and filed the claim 17 days after he was released. So I respectfully concluded that he was aware of his rights because he filed a claim here and that he could have exhausted. So I did have a strict interpretation of the exhaustion statute.
Yeah, I guess my concern is that the gentleman obviously did suffer a significant injury. And he did, even though significantly injured, attempted in good faith to follow the process that they're required to. And even once released, you know, people that get released are, you know, unless they're frequent flyers, not familiar with the system and how to get to the system and all of that stuff.
Well, on that point, he very quickly contacted an attorney. So that was part of my reasoning for the strict interpretation.
Yeah, but, you know, I mean, I get a call, you know, I'm not going to turn around that day necessarily. I'm going to investigate the case and put the papers together and perhaps investigate how to even do this.
Right.
You know, so is 17 days unreasonable? And I think public policy says that we should be affording individuals access to the system, especially when they attempt to, but their failure is perhaps the system in and of itself. So I do appreciate your candid answer to my question. So thank you, Mr. Chairman.
Further questions or comments on any of the claims for the Claims Commissioner?
I wonder if I could just give brief explanations on maybe 3 of the claims that engendered a lot of testimony today, or are you all set?
I mean, if
mean,
you want,
I
if
can
you
tell
want-
you with,
Yeah, if you want.
what happened on the Columbia Dental case,
I think, yeah, I think we understand that one.
Okay.
What were the other ones?
Miss Hess, the baby who passed away, I'll tell you what my thinking was.
Sure.
I thought that the DCF foster mom and the DCF social worker did everything that they could and was very reasonable in trying to help this baby who was sick. And they took the baby to the doctor a couple times. They took the baby to an emergency room a couple times. And the baby was let out of the emergency room at 8:30 at night on September 29th. And, you know, the emergency room doctor said, baby's good enough to go home. So the next morning on the 30th, the DCF social worker brought the baby to see the biological mom. And they both realized that the baby was sick. So they called the pediatrician. You know, the social worker called the pediatrician and said, this baby was just in the emergency room, you know, 12 or 14 hours ago and was released, but the baby still seems sick. And so the plan was to have the baby visit the pediatrician that afternoon. So it was a very difficult hearing for everyone, but I respectfully decided that I thought that the foster mom and the DCF social worker cared very deeply about this child and acted reasonably in trying to take care of the child. And ultimately, the next day, the autopsy report issued by the hospital said that the baby died of spinal meningitis and that the cause of the death was natural. So that's why I decided there wasn't an issue of law or fact where the state could be held liable. And I guess on the Lavoie case, you heard a lot of testimony about that. The Lavoie claim, very, very sad as well. You know, there is a concept called prosecutorial immunity where citizens generally under the Supreme Court decisions don't have standing to challenge how the state decides to prosecute crimes or when people get incarcerated and released and everything. It's a difficult concept, but in this case, we decided that the state's attorney's office and the state police should have the protection of that doctrine. So those were the reasons for our office's decisions on those three very controversial claims.
Appreciate it. Further questions or comments? If not, Commissioner Shea, I just want to thank you on behalf of the committee again. You know, we know these are difficult cases. We know these are difficult decisions. We know that oftentimes, particularly on something like a negligence claim, it is a judgment call based on the testimony that's provided and within the rules of evidence. And we appreciate the dedication and the thoroughness with which your office looks at these.
Well, I'm honored to work with you all, so thank you very much.
And I think we would
I'm honored to have this job as the claims commissioner as well.
Well, look, I mean, I often say, you know, in some states, particularly states that have full-time legislatures, the decision of whether to waive sovereign immunity or not is one made by the legislature in the first instance. And frankly, the claims commissioner's office in Connecticut is a delegation of our authority. And if it weren't for you, then our one-day hearing here would turn into months and months and months of hearings on each one of these claims. So we appreciate the work you do, and I think I speak for all of us when I say this is the second year in a row in which we've not heard folks in here objecting to requests for extension of time to decide their claims, and we appreciate the work you've done on that. So with that, I am going to declare this hearing